Section 72 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Action of James Maurice against Samuel Judd for a penalty. New York City, 1818, Part 5. Mr. Anthon, gentlemen of the jury, I shall trouble you with a few remarks on the law and evidence in this cause. The wit and learning belonging to it I shall leave to my learned associate. Our opponents gave early intimation of their consciousness of the imbecility of their defense by resorting at the very outset to legal technicalities, by which they hoped to avoid a contest on the merits. And although driven from these holes, and compelled to produce their strength before you, they still manifest their alarm by calling for your verdict on the last desperate formal objection that remains to them. We are told that there is no evidence that any inspector was ever appointed under this law, and that consequently there could be no fault in the defendant in purchasing uninspected oil. Although this proposition has been thus gravely put before you, is it a legitimate question in this cause? Has not this trial proceeded throughout on that as an admitted fact? But independent of this manifest admission, the defendant himself has furnished us with ample proof. The testimony of Mr. Davis, who describes Mr. Maurice in the act of inspecting oils shortly after the passing of the law, and entrapped for the moment by the question artfully put to him, whether he was inspecting fish oil. The admissions of Mr. Fish and Mr. Hazard, though through fear of the penalties of the law, they have submitted to have their oils inspected from time to time, afford abundant proof of an inspector in the active exercise of his office. We are not bound to produce his commission, as the court will charge you. Driven, therefore, from this last forlorn hope, the defendant is compelled, reluctantly indeed, to meet us on the substantial merits of the cause. In deciding this controversy, gentlemen, I must request you to bear in mind its strong discriminating feature. It is a struggle between the vendors on the one side and the purchasers on the other, the latter insisting on inspection for their protection, and the former wishing to avoid it for their own interest. This fact will fully account for all collisions in the testimony in this cause, and if carefully attended to, will enable you to solve all its difficulties. We have conducted this cause on our part with perfect good humor, which has not certainly been manifested by our opponents, but his temper is at once the evidence and prerogative of acknowledged defeat. We are bound to bear with it, and even to answer his querulousness. We are told in this spirit that the plaintiff is an avaricious and greedy inspector. We reply that we can discover nothing in him but a faithful public servant, duly executing the trust reposed in him. We are told that he is seeking in this suit to obtain money he has never worked for. We reply that this, if allowed to have any weight with the jury, would go to repeal all penal provisions in our statute book. Our opponents next attempt to alarm you and gain your sympathies in their favor by alleging that we charge the defendant with fraud. The suggestion is entirely their own, and we have throughout disclaimed it. These matters, then, being disposed of, let us return to the cause. It has been fully proved that the defendant in the month of September last purchased from Mr. Russell 3 casks of sperm oil, which oil at the time of the purchase had not been inspected. If the oil, therefore, contained in those casks was fish oil, the penalty of the law attaches to the defendant, and consequently, in order to escape the penalty, he must either convince you that the oil of a whale is not the oil of a fish, or that whale oil is not fish oil, in a commercial acceptation, both of which he has attempted but has unquestionably failed in both. As to the opinions and classifications of modern naturalists on the subject, they are undoubtedly against us as far as their evidence has been heard. And if this statute is to be interpreted in this way, we should be bound to surrender our common sense and say with Dr. Mitchell that a whale is not a fish, and that whale oil is consequently not fish oil. But, gentlemen, such a construction of a statute would be in opposition to the well-established rules of the common law, statutes being enacted to regulate the conduct of the whole community. The words of the statute are to be interpreted according to their common usage and acceptation. Applying this plain rule to this case, all refined theories are at once put to flight, and the words fish oils must be considered as embracing the oil of the whale, as well as that of any other fish. On this branch of the subject, as my learned colleague will have much to say, and as I am desirous to give him full possession of the field, I shall content myself with giving one practical illustration of the absurdities in which the interpretation of statutes, according to the opinions and classifications of naturalists, would inevitably lead us. The whale is elevated to the same class with man, because he breathes the vital air through lungs, and has, in common with man, the various peculiarities which have been enumerated in the progress of this trial. The monkey possessing them also, in a still more eminent degree, is also classed with us. He is, in truth, in language of naturalists, no more a brute than a whale is a fish. He is, in short, in form and structure a man. We have a statute which declares that every freeman shall be entitled to a vote at our public elections. Let us suppose, then, that at some time one of those arduous struggles, where everything in the shape of man has been by the zeal of politicians urged to the hustings, that the learned doctor had appeared, leading forward with all due gravity to the polls an orangutan, or man of the woods, would the stranger's vote be received, although the doctor should learnedly and eloquently urge his claims, as he has those of the whale on the present occasion. He breathes the vital air, the doctor might say, through lungs. He moves erect, etc., has warm blood. The female brings forth her young alive, and breathes the bantling at her breasts. The inspectors would say in reply to all the eloquence and learning of the doctor, as we do in the case of the whale, all this indeed is very strange and curious, but still, doctor, it is a monkey in common acceptation, however naturalists may choose to hail and class him as a brother. As to the common acceptation of the term fish oil, we have offered you the most satisfactory testimony. We have produced and examined before you Mr. Gideon Lee, a gentleman of great respectability and intelligence, the very man, too, who penned the law in controversy. He tells you he is a tanner and currier, that this class of artisans use every kind of oil in their business, that they prefer the cod liver oil, but use whale oil when that cannot be procured, that they had been imposed upon and cheated in every species of oil they had used, and that this law was passed for their protection. He also tells you that he was anxious to use a term sufficiently broad to cover all marine oils, and with that very view introduced the term fish oil into the statute. And this general sense, he says, is the common acceptation of the term. The counsel who first addressed you on behalf of the defendant has attempted to expose Mr. Lee in his testimony to ridicule. I am thoroughly acquainted with all the devices of that gentleman. He was eminent at the bar when I first entered into precincts, and his good fortune followed in his steps, and he had obtained respectability and wealth by his professional efforts. His movements naturally fixed my attention, and the secret springs which opened to him, the avenues to success have been, to my judgment, frequently developed. On this occasion he has attempted one of them, but I trust the sterling merit of Mr. Lee will baffle his efforts. With peculiar adroitness he singles out the most powerful witness of his antagonist, and employs all his power of raillery, sarcasm, and ridicule against him, that he may weaken his influence over the minds of the jury. It is enough in this case, gentlemen, for the interest of my client, and it is a full performance of my duty to the witness, who is entitled to the protection of the counsel who produces him, to have exposed to view the masked battery of our opponents. This witness is confirmed in all his statements by Mr. Jacob Lorillard, a gentleman of equal respectability and intelligence, who expressly states that he considers every species of marine oil embraced under the term fish oil, and that this is the common acceptation of the term. Israel Course, Thomas Brooks, William Hall, and Lucy Van Lorston, all respectable tanners and couriers, have been produced on our part, confirming the testimony of these gentlemen and forming a body of testimony bearing on the very point in controversy, too powerful to be resisted. The vendors of oil, who have been examined by our opponents, have drawn a distinction between fish oil and whale oil, and would have us to understand that fish oil embraces exclusively the cod liver oil, and such like oils extracted from the livers of fish, and that this is the common commercial acceptation of the words. It very speedily became manifest that all these gentlemen were of Eastern origin, and were giving to us the acceptation of the words in the Eastern states only. When this became apparent, the question was reiterated on our part to every witness, who maintained that opinion whether he was not from the eastward, and the invariable affirmative demonstrated the force of our inquiry. The counsel for the defendant here appraised us with having called respectable gentlemen by the vulgar epithet of Yankees. The term was never heard in this cause until used by your opponents in their address to you. Neither vulgarity of epithet nor angry feeling have been manifested by us in this cause. We are indebted to our opponents for both. We respect this class of our fellow citizens as much as they can, but we are not, therefore, willing that they shall dictate to us the meaning of words, especially when the whole commercial world is arrayed against them. In opposition to this novel distinction, we have produced to you the price currents of London, Liverpool, Bordeaux, and Baltimore, and it is not to be found in any of them. On the contrary, you have seen in some of them the term fish oil, applied in the very same sense in which it is used in this statute. We have, therefore, the common acceptation of the terms, and also the acceptation of the whole commercial world, in opposition to a mere provincial usage, and it certainly can require no refined deductions of reason to teach you which ought to prevail. There is another rule of construction which we have also applied to the interpretation of the statute, an inquiry into the mischief intended to be prevented, and have fully proved that frauds have been practiced in every species of whale oil, and those too of the grossest nature. We have proved to you that in a vessel of 110 gallons, 96 gallons of water have been detected, and that in a variety of others the water has varied from 3 to 5 gallons. When a matter is thus proved to be fully within the mischief intended to be prevented by a statute, it is the strongest possible evidence that it was the intention of the legislature to embrace it within its provisions. The title of the statute in which the term fish oils is used is conclusive evidence that more was intended by the act than mere fish oil, in the limited sense contended for by the defendant. Gentlemen, this case is now with you. It is for you to dispose of it according to the testimony before you. The counsel for the defendant desire you to decline the decision, and thus to send back the statute to the legislature for their interpretation. You cannot safely follow their advice. You have an oath on record, which you would thereby violate. You are sworn to decide between these parties, according to the evidence, and the evidence is decidedly with the plaintiff. End of section 72. Section 73 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Action of James Maurice against Samuel Judd for a penalty. New York City, 1818, Part 6. Mr. Sampson. Gentlemen of the jury, curious and novel as is the subject of this trial, and much as it challenges of observation, I fear at this late hour I can offer nothing so agreeable to you as retirement and repose. I shall, therefore, leave much unsaid of what, under less disadvantageous circumstances, might not have been thought from the purpose. The evidence has been so perspicuously commented upon by my learned colleague that I shall be readily excused from going over the same ground, as nothing is more tedious to a jury, nor less profitable to a client, than repetitions by one counsel of what another has said. The result seems to be this, that though the witnesses on the one side and the other hold opposite opinions, yet the character of none has been impeached. All that can affect the credit of any is that bias which the law recognizes as a principle of human nature whenever interest usurps over the judgment. And when our adversaries show that their witnesses are wholesale vendors of whale oils, and ours only casual purchasers, they show in which scale the weight of interest preponderates, and prove everything for us. As to the evidence touching the meaning of the legislature, I had great doubts whether it was admissible, but as the counsel for the defendant introduced it, we have rebutted it, I think successfully. We have produced Mr. Lee, a competent and most intelligent witness. He drew the bill and tells you with what view the act was solicited from the legislature, what mischiefs it was intended to remedy, and that the term fish oils was used as the most certain to embrace all marine oils, and that of whales amongst the rest, without any possibility of doubt or equivocation, and to show the general understanding of the commercial world, price cards, bills of lading, bills of parcels, and correspondences, both foreign and domestic, have been produced, to which nothing has been opposed, unless the particular phraseology of a small section of the Union shall control the general acceptation of words. My learned colleague has been accused of illiberality, because he directed his inquiries to this point, and has been charged with calling the witnesses of the defendant Yankees. Certainly, if the word Yankee be a reproach, he is not answerable, for he never once uttered it. Mr. Anthon has too much good sense, if good manners did not restrain him, not to know that a counsel never gains a point by the use of national or local reflection, but at the expense of his own character. The opposite counsel paid the worst compliment to their own witness, first, by introducing the word Yankee, if it be a term of reproach in their apprehension, and secondly, by supposing it to be such. For my part, I have often heard it echoed as the word for triumph, and who has not joined in the chorus of Yankee Doodle? Sure I am of one thing, that though the witnesses on the other side may be interested in the event of this trial, they will still have the good sense to acknowledge that my friend has done nothing but his duty, and on other occasions they will endeavor, when they want an able advocate, to engage him on their side. Nor will it more avail the counsel to exhibit these gentlemen from the eastward in the light of martyrs, for if they have any good quality, and I think they have many, they possess in a peculiar degree that good sense that takes care of itself, and are better made to figure in any other character than that of victims. And truly, the oppression they suffer by this law is not much. Before it passed, they paid 12 cents a cask for gauging, and now they pay 10 cents for both gauging and inspection, buyer and seller each paying 10 cents. Having said so much for my associate counsel, respect for those opposed to us requires that I should give some answer to their arguments. Luckily for me, they have neutralized each other, as sometimes it happens in an unconcerted night attack. They have fired into each other's mouths. The one clung with affectionate zeal to the great ichthyologist, as determined to stand or fall with him, who was the pride of science, the honor of his country, the glory of the age, light of the universe, and so on and so on, still kindling as he spake, till it went nigh to weeping with me, so like it sounded to a funeral oration. For though I would not deprive that great man of his rank amongst constellations, yet let it not offend him if I wish his hypothesis deferred for a time. For were he suddenly snatched from among us, there is none in this sublunary sphere to fill his place. Not only in the regions of science would there be a void and vacancy, but man, woman, and child would miss him in his walks, and fish, flesh, and fowl mourn for their historian. Happily for all, it was but a false alarm. He is yet in the body, yet hale and vivacious, so that if his eloquent panegyrist does not keep from such strong emotions, from the night air and other accidents that shorten life, the doctor may live to repay the compliment and sing his dirge in return. But I hope that day is also far distant. The other counsel, who affected so little respect for science, did not turn his back, however, upon science, while science kept her face towards him. But no sooner did he find that all the philosophy was in the Pentateuch, than he tacked about, for as he could not persuade himself, so he knew he could not persuade the jury, that Moses classed the whales with men and four-footed beasts. If he had not studied comparative anatomy, he had learned to dissect men's thoughts, and he saw with the glance of a practiced eye that the joke would not take. So shifting his course with the sudden shift of the wind, he cries, "What's this? What is all this? What have we to do with all this learning? What have juries to do with questions of science? What need do we have of Dr. Mitchell?" But recollecting that he had subpoenaed Dr. Mitchell and postponed the trial because of the absence of Dr. Mitchell, he slants off by saying, "I only consented to his coming because it was proposed for the sake of amusement, as people like to hear him talk." Very good and very true, and people have heard him talk. We all love the doctor, and everybody likes to hear him talk, and it needed no handbills to collect the crowd that has filled this court during the whole trial. The rumor of such a paradox, to be maintained by such a disputant, was enough, if the living had no curiosity, to bring the dead out of their graves. And let me say that this crowd is a better prognostic of an enlightened community, and indicative of a higher moral sense and sentiment, than those that sometimes waste days and nights in trials where the only interest is in the lewdness of the story. And the counsel should have remembered that making sport with men of might is playing with edged tools. He should have recollected that when the Philistines brought Samson up to make them sport, the sport he made them was to pull the house about their ears. It was not, "What have we to do with science?" when the flag was first unfurled, and the trumpets flourished so loud as who should say, "Here comes the great Leviathan whom the arrow cannot make flee, the spear, the dart, nor the halberdier, out of whose nostrils goeth smoke, as out of a seething pot or a cauldron, like the king of the children of pride that beholdeth all things." And when my presumption was arraigned for inquiring into the grounds of his opinions, as though they were omnipotent, "Canst thou open the doors of his face," it was said, or words to that effect? "Canst thou play with him as with a bird, or bind him for the maidens? Who shall put a hook in his nose, or go to him with a double bridle?" It reminded me of one of whom I never thought to speak again, and of whom you, gentlemen of the jury, never, I presume, did hear before. Mickey MacDonald was a man, if compared to Dr. Mitchell, of very little learning. But in a country where philosophy is taught by the bailiff and the proctor, and consists in the simple practical observances of hungry stomach and bare feet, as in the realms of the blind one eye makes a king, so there a lofty stature, and corresponding energies of body and mind, and a knowledge of the Gaelic tongue, had acquired for the individual blessed with such gifts, an ascendancy so high that in his parish and the two adjoining, his word was as an estoppel of record to all mankind. Chancellor or judge might err, But a decree once promulgated in this simple formula: Seville, Mahel, fine, dwert, ear. Mickey's own mouth said it. In a moment all was hushed. If we must have a Mickey's mouth here too, none so worthy as that which is spoken, yet still it is an opinion. The fire will not melt out of me, that a whale resembles a fish more than a man. I labor under another difficulty. Perhaps it is a prejudice of education, but I was bred up in the faith that a counselor of the law was not ex concesso, to be so ignorant of all liberal learning as to be spoon-fed by doctors of medicine with ill-concocted Greek, such as Greek babies would spit out. But on the other hand, that not only his own dignity, but the dignity and efficacy of the laws depended upon his competency to push every necessary inquiry, whatever opinion in matter of science became evidence. And I trust the counsel who interrupted me will, upon reflection, bear me goodwill for vindicating the common privilege of the counsel, the client, and the community. The other gentleman, in slighting philosophy, wrongs himself, for he made more ingenious distinctions out of his native abundance and extempore, and in a few minutes than would have cost Linnaeus years of painful toil. The arrangement of ladies, ostriches, fowls, geese, and generals, or as we may say, the feathered tribe, by their plumage was very felicitous, and if his arguments were not of much weight in the cause, they were still feathers, which is something, in a soldier's cap. His association of fish, crabs, and oysters, though not according to the modern French school, also ingeniously curious, and proves that he never wants resources and will not in any case go out like a snuff. His observations upon the allotment by the learned Prynne are the whale's tail to the Queen's Majesty, to furnish her royal wardrobe with whale bone. I feel in their full force, and am much troubled for an answer, that whales do not now wear whalebone in their tails, is as true as that ladies have left off hooped petticoats, and gentlemen taken to wearing stays. But where the whales do this out of malice, or whether modern zoologists have made the alteration, is the thing to be inquired into, unless there be a third way of accounting for it, to which I am not the less inclined from what I have heard in this cause. The very learned men may be very much mistaken. At all events, Prince Aurum Reginum, or Queen's Gold, go as far to prove a whale to be a fish as the Princess Sophia, and the airs of her body do to make it flesh, and I leave the one as a set-off against the other. Upon the authorities with which we had entrenched ourselves against the threatened invasion, the general remarked in his own peculiar way that he feared our pains would exceed our pay. I must there also admit that there is much truth. Learning is not the commodity that comes to the best market, and if there be virtue in it, it must be its own reward. We, however, knew the sway of a great name, and that he who has to encounter the authority of Dr. Mitchell, backed by his ready elocution, cannot make himself too sure. Therefore it was that we formed alliances with the Syrians, Greeks, and Chaldeans, had certain opinions of Aristotle before they became articles of faith, and brought to the test of common sense, and that great man had been called as a witness in the Halia, or other Athenian courts, and had some Crito, Phaedon, or Socrates used the privilege of cross-examination, the schools would not have been occupied till our own times, with the unprofitable doctrines of form, privation, and matter, categories, sophisms, and syllogisms. Nor would it have been held impious amongst Christians to impugn his heathenish dogmas. The same might be said of many other vanities, as the elixir of life, and the philosopher's stone, and all the subtleties of the Gnostics, sciolists, satirists, and soothsayers. And remember that if Aristotle was aggrandized by a pupil who made the world tributary to his researches, Mitchell, greater than himself, holds the sway over public opinion no less despotic, who but one conscious of his terrible power would have planted himself in the attitude of proud defiance, like a castle on a cliff, and proclaimed in the face of a court and jury what he did, on that ever memorable moment when he declared upon the faith of modern zoologists that a whale was no more a fish than a man, and that none but lawyers and politicians would nowadays suppose it so. What would the learned doctor say, were I to enter his lecture room and inform the youth of his class that his opinions were sophisticated, and refer them to the venerable sages of the law, to King Brutus, Queen Marcia, and the long and royal lines of British, Saxon, and Kentish lawgivers, Ines, Alfreds, and Edwards? What figure would the names of Blumenbach, Cuvier, or Lamarck cut, opposed to Howell Da, Del Marlo, Malmutus, and Bladrodobus Laguardus, all of whom held the whale as it was and is, by the common law, a fish? The learned witness could not steer clear of much uncertainty when speaking of the sea cow that goes ashore with its baby to graze. He called it one of the cetaceous tribe, though Linnaeus ranks it in the order of the bruta, or brutish beasts, and so unsteady is the footing of those who stand upon each other's shoulders, that I fear this cumulative series will not gain strength by numbers, and if the most learned are uppermost, there is danger of the column becoming top-heavy. It was in this manner the giants tried to climb, but their pride got a fall, and I fear this new philosophical ladder will scarcely reach where Jacob's did. Upon the whole, it would be well when the books are next posted and the balance struck to add, by way of precaution, errors accepted. There is another difficulty. Every day brings to light some new and important creature, as the mammoth, known only by fossil remains. Others long thought fabulous, revived and reinstated, as the camel leopard and the siren or mermaid. The sea serpent, proved to exist by oaths, that strongest of human proof, by which men's lives are judged. The hippocentaur, or Kentucky man, so celebrated on the banks of the Mississippi, worthy by its importance of a class or order for itself. Footnote: when these formidable beings first appeared to the ancient French settlers, they named them sacre cane-tucks, and they are still so called by many. End of footnote. Had the existence of these creatures been known or admitted, they might have been connecting links to prevent such too important to be left out. The ranks must open to receive them as they respectively arrive, and the order of the parade be still changing. And what virtue is there in the scalpel of the anatomist, or in his blowpipe, that he should have the sole privilege of new creating and nicknaming God's creatures? Why may not the school of Burr have found a system of zoology upon the Elementa Medici Physico-Mathematical, and class according to the animal functions explained by mechanical causes and mathematical demonstrations? The craniologist, cranisophist, cranionomist, or craniogenist, after Gall and Spurzheim, may, by the nervous streaks of the ganglion of the brain, and their circumambulations on the hemispheres, and the protrusions by the organs of the mental faculties of the parallel lamina of the skull, as they indicate murder, robbery, love, courage, or constancy, class and arrange all living things. An amative class will take in hogs, frogs, and snails, and be called the Abelard and Lucius. A pugnacious class will take in General Jackson, the gamecock, and the swordfish, unless the last of these be held by nearer ties to the class of the prudes and platonists, by the character of Castus Amor. Doves and dolphins will be of the Penelope class, and so of the rest. The geometricians will have pantometrical zoology, classing by points, lines, surfaces, and solids, the genders of curves, ratios of affections, motions, and positions. There will be the straight, crooked, and perpendicular families, the equilateral, curvilateral, and multicrural, the cycloid, trapezoid, and rhomboid orders, so that by comparing the angles of the bee's knees with the inclination of the cat's tail, There will be no danger of mistake, and with the aid of a Gunter scale, a logarithmic table, and a theodolite, you may distinguish a maiden from a bat. I do not say there ever will be such systems, and if there were, I think they would be of little value. For those who attempt to follow nature into the secret recesses where she loves to retire, find themselves in a labyrinth to which they have no clue, waste themselves in unavailing toil, and sink subdued by efforts in which their powers are inadequate. Hence, these grave mistakes of the learned, who are neither lawyers nor politicians, nor sitting in halls of legislature, but who, judging of nature by their narrow views, were subjected to arbitrary regulations. Hence, those trembling lines, traced with a feeble hand, those limits which nature disavows and boundaries which she disowns. Hence, those ephemeral systems which efface each other, succeeding like the ocean's waves of which the inventor has only this benefit, that his errors are concealed under the protecting cloud of mystical jargon, and like to those who have the receipt of fern seed, he walks unseen, nor is he who makes microscopic researches the best qualified to judge or testify, for the rays of the intellect, being concentrated upon one point, are apt to leave all else in darkness and unnoticed. The most learned, besides, are not always the most sure-footed witnesses. Learning is a heavy burden, and men will stagger under it. It is not so easy to run with the gates of Gaza on one's back. The worst effect of all, however, is that instead of inviting to the study of nature and laying open the door of the most enchanting science, these systems rob it of its attractions and are as forbidding as the 100-tongued scarecrow of the Hesperian fruit. But I return to the learned witness. There was a demigod of old, a great ichthyologist, for he kept the flocks of Neptune. He knew almost everything and was consulted upon all great occasions by kings and people. He was called Proteus, and could, if not disposed to answer categorically, use all shapes, shifts, and transitions. It was so with the learned witness in this cause. You saw that he eluded our inquiries, how he flew from the Arctic to the Antarctic Circle, from Davis's Straits to the Straits of Magellan, and like Puck, the fairy, put a girdle around the earth in 40 minutes. But I, remembering the moral, held fast till he solved every doubt, by referring to the authority of Moses, and as this part of our subject will not admit of levity, I now beg your serious attention. In the first chapter of Genesis it is related, with simple brevity, the daily progress of the creation. We find there the style of narration by the inspired writer to be this: first, to announce the will of the Creator touching each distinct act, and then, in terms as distinct, the execution of it. Thus, let there be light, and there was light. Let there be firmament, and God created the firmament. Let the waters be gathered together, and the dry land appear. And then follows the formation of the earth. Let the earth bring forth grass, etc., and the earth brought forth, etc. Let there be lights in the firmament, and then God made 2 great lights. In like manner, the history proceeds till the 20th and 21st verses, which relates to 5th day's work. Thus we find in the sacred history of the creation one homogeneous ray of light, and in the corruptions of the heathen poets and mythologists, the same ray alters as it were by prismatic refraction, exhibiting a show of various colors, but wanting the purity of the original. And God said, let the waters bring forth abundantly the moving creature that hath life, and fowl that may fly above the earth in the open firmament of heaven. This is evidently, as in all the preceding instances, the enumeration of the intent of the Almighty to create the finny and the feathered tribes, and the execution of that purpose is related in the succeeding verse, where the whale is put, not as a distinct creature, but as the great type of all fish. And God created great whales, and every living creature that moveth, which the waters brought forth abundantly after their kind, and the winged fowl after their kind. Now the witness thinks that he finds the creation of fish by implication in the former of these two verses, and that of whales distinct from fish in the latter, for otherwise, he thinks, the fish would have been twice created. This savours a little of incogitency, and wants the precision that usually marks the opinions of Dr. Mitchell, whereas the creation of fish is at least as strongly implied in the latter as the former verse. It would follow that whales were created once and fish twice. But scriptural authority does not stop there. In the book of Jonah, chapter 1, verse 17, it is said, "The Lord prepared a great fish, and that Jonah was in the belly of the fish 3 days and 3 nights. And the Gospel of St. Matthew, chapter 12, verse 40 says that as the prophet Jonah was 3 days and 3 nights in the whale's belly, etc., showing that the great fish was no other than a whale. So the common law, which is founded upon the law of God and revelation, has always considered it. So 9/10 of all that speak English consider it. What equivalent does this philosophy then offer for the surrender of faith, law, and vernacular speech? I am no cantor, nor was it I that pressed Holy Writ into the argument of the cause, but I should beg of the doctor, if it can be at all dispensed with, to let us remain as we were before the second creation, for I do not think it becoming for the lords of the creation to be ranked with porpoises and hogs. Not that Amelia sounds so badly, nor is Primus an ill name, but Bimanus and Quadrumanus are too much to be endured, however it may be that man, monkey, and bat all agree in the number of incisor teeth and pectoral mammae. Figure to yourselves, gentlemen, a beautiful woman in the act of nursing her first child, her eyes beaming with tenderness and love, and grace and beauty in her form and attitude. And now imagine me, a Borneo bat, clinging torpidly in some filthy hole, by the hooks which terminate in hinder extremities, its head downwards, its ugly brood sticking to its dugs, and reconcile, if you can, this fantastical association to decency or reason. What is there in common between the beings made after God's image, excelling all in beauty, and that which, still conscious of its hideous aspect, and nothing elated by its new breath, will not venture abroad till the blessed sun has withdrawn his light, and evening has cast her friendly veil over its unseemliness? I may perhaps be speaking too irreverently, perhaps ignorantly, of what the learned commend, but still, I think, the onus lies on the advocates of this new philosophy to show to what good it tends. If it be to elevate the brutes, it is well contrived. But if it is for the benefit of the humankind, let them show what its virtue is. If it makes us better, happier, or wiser, diminishes our toils, lessens our sorrows, or exalts our hopes, it is worthy of our gratitude and praise. But if it be said that these arrangements assist man in acquiring knowledge of subordinate creatures, I will ask how this can be, since we find the whale and dolphin in an order called cetaceous, by reason of their inhabiting the sea, having a double heart, lungs, and warm blood, and yet we find others of these same cetaceans, as the seal and the sea cow, associated, the one with the predaceous beasts of the forest, and the other with those called brutes, as the elephant and armadillo, where no one would think of looking for them, and that by so insignificant a relation as their teeth. And as man is related to monkeys by the same members, I should like to be informed whether he might not lose his caste by the loss of his front teeth, and in such case whether the dentist could restore him. The maxim of law being that a prescriptive right, once suspended, is gone forever. Yes, gentlemen of the jury, in the same order with man they place the monkey, ape, and baboon, all equally related and differing from the Lord of creation, only as they differ from each other. To do them justice, however, they have discovered a way by which a man may be distinguished from his class fellows, and that is by his thumbs. He has a great toe upon his hind foot, where they, it seems, to assist them in climbing have a thumb. He then has but two hands, and they have four. Or, to speak learnedly, he is Biomenes, and they are Quadromanes. As it was long before the workings of genius brought this discovery to the world's light, it is wonderful how these brothers were known apart before the days of Linnaeus. But now the rule is this, and if you follow it, you will be quite safe. A man is an ape minus two thumbs, and a baboon minus two thumbs and a tail. And e converso, a baboon is a man plus two thumbs and a tail, and a monkey is a man plus two thumbs. Or thus, a man with an extra pair of thumbs would be an ape, and with those, and the addition of a tail, would be a baboon. If I had not known this to be philosophy, I should have supposed it was the black art. It is enough to give bad dreams. There is a story of a poor man who was so infected with this philosophy that he became hypochondriac, and seeing a bat flying about, stuck his thumbs and great toes through the corners of his blanket, and went out of the window to take a few turns through the air with his cousin Vespertilio. You can conceive how it ended. He died a victim of the Linnaean system, leaving a wife and children to deplore his untimely loss. Again, what is more grotesque than associating the kraken, which is a mile and a half big, with the oyster in the class of worms, or crabs and lobsters with fleas and lice? Yet so much do these systems mislead, that Sir Joseph Banks boiled his fleas to see if they would turn red. What more violent than to class men with whales, upon the ground of some casual conformities, since, notwithstanding the bony skeleton, double heart, warm blood, and alternate breathing, there are scarcely two things, even physically speaking, so unlike. Its form, attitude, covering, manner of moving and being, declaring it to be of the finny tribe. Yet you have heard one of the greatest men of the age, and one as good as he is great, declare upon the solemnity of his oath, that a whale was no more a fish than a man. If he had said even that it was half a fish, I should have been less unhappy, because from the midriff down it has no one of the characters of man or quadruped, so that all the power of philosophy with oxen and wain ropes to boot can never get it more than half out of the water, and the other characters relied on are very uncertain, since we find from that practical witness, Mr. Reeves, that the dogfish is also viviparous, the word being that the whale calves and the dog pups, and it is well known that the blenny and the eel bring forth their young alive. It is worth remarking that Pliny, the most learned of the heathens, agrees with Moses in placing man at the head of the creation, where God placed him, classing the rest under the obvious divisions of terrestrial, aquatic, amphibious, birds, and insects, a classification that unsophisticated reason will assent to as long as the book of nature lies open, and man is not too proud to read in it. It was so the masterly genius of the great Buffon viewed these contrivances, rescued science from pedantry, brought light from darkness, and grouped families by family likeness. So Goldsmith after him, the child of sense and taste, the exquisite interpreter of nature. For though he could appreciate the efforts of Linnaeus, the vivid instinct of his own mind pointed out to him how much industry may be wasted in laborious trifling. If wit consists in seeing resemblances, and judgment in perceiving differences, I think these men discover more wit than wisdom, who catch at such slight resemblances, and overlook such glaring dissimilitudes. There are few things, indeed, animate or inanimate, in which fancy cannot find resemblance. A facile imagination finds forms in the clouds, and figures in the fire, but take away the quality of life, and there is less similarity between a man and a whale than between a whale and a whistle. Your imagination will supply the rest. My allotted hour is out, and I therefore conclude that, as the law stands, we have proved everything to entitle us to your verdict, and that none of the grounds of defense taken are maintainable. If there be any reason why the law should be altered or amended, it concerns the legislature, and the griefs of the parties must be carried there. It is for our opponents to set forth the motives of legislative interposition, and I think they must show some better reasons than they have been able to do upon this trial, or they will equally fail there. End of section 73.
Section 74 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Eric Hansen. American State Trials, Volume 3 by John D. Lawson. Action of James Maurice against Samuel Judd for a penalty. New York City, 1818, Part 7. The Recorder to the jury. In the first place, the defendant objects to the want of evidence that the plaintiff was appointed, or that any person was appointed inspector of oils under the Act, and that no penalty could attach for selling or buying without inspection if there were no person to do the duty of inspector. But this point was sufficiently made out by the evidence of Mr. Duncan and Mr. Hazard. The production and proof of Mr. Maurice's commission is unnecessary, as it was not an instrument through which the plaintiff made any title or justification. The fact of selling being proved by the admissions of the defendant to Mr. Ellis, and not at all denied, the broad question remains: has the defendant incurred the penalty under the Act? In construing statutes, a court and jury must be guided by the spirit rather than the letter. The term any oils in this section would, if taken at the letter, embrace every kind of oil, and even vegetable oil. But from the context and the letter, we must narrow it down to fish oil. The proof is that the oil in question was called spermaceti, and that it is extracted from an animal called the spermaceti whale. And there comes the question: is that whale a fish? For the defendant, it is contended: first, that the whale is not a fish. Second, if so, the oil of the whale cannot be fish oil. Third, that the legislature did not intend that spermaceti or whale oil should be inspected, but used the word fish in a different sense. To come at the true application of the law to the fact, the counsel has taken various courses. They have called our attention, first, to the theories of naturalists; secondly, to the popular acceptation of the terms used; thirdly, to the common and statute law. Between the most eminent zoologists, ancient and modern, there is much disagreement, and even the moderns are not in accordance with each other. You have heard the opinions of Dr. Goldsmith, amongst others, who, after reciting the distinguishing characteristics of the whale, still yields to the popular belief that a whale is a fish. But you have also heard the testimony, upon oath, of our learned fellow citizen, who tells you, with great seriousness, that a whale is no more a fish than a man. It is, however, admitted that the great mass of mankind, and, as Dr. Mitchell says, of those that speak English, do call it a fish. As to the legal sense, there is not much doubt. Treatises on common law, and the ancient English statutes, treat of it as a fish, and our National Congress, in legislating on the subject, likewise adopts the popular meaning. There is much plausibility in the arguments applied to the subject in these various points of view, and you must decide amongst these conflicting opinions, either adopting the opinions of the naturalists, of the mass of mankind, or of the common law. But the subject has also been presented to our consideration in another important view, that is, as to the commercial sense. As to this, it is contended that fish oils were never used in commerce as applying to anything but the oils which proceed from the livers of fish, and on this point also, very respectable witnesses have been opposed in opinion to each other. Those for the defendant have testified that if an order was given for fish oil, they would no more think of sending whale oil than they would on an order for sugar send molasses. That when whale oil is called for, it is particularly demanded by some of the names which distinguish one kind from another, as sperm oil, etc. If these opinions are correct, it would lead us to think that the legislature did not intend to include whale oil under the term fish oils. But, on the other hand, many respectable witnesses swear that in commerce it means all manner of marine oil, including the oil of whales of every species. And they have supported their opinion by producing price currents of various countries. Then you must judge to which of these opinions you will yield your assent, it being entirely a matter of fact. The mischief, to remedy which a statute is enacted, is one of the rules for its construction. Testimony has been given to throw light upon the subject also, in this pretty important point of view. But here we find the same diversity of opinion among the witnesses, some saying that there were no frauds in whale oil requiring inspection, whilst others swear to actual frauds committed and detected. There is much difficulty in coming to a conclusion. We must expound the law according to the intent of the legislature as near as we can find it. But sometimes the object to which the law is to apply is expressed by terms, the meaning of which is not defined in any book of law, nor to be ascertained except by the testimony of witnesses conversant with the particular subject, whether it belong to science, art, or commerce. And so it was understood by the defendant's counsel when they called the learned Dr. Mitchell. If, then, you are of opinion with the naturalists that a whale is not a fish, or if you think that, in the commercial sense, fish oil does not mean whale oil, you may then find for the defendant, as he will not have incurred the penalty given by this statute. You may also, if you doubt, this being a penal act, and against the common right of the citizen, which is to deal in all commodities not noxious or restrained or prohibited by law, find against the plaintiff. The jury retired, and returned in about a quarter of an hour with a verdict for the plaintiff, for the 3 penalties demanded. The defendant, being dissatisfied with this verdict, moves for a new trial in the next January term. The motion was argued by General Bogardus for the defendant, and by Mr. Sampson and Mr. Anton for the plaintiff. The recorder, being informed that the legislature, then in session, had been petitioned for an amendment to the law, delayed his opinion, intending to grant a new trial, if the sense of the legislature should make it appear that the statute had been incorrectly construed. But the legislature having passed a new act, the judge refused a new trial. By amending the law, the legislature considered that it bore the sense contended for by plaintiff, viz. That whale oil was subject to inspection. February 17, 1819. After the passing of this act, plaintiff, deeming his office of too little value or importance, immediately resigned it. End of section 74.
Section 75 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Ebenezer Clough for Embracery, Boston, Massachusetts, 1833, Part 1. The narrative. This trial throws a sidelight on the movement following the abduction of Morgan. There had been an action of libel tried in the Boston courts, in which the parties were Masons and anti-Masons, and in the course of the trial, Clough, who seems to have been active in the distributing of anti-Masonic literature, handed to one of the jurymen a pamphlet of this character. He was indicted for embracery, which Blackstone defines as an attempt to influence a jury corruptly to one side by promises, persuasion, entreaties, money, entertainments, and the like. It was the first trial in this country for that crime of which we have any record, as nearly all the voters and citizens of the state were on one side or the other of the question. The difficulty of finding an impartial jury is apparent, but the challenging of a juror because he was a Mason was not sustained, and the trial resulted in the acquittal of the accused. The trial. Footnote. Trial for alleged embracery and challenge of a juror decided by triers. Commonwealth of Massachusetts versus Ebenezer Clough. Before the Municipal Court of Boston, Judge Thatcher. October term, 1833. Boston. Printed by Beals, Homer, N.C. Number 36 Congress Street, 1833. End of footnote. In the Municipal Court of Boston, Massachusetts, October 1833. Honorable Peter O. Thatcher, Judge. October 12th. This indictment for embracery found by the grand jury at the September term of the court and continued to the present term, upon the individual recognizance of defendant, was read by the clerk to defendant, to which he pleaded not guilty. Footnote. The jurors of the Commonwealth of Massachusetts on their oath present that Ebenezer Clough of said Boston, gentlemen, on the 19th day of July in the year of our Lord, 1833, at Boston aforesaid, knowing that a certain jury of said county of Suffolk was then and there duly returned, impaneled and sworn, to try a certain issue joined in the municipal court of the city of Boston, begun and holden at said Boston, within and for the county of Suffolk aforesaid, on the first Monday of July, in the year of our Lord 1833, and then held, and being in session according to law, on said 19th day of said July, between the Commonwealth of Massachusetts by indictment, on the complaint and prosecution of one Samuel D. Green, for a supposed libel on him on one part, and on the other part the said issue was joined by one Charles W. Moore and one Edwin Sevey, as defendants, named in said indictment, and said Ebenezer Clough, also knowing that a trial had been begun, and was in progress, and was about to be terminated, and had upon the issue aforesaid, before the said court on said 19th day of July, wickedly and unlawfully intending and devising to hinder a just and lawful trial of said issue by the jurors aforesaid, returned, impaneled, and sworn as aforesaid, to try said issue at said Boston on said 19th day of said July, unlawfully, wickedly, and unjustly, on behalf of said Samuel D. Green, the said prosecutor in said case, did corruptly move, desire, solicit, and persuade one Nathaniel Frothingham, one of the jurors of said jury, returned, impaneled, and sworn according to the law for the trial of said issue, to take and receive from said Clough, and the said Clough did unlawfully, unjustly, and corruptly give and deliver then and there to said Frothingham, one of the jury as aforesaid, before said jury had been charged and instructed by the court, and before they retired to agree on a verdict, a certain printed paper, one part whereof purported to have printed thereon a letter of the Honorable Samuel Dexter to the Grand Master of the Grand Lodge of Freemasons of Massachusetts, and on another part thereof there was purported to be printed and addressed to the Masonic fraternity, extracted from the Boston Sentinel, printed in the year 1816, and said Clough, with the unlawful intentions aforesaid, did then and there urge, solicit, and persuade said Frothingham, one of the jurors aforesaid, to read said printed paper, and to let others of the jurors so as aforesaid returned, impaneled, and sworn, to try the said issue to read the same, by way of commendation on behalf of said Green, prosecutor of said indictment as aforesaid, in as far as he was concerned and interested in the trial of the issue aforesaid, and in disparagement of the said Charles W. Moore and Edward Sevey, defendants named in said indictment as aforesaid, is so far as they were concerned and interested in the trial of said issue, and to influence said Frothingham and incline him to be more favorable to said Green than to said Moore and Sevy. And said Clough did then and there deliver to the said Frothingham, for the purpose aforesaid, the said printed paper, and said Frothingham did then and there receive from said Clough the said printed paper, and he carried the same there afterwards with him into the jury room, when said jury retired into their room to deliberate, and agree upon their verdict and finding as to the issue aforesaid. He, the said Clough, then and there, well knowing that said Nathaniel Frothingham, then and there was one of the jurors returned, impaneled and sworn to try the said issue, against the peace and dignity of the Commonwealth aforesaid. End of footnote. S.D. Parker, Commonwealth Attorney for the prosecution. B.F. Hallett for the defendant. Footnote. Hallett, Benjamin Franklin, 1797 to 1862. Born Barnstable, Massachusetts. A noted politician, delegate to many political conventions, chairman of the National Committee of his party, United States District Attorney, Massachusetts. End of footnote. The clerk proceeded to call the jury. The first juror called was Daniel Sargent. Mr. Hallett challenged the juror to the favor on the ground of supposed bias growing out of the oaths and obligations which he had taken upon him as a Mason, the nominal prosecutor in this case being a Mason, and the defendant not a Mason. He claimed the right in behalf of his client to have the inquiry gone into, whether the jury had taken obligations as a Mason, which might prevent his standing indifferent before he was sworn in this cause. Judge Thatcher. The statute makes it the duty of the court on motion of either party to inquire of the juror whether he was conscious of any bias or prejudice. Mr. Hallett said he did not make that motion and did not propose to question the juror under the statute, but having a right to choose either mode, he should elect to prove the facts, aliundi by introducing testimony, instead of putting the juror on his voir dire, which would preclude further examination. Judge Thatcher said he had an undoubted right to elect to proceed either according to the statute or under the common law. Mr. Hallett said he preferred the mode pointed out by the common law. Mr. Parker, if the gentleman elects to proceed under the common law, triers must be appointed, which had never been the practice in this state, though I am not prepared to say it is not a correct course. Mr. Hallett, I am not aware what the practice had been, but believe the common law is in force here, that a principal challenge was to be tried by the court, but a challenge to favor for bias, etc., by two triers. Judge Thatcher, the question is a novel one, but I incline to the opinion that the proper mode to try a challenge to favor, where the party claimed it, is by appointing triers. If the counsel has any authorities in point, I should like to hear them. Mr. Hallett, I cite 7 Danes Abridgment, Section 3, Article 6, page 332. 1. Archbold's Practice, 184. Company Lit, 158A. 2. Keynes Rep, 138. 1 Cohen, 441. 1 South Rep, 364, 712. The doctrine there laid down is, if the challenge to the polls be to the favor, it is thus tried. If 2 jurors have been already called and take the box without challenge, they shall try the challenge. If not, the court appoint 2 indifferent persons to try it, and who are thence named triers. If the triers try 1 juror, and he is found indifferent, he and the 2 triers shall try the next. Mr. Dane is in his abridgment, Volume 7, page 332, has this remark: acquaintance, etc., is a challenge to the favor and must be left to the triers sworn well and truly to try the issue whether the juror stands indifferent between the parties to this issue. From this remark and the fact that Mr. Dane nowhere says the common law relating to triers is set aside by the jury statute of 1807, I argue that the common law is still in force on that point in this Commonwealth. Judge Thatcher held that the triers should be appointed, and that no juror having been impaneled, the first juror called being the party challenged, the court must appoint triers from the bystanders. He accordingly named Mr. Chalice and Mr. J. Marshall, members of the bar. Mr. Marshall said that he was summoned in this cause as a witness for the defendant. He was excused by Judge Thatcher and Bradford Sumner, a barrister at law appointed. Mr. Chalice claimed to be excused on the ground that he had formed an opinion upon the question whether Masonic oaths disqualified a juror from sitting, and he also was excused by the court as not standing himself indifferent. John Pickering, barrister and city solicitor, was next appointed. Mr. Pickering protested against the right of the judge to take up a counselor and make him act as a juror. He said he was also engaged in other and more important business. The judge said the service must be performed by someone, and he knew of no one more qualified to discharge it than the gentleman he had appointed. Mr. Summers said he was not fully advised as to his rights or his duties in this case, but was disposed to conform to both if he knew them. He conceived the exemption of a counselor and attorney which applied to their serving as jurors, also by analogy extended to triers, who were in effect jurors, and lawyers could not be made jurors. Mr. Hallett: lawyers could be made judges, and even jurors were judges. Triers were especially so, for they acted in the capacity of judges. Mr. Pickering said he was not apprised whether the proceeding was correct, but it appeared to him to be entirely irregular to select the triers from the officers of court, and he should like to be heard on that point. He thought the question ought to be reserved for the decision of the Supreme Court as to the right of exemption. Judge Thatcher: this is a question which, in its present stage, must be decided here, and for that purpose this court is supreme. I conceive I have a right to the services of the gentlemen, and they must take their seats as triers. Mr. Pickering: I never before have been obliged to submit to a mandate of the court, but if it is to be insisted on, I shall not resist the requisition, though I conceive it to be arbitrary to enforce me to this service. Judge Thatcher: the best men must expect to perform the most service, and sometimes they must submit to a disagreeable service, as in the present case. I conceive I have a right to their services to aid the court by their judgment in this business, and shall insist upon it. The following oath was administered to the triers by the clerk: you shall well and truly try whether Daniel Sargent stands indifferent between the parties to this issue. Mr. Pickering requested the court to note the exception taken to the right to require a counselor to sit as a trier, which was done, and the gentlemen took their seats as triers. Mr. Hallett: I expect to prove a bias by showing that the juror was a Freemason, that the nominal prosecutor was also a Freemason, and the defendant not a Mason, and that the obligations assumed by the juror as a Mason and the relation he stood in this particular case, are calculated to create a bias or prejudice, even unconsciously to himself, and under which he could not act with entire impartiality. The evidence. Benjamin Russell: Mr. Hallett: do you know Daniel Sargent to be a member of the Masonic fraternity? I do not. Did you ever meet him or sit with him in a lodge? I shall not be interrogated by anyone but your honor. If your honor will put the question, I am bound to answer. I will answer them. I will not be questioned except by the court. The court: why, Major Russell, you are necessarily as a witness bound to answer all legal questions which the counsel may put to you. The court will see that your rights as a witness are protected, but it cannot take the right of examination from the party and its counsel. Mr. Russell: then I must submit, but I do not wish to be interrogated impertinently. Mr. Hallett: you may rely upon it, sir, that I shall treat you with entire respect, but I must insist upon my right to have you answer such questions as the court does not prevent my putting to you. I thought there was something impertinent in the question. Oh, no, sir. You will find no cause to complain. I shall treat you with very great respect. I only want to get all the facts. The court. You will answer the question. Did you ever meet with Mr. Sargent in a lodge? Mr. Parker. The question is wholly irrelevant. It has nothing to do with the matter in issue, whether the jurors stood indifferent. The court. I think the question a proper one, and the witness must answer it. I have got it down that the witness says he does not know Daniel Sargent to be a member of the Masonic Society. Mr. Russell. I wish to correct it. My answer should have been that I had no personal knowledge that he was ever initiated as a Mason. Whether I have ever sat with him in a lodge I cannot recollect. I was never present when he was tried as a Mason. It is 30 years since I have been much in the working lodges. I have been in the Grand Lodge, and did not attend the working lodges much after I became a member of the Grand Lodge. Mr. Hallett. Mr. Witness, have you ever seen? Mr. Russell. I consider that impertinent. I have not been in the habit of being called Mr. Witness. It is not my name. Mr. Hallett. Then if you prefer it, I will certainly call you Major Russell. Mr. Witness is a very common mode of address at the bar, and I never before heard of its being considered impertinent. Mr. Russell. It sounded to me so. Mr. Hallett. Then you are certainly under a wrong impression. The witness may rely upon my treating him with all proper respect, consistent with the rights of my client. Mr. Parker. It is now apparent that the witness is a Mason, and I object to his being examined. If being a Mason is an objection to a juror, it is to a witness. Mr. Hallett. The cases are entirely different. A witness cannot be set aside for bias or prejudice, but a juror can. The court. You need not answer that objection. The question, as I have taken it down, is, have you ever seen Mr. Sargent in a Masonic procession? Mr. Russell. To the best of my recollection, I have not. There have not been many Masonic processions of late years. There was one at the laying of the cornerstone of the temple. I do not recollect whether I saw him there. I should not have been surprised if I had seen him there, because I always esteemed him as one of those high and honorable men who usually are Masons. Mr. Hallett. Did you know Mr. Daniel Sargent in 1801? Yes. Was he then known as Daniel Sargent, Jr.? He was. Were you at the time Grand Marshal of the Grand Lodge? I believe I was. Mr. Hallett. Here is a book called Harris's Masonic Discourses. Look at the list of members of the lodges, etc., printed in it, among which appears your name and that of Daniel Sargent, Jr. as Masons. Mr. Russell. I remember subscribing for that book, and suppose the list it gave of Masons is correct, but whether Mr. Sargent subscribed to it or not, I cannot tell. Mr. Parker. We object to the book being offered in evidence. It might have been printed for the occasion at the advocate office. Mr. Hallett. Oh, no, it is a very old book, as the gentleman may see if he will look at the title page. It was printed as long ago as 5801. The court said the book could not be given in evidence to prove that the juror was a Mason. Mr. Hallett called Mr. Sargent the juror to be sworn as a witness before the triers. Mr. Parker objected. The court. He cannot be sworn. You have elected to prove the bias by other testimony, and must pursue that course. Hallett. I concede that I have the same right to call the juror as a witness as to call any other person as a witness before the triers. It is so laid down expressly in the books, and is the uniform practice in New York, where this mode of trying the impartiality of a juror is very common. In all the Lockport trials, the challenged jurors were invariably examined before the triers. The court. You cannot require the juror to be sworn in order to disparage himself by his testimony and to show that he is not qualified to sit as a juror. Mr. Hallett. A juror may be sworn as a witness before trials of his bias, unless the matter tends to his dishonor or discredit. In 1 Cal 435, the juror was sworn before the triers on the issue of the challenge, and the Supreme Court held that there was no impropriety in swearing the challenged juror as a witness, though the challenge was a principal challenge which ought to have been tried by the court. The court decided that the juror could not be examined as a witness, on the ground that it would tend to his disparagement of himself, and he could not be required to testify to what will discredit him. Mr. Hallett asked the court to note the exception he should take to the decision of his honor, excluding the juror as a witness, in case the result of the trial should make it necessary to his client. Having this testimony unexpectedly excluded, he was not prepared with further testimony to make out the fact that the juror was a Mason, which was the first step in order to show that he was under a bias, growing out of his Masonic oaths. Having failed, therefore, to make out the fact that the juror was a Mason, which comprised the whole ground of objection, he withdrew the objection and the juror might be sworn. The court: I cannot take the issue from the triers. The case is before them, and they must consider of it and return their verdict. Mr. Sumner, one of the triers, conceded that the presumption in every case was that the juror stood indifferent, unless objected to, but when the objection was taken out of the way, the presumption of impartiality prevails. The objection was withdrawn in this case by the party who made it. Mr. Pickering, the other trier, did not see the necessity of a verdict after the objection was withdrawn. The juror stood as if no challenge had been made. The court: Gentlemen, the case is before you, and you must decide it. It is not in my power to take it from you. You must hear both sides and make up your decision whether the juror stands indifferent. Mr. Hallett: I had supposed that by my withdrawing the objection, I left the matter where it was before the challenge was made, and I did so because the evidence did not seem to establish the fact that the juror was a Mason, and I do not wish to detain the triers by arguing upon this evidence. But if they were required to give a verdict, I felt it due to myself and my client to show to the triers that if the facts were made out that the juror was under Masonic obligations, the grounds of the challenge were well taken, in the exercise of a plain legal right, and therefore ought not to work any prejudice to the defendant. The court: The counsel is at liberty to proceed. End of section 75. Section 76 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Ebenezer Claw for Embracery. Boston, Massachusetts, 1833, Part 2. Mr. Hallett: Gentlemen triers, having by the decision of the court been unexpectedly deprived of the testimony on which I relied to prove the fact that the challenged juror is a Freemason, I had intended to relieve you from any further consideration of the subject, and therefore withdrew the challenge. The whole and only ground of objection being that the juror, as a Freemason, has done certain acts and assumed certain obligations, which furnish legal grounds for the belief that he does not stand indifferent in this cause. If he has not taken these obligations as a Freemason, I know of no objection to his indifference, and certainly have none to his entire respectability as a citizen. But although I might have argued from the somewhat confused and contradictory statement of the witness that the juror was a Mason, yet as the evidence was not sufficient to satisfy my mind as to that fact, I presumed it could not satisfy yours. I therefore felt bound to withdraw the challenge. The court, however, is of opinion that the question cannot be taken from you, and that the triers must return a verdict. And as I know not in what form that verdict may be returned, I deem it a duty I owe to myself and my client to state the grounds upon which the challenge was taken, in order to obviate the effects of any prejudice it might otherwise excite in this cause. Besides, as you are required to pass upon the testimony before you, I may at least infer the possibility that the conclusions you will come to, as to the fact whether the juror is a Mason, may be different from what the evidence seems to me to warrant. If under these circumstances I claim your attention, I shall esteem myself and my client fortunate in an opportunity of presenting the grounds of this challenge. Two gentlemen distinguished for their professional learning and sound judgment. I make this no party a political question, but simply a legal question. The grounds of this challenge are strictly legal, and though the question is novel here, the principles that govern it are the same as those that govern every other challenge to the favor. I do not challenge the juror because he is a Mason. That principle I totally disclaim, because it would go directly to his general competency as a juror in any case, and would be a principal challenge, and not a challenge to favor. He may be a Mason and yet be a lawful juror in many cases, but I challenge him to the favor in this cause, on the ground of bias, because he has, out of court, assumed certain obligation toward the members of a particular society, whose direct tendency is to compel or to incline him to give any member of that society a preference over a party who is not a member. The object of the challenge is to secure an impartial jury, a right of which the law is extremely jealous, and therefore challenges to the favor always to be regarded with indulgence, especially in this case, gentlemen triers, should the defendant be secure of having a jury free from all bias or prejudice against him. He stands charged with an attempt to influence a juror by an improper bias, and surely he should be tried by a jury who are themselves free from all external influence or improper bias. If he is to be punished for attempting to render a jury partial, it should not be by a partial jury, some of whom are under obligations to favor the nominal prosecutor more than the defendant in this cause. The whole object and pretense of this trial is to guard the purity of juries, and it would be a libel upon public justice that a party thus arraigned should not be entitled to avail himself of every legal objection that will secure to him a fair trial by a jury as impartial as the lot of humanity will admit. You are then to consider the relation of the parties, assuming, as proved, that the juror is a Freemason. The legal prosecutor, who is virtually the party represented by the Commonwealth, is a Mason, and defendant is not a Mason. The offense charged is an attempt to influence a juror in a case which has produced much excitement between Masons and anti-Masons. Under these circumstances, can a Mason on the jury be above all suspicion of bias? I do not place this question precisely on the ground of a case involving private interest between a Mason and one not a Mason. It is not so strong a case as that would be, I admit, but I take it on the broad ground of the constitutional right to an impartial jury, which every citizen can claim. There are two kinds of challenge, as is familiar to you gentlemen. A principal challenge for clauses which in themselves disqualify a juror, and a challenge to the favor, which depends upon evidence to establish a bias or leaning, or undue influence in the mind of a juror. Such a bias or influence, we conceive, exists between a juror and a party who are Masons, the other party not being a Mason. The principles laid down in the authorities which apply to this Masonic relation between a juror and one of the parties to a cause are these. Third Black, Com 363. It is a good cause of challenge to a juror that he is the party's master, servant, steward, attorney, counselor, or of the same society corporation with him. The same rule is laid down in 1 Archbold's Practice 183, and also in 7 Dane's Abridgment 332. Mr. Dane says, or of the same society, omitting the word corporation, but the principle is the same. See also Coke on Littleton, Lib 2 157b, Section 234, where the causes of challenge to the favor are very fully given, and show upon what slight grounds of suspicion of bias the law will set a juror aside. The case of Me McQueen versus Kelburn, 7 Cranch 291, 297, involves principles directly in point. Chief Justice Marshall takes ground there to secure impartiality in a jury, which cannot be sustained unless the analogy is to embrace the case where the juror and one of the parties are brother Masons. The doctrine there, which aptly applies to the challenge of a Mason, is this: if a jury declare an oath to the triers that the testimony being equal, he should find a verdict for the plaintiff, he should be rejected. Now Masons hold that all things being equal, they are bound to prefer a brother Mason. To Reeves' History of the Sea Law, page 446, says, a great or particular familiarity between the juror and a party, as being constantly at the same table with him, is a disqualification. Is not the intercourse between Masonic brethren closer than this? In Burr's trial by Robinson, Volume 1, page 415, Chief Justice Marshall states the objection to a juror arising from remote relationship and adds, it is because the law suspects his prejudice, because in general persons in a similar situation would feel prejudice. So affinity to any member of a corporation, which is a party, is cause for challenge. 1 Saunders 344. Now, would it not be absurd that the law should be so solicitous to secure an impartial jury as to exclude from the jury a distant, unknown relative of the party, to the 9th degree even by marriage, and yet be wholly regardless of the strong artificial ties of brotherhood created by Masonic relations, where the juror is under sworn obligations to the party, much more unfavorable to an impartial decision than remote ties of relationship can be? Can it for a moment be believed that a 9th cousin would be more likely to favor the party thus related to him than a Mason would be to favor a brother Mason, whom he has sworn to obey and assist, and to extricate from difficulty, right or wrong? In 2 Salkeld 81, there is a case of a juror set aside from the trial because it was proved that the juror had lately entertained the prosecutor at his house. This circumstance, and in the case of a public prosecution too, was deemed sufficient to excite suspicion of the juror's impartiality toward the defendant, and he was set aside. In 2 Kane's Report 133, Judge Livingston strongly implies that it would be a good challenge to the favor that the juror was an underwriter, in a case where one of the parties to the suit were also underwriters. Judge Woodworth cites and approves this principle in 19 Johns 121-122, and he also held in that case that it would be proper evidence to support a challenge to the favor that a juror was an endorser of a note or a stockholder at the bank of one of the parties. Anthony's Prius 75, Lewis versus Few. In an action for a libel, the plaintiff challenged a juror as incompetent on the ground of his having been present and acting at the meeting at which the libel complained of was made public. In that case, Justice Thompson, now a judge of the U.S. Supreme Court, charged the triers that the challenge was well taken and that the juror could not be considered indifferent between the parties. In 1 Cowan 432, Pringle versus Hughes, there is much valuable instruction on this point in the mode of ensuring an impartial jury. In that case, the plaintiff in the court below had refused to go on with the trial because the judge denied him an impartial jury. Chief Justice Savage refused a motion for judgment as in case of non-suit because the plaintiff was entitled to a jury free from partiality and bias. The ground of challenge in that case was that the juror had expressed an opinion. The juror himself was called as a witness before the triers, which the court say was properly done, and on his evidence the challenge was overruled. And yet Chief Justice Savage remarks, there is no reason to suppose the challenge was made for the purpose of delay, but in good faith and under an honest impression that a fair trial could not be had by that jury. The essence of the whole law on this subject is well expressed by Judge Woodward in the case of Vermillion versus People, 7 Column 122, viz., that the requisition of the law is that the mind of the juror is in a state of neutrality as respects the person and the matter to be tried, that there exists no bias for or against either party in the mind of the juror, calculated to operate on him. So, if the triers are in doubt whether the juror is indifferent, they should find him not indifferent. 1 Column 439, CH Recorder 81. In this Commonwealth, the legislature and the courts have been extremely cautious to ensure an impartial jury to the party. The challenge in this case, if the juror is a Mason and has taken Masonic oaths, is founded on broad constitutional principles. The Constitution of the United States declares that the accused shall enjoy the right of trial by an impartial jury. The 11th section of the Constitution of Massachusetts declares that every subject of the Commonwealth ought to find a certain remedy by having recourse to the laws for all injuries or wrongs in his person, property, or character. It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. By the Statute of Massachusetts of 1807, Chapter 139, Section 9, it is enacted that the justices of the respective courts shall, on motion from either party in a suit, put any juror upon oath, whether he is any way related to either party, or hath formed or given any opinion, or is sensible of any particular interest or prejudice in the cause. And if thereupon it shall appear to the court that such juror does not stand indifferent in the cause, another juror shall be called or returned, and be placed for the trial of that cause in his stead. This statute was in extension and not in repeal of the common law relating to jury trials, because if this were the only mode of trying a juror's indifference, the party was entirely at the mercy of a corrupt juror who might be biased or bribed or have expressed an opinion, and yet if he denied it on his oath, the party could not contradict it by testimony, and must abide by it. A strongly analogous case is presented in the Statute of Massachusetts 1807, Chapter 75, a limitation of real actions, which provides that no person shall be allowed to sit on a jury for trying the value of buildings, where such person is interested in a similar question, but the same shall be good cause of challenge to such juror. In Jeffries versus Randall, 14 Massachusetts 205, the courts say, this provision extends to all cases where the juror is liable to be interested in a similar question, although no action is pending to which he is a party, in which a similar question may arise. It is apparent that the legislature intended to exclude from juries in the trial of causes of this description not only such as were interested, prepossessed with an opinion, or of kindred to either party, but it extended its caution to such as from their being liable to be interested in a similar question might have their affections excited in the trial of a cause. In Commonwealth versus Ryan, 5 Massachusetts 90, a challenge was made to the jury in an action where the forfeiture went to the county on the ground that the jurors had an interest, although almost indivisible. The court set aside the challenge solely on the ground of necessity, because no jury, not inhabitants of the county, could be returned, and the cause could not otherwise be tried. They say, a remote and small corporate interest is no legal objection to a juror's trying a case, if by the necessary construction of the law the cause could not otherwise be tried. In a case in New York 2 Johns 194, where one brought an action qui tam to recover a fine, half of which went to the inhabitants of a particular town. All the juries belonging to that town were challenged and set aside. The court declared that the jurors must be omni exceptione majoris, free from every objection and wholly disinterested. These decisions relate to matters of pecuniary interest. It is true, but they go directly to illustrate the principle. If the interest of a few cents or the fraction of a cent is self-sufficient to affect the oath of a juror to decide impartially, will not the affections or prejudices of a juror go much farther, especially in the relation one mason stands to another? In the Commonwealth versus Knapp, 9 Pick 496, a juror having said his prejudices were against the prisoner, but that he had no definite opinion, and should be governed by the evidence, was set aside for cause. In the same case, a juror, on his voir dire, was asked if he had formed such an opinion as incapacitated him from giving an impartial verdict, replied he did not know how much he might be influenced by his preconceived opinion. This was held as sufficient cause for challenge. In 14 Massachusetts 207, the court says, if we had evidence that the juror acted under the influence of improper motives or principles, we should set aside the verdict. All these cases go to show the extreme jealousy of the law in guarding against any prejudice, bias, prepossession, or influence on the mind of a juror, and they certainly apply with increased force to the influence and bias between one Mason and another Mason, growing out of the Masonic relation and obligations. We have seen what the Constitution of the United States and of this state say upon the subject of an impartial jury. Are they less emphatic in this respect than the Constitution of Great Britain? If not, then the construction put upon the British Constitution by Lord Kenyon is directly in point in this case. In 4-term Republic 289, King versus Joseph, in the year 1791, Lord Kenyon, Chief Justice, says, it is the pride of the Constitution of this country that all causes shall be decided by jurors who are chosen in a manner which excludes all possibility of bias, and who are chosen by ballot in order to prevent any possibility of their being tampered with. But if an individual can break down any one of those safeguards which the Constitution has so wisely and so cautiously erected, by poisoning the minds of the jury at a time when they are called upon to decide, he will stab the administration of justice in its most vital parts. In what way could an individual more secretly and effectually poison the mind of a juror at the moment he was about to decide a case, than to have it in his power to make to the juror a secret sign of fraternal relationship, or a sign of distress, which the juror had previously taken an oath to obey, and to fly to the relief of the party making it? The principles governing the impaneling of a jury are well laid down in 4 Bacon's Abridgment 561, titular juries, E5, and are especially applicable to this challenge. Jurors are to be omni exceptione majoris, free from all causes of objection from partiality or incapacity, consanguinity, and affinity. Therefore, if the juror be under the power of either party, as counsel, servant, or tenant, he is expressly within the intent of the writ, and must be set aside. So if he has declared his opinion touching the matter, or is a parishioner of the parish whereof the other party is parson, and the right of the church comes in question, or has done any act by which it appears that he cannot be impartial, these are principal causes of challenge. But though a juror has not given apparent marks of partiality, yet there may be a sufficient reason to suspect he may be more favorable to one side than the other, and this is a challenge to the favor. And in these inducements to suspicion of favor, the question is whether the juryman is indifferent as he stands unsworn, for a juryman ought to be perfectly impartial to either side, but otherwise his affection will give weight to the evidence of one party, and an honest but weak man may be so much biased as to think he goes by the evidence when his affections add weight to the evidence. This is the peculiar danger of a partial bias in the minds of even upright men who are under Masonic oaths. The oath, the fraternal tie, and the inclination all lead to favor the brother against one not a brother, and these can readily furnish a justification for doing so, even to a pretty conscientious man who is a Mason, and to decide a cause between a Mason and one not a Mason. Relationship is a good ground of challenge if the juror is related to either party within the ninth degree, though it is only by marriage. A principal challenge will be admitted. 1 Chit CL 541. The juror being of kin to any member of a corporation or of a party is a principal cause of challenge. Challenges are allowed where the issue concerns a city or corporation, and they are to make the panel, or where any of their body be, to go on the jury or any kin to them, though the body corporate be not directly party to their suit. So where a dean and chapter brought an assize, a juror was challenged because he was brother to one of the prebendaries. The importance of guarding a jury against every possible bias is strongly urged in the 13th of Massachusetts, Rep. 220, Knight versus Inhabitants of Freeport. The court says, too much care and precaution cannot be used to preserve the purity of jury trials. We cannot be too strict in guarding trials by jury from improper influence. This strictness is necessary to give due confidence to parties in the results of their causes, and everyone ought to know that for any, even the least intermeddling with juries, a verdict will always be set aside. These arguments are drawn principally from analogy, but they fairly establish the position I started with in the beginning, that there is nothing which ought to excite alarm or condemnation in a challenge of a juror for Masonic favor, any more than the challenge of a relative or any other person on the jury, whom the law suspects may be biased, in consequence of such relation and of certain obligations to favor one party more than another. The principles, therefore, which govern this challenge are fixed. The only question for consideration is their application to this case. Such application has been made in several decisions in courts in this country. I will now read from Opinions on Speculative Masonry by James C. Ordiner. Appendix, page 271. Trial of Elihu Mather for the Morgan Conspiracy in Orleans County, New York, 1829, before Judge Gardner. John C. Spencer, the special counsel, challenged Robert Anderson, a juror, on the ground that he was a member of the Society of Freemasons, to which the defendant also belonged. The juror himself was sworn as a witness before the triers, and Judge Gardner charged the triers that if they were satisfied the juror had taken the Masonic oaths, as testified to, they would reject him. The triers decided that Anderson was not impartial. In the same case, John Dolly was challenged and set aside for the same cause, after being sworn as a witness before the triers. In the trial of Elijah Adams before a special court, Judge Nelson at Lockport, New York, February 1831, Andrew Estes, the first juror, was challenged as a Mason and set aside by the triers. George W. Rogers, Caleb W. Raymond, and one other Mason was on the jury, were also rejected. William Wilson, a master Mason, was called before the triers and swore he had forgotten his obligations, was initiated in Canada. The court admitted this man, who was the only Mason on the jury. The jury did not agree. All but one were for bringing in a verdict of guilty. The juror who stood out was called for by the judge, and Wilson, the Mason, stood up. In other trials for the abduction of Morgan, Judge Marcy, now governor of New York, repeatedly decided that a juror who is a Mason was incompetent to act impartially, where the party was a Mason. No verdict upon the plainest evidence could be obtained against the conspirators, where a Mason was left upon the jury, and they were almost invariably the only jurors who held out against conviction. In a civil suit between Richard Shaw and John C. Borden, before the Court of Common Pleas, Newport County, Rhode Island, in November 1830, Bateman Monroe, a Mason on the jury, was challenged on the ground of bias, the defendant being a Mason and the plaintiff not a Mason. The challenge was made by George Turner, Esquire, and was argued by Honorable T. J. Pierce, formerly Attorney General and then a member of Congress. The court sustained the challenge, and the juror was declared not impartial. I hold in my hand, gentlemen, a manuscript copy which has never been printed of the able and learned opinion on that point given by Chief Justice Jocelyn, and though he be a Rhode Island judge, I should be proud to lay this opinion before you or any other jurist in the country. It will bear the closest scrutiny. It considers the question purely as a legal question, and ably vindicates the right every citizen has to be tried by a jury, free from the biases of Masonic Brotherhood and Masonic oaths. I think no sound lawyer could read that opinion without being satisfied that a challenge for favor to a juror who is a Mason, in a cause where but one of the parties is a brother Mason, is well founded in law and in the fundamental principles of justice. The rejection of Monroe, the juror, though he was a very respectable man, was fully justified by subsequent events. For when this same man was sworn before the committee of the legislature to investigate Masonry, he there admitted that he had always used his Masonry as captain of a vessel to aid him in smuggling. The grounds upon which a challenge of this kind is sustained have been greatly misapprehended and misrepresented, and the notions of proscription, persecution, and disfranchisement are successfully held up to prevent a clear view of the question and its legal bearings upon the right of a party to have his case submitted to a jury, standing strictly impartial and free from all reasonable suspicion of bias. There is no disfranchisement of jurors, as it is called, intended by a challenge to the favor in this, any more than in any other challenge for legal cause. The same settled principles of law are applied to this case, as one applicable to all other challenges for bias. The right is claimed, and nothing more, under the known laws of the land to challenge a juror who is under Masonic ties and oaths, and all trials where Masonic oaths and affinity may, by implication of law, create a bias, favorable to one party and unfavorable to the other. We protest against the right of a class of citizens belonging to a secret society to have their causes tried by jurors standing in a sworn relation to them, which binds them to fly to their relief and to extricate them from difficulty, even if this artificial brotherhood goes no further than to bias the juror to one party more than the other, where the testimony is balanced. Still, I contend it is a good ground for challenge, and gives an advantage over all others to members of this society, which have no right to claim over their fellow citizens. The court, the legislature, must regulate this. So long as the law did not disqualify a Mason from being a juror, he had a right to sit. Mr. Hallett, allow me to say, gentlemen, with the utmost deference for the court, that the suggestion which has just fallen from His Honor the Judge is one of the popular misapprehensions in relation to this subject. It does not discriminate between the genus and the species, and receives as a general disqualification what is only intended for an exclusion in particular cases. A Mason is not to be held incompetent as a juror in all cases, but is laboring under a bias which disqualifies him in particular cases. The legislature had nothing to do with this question as applicable to individual cases. They could not, without manifest injustice, make a law to exclude a particular class of citizens having the legal qualifications from being jurors at all, and the principles of law are already sufficient to exclude any juror where there is undue favor, affection, a prejudice, or bias. The application of these principles depends upon each particular case. Masons, therefore, I repeat, are not to be excluded from all juries because they are Masons, but they are to be excluded in all cases where the relation they stand in to a brother Mason on trial may induce an improper bias or affection, so that even an honest man may be subject to bias as a juror, and to think that he goes by the evidence alone. When the weight of evidence is increased for the secret obligations, he is assumed to favor one of the parties. Were it proved to you, gentlemen, that a juror had made an unqualified promise to one of the parties in any cause to fly to his relief and help him out of difficulty, would you hesitate to pronounce him not impartial, not indifferent? Does a juror satisfy the law who stands so that, all things being equal, his mind is made up beforehand to incline to one party more than the other? Are men, not Masons, obliged to take this risk against themselves and in favor of those who are Masons, in all cases where testimony is equally balanced? The suggestion of disfranchisement to the jury is therefore wholly unfounded. Members of the same religious society with one of the parties are incompetent jurors, and yet no religious society calls this a disfranchisement. In the case of Reverend Dr. Phillips in New York, an indictment for conspiracy, members of the Presbyterian Church to which the prosecutor belonged were held incompetent jurors. The presumption of bias in the mind of a Masonic juror is found on the circumstance of the general favor he is under obligation to extend to a particular class of persons, and not on the consideration of the juror's motives as a juror. Hence, it no more disfranchises a jury to prevent his sitting in a cause where he may favor a Masonic brother, and to prevent his sitting in a case where he may favor a natural brother or other relation. In both cases, the juror may act honestly. There are Masons who would be above this bias. There are also natural brothers who might safely be entrusted to decide a cause between a brother and a stranger. But does that prove the principles of the law to be unjust, which exclude a brother from the jury when his brother is a party? The policy of the law will not trust him. It will not expose him to a conflict between his duty and his affections, and much less ought it to expose him to a conflict between his Masonic and civil oaths, which are incompatible. The brother Mason is bound by express oaths and promises to obey all signs and summons from his brother Mason, to fly to his relief at the risk of his life, to apprise him of danger, to answer the grand hailing sign of distress, which may at any moment be made in open court, unobserved, between the party and a juror, and to espouse his cause, so as to extricate him from any difficulty, right or wrong. The natural brother has made no such promises as these, and yet is excluded from the jury when his brother is a party. The case is precisely parallel. The natural brother is not disqualified as a juror because he is a brother, but because his brother is a party to the suit. It is not a general, but a particular exclusion, not an objection to competency at large, but to qualification in a particular case. Why then should Masonic brothers insist upon the right of sitting on juries to decide causes where their brethren are concerned, any more than natural brothers should? If it disfranchises the Mason to exclude him, and implies aught against his fairness as a man, does it equally implicate the natural brother to exclude him? I might enlarge upon the relation of master and servant in which each Mason, by his oath to obey signs and summons, etc., stands to another Mason. That relation in law excludes a juror, on the ground that the juror must not, in any case, be subject to the command of either party and bound to obey him. Neither is the sitting of a juror in any cause a franchise, a privilege, but a duty, a burden imposed by the law, as you gentlemen have found the burden imposed on you, of sitting as triers. If to sit on a jury be a privilege, a franchise, why are certain classes of citizens exempted from the service as a special favor? Hence, it can be no disfranchisement to set a juror aside on legal grounds of challenge. The franchise consists in the constitutional and legal right of the party to be tried by an impartial jury free from all bias. Taking then the principles and analogy of the law governing challenges of juries, and assuming as a fact that Masons are to be subjected to the same disabilities, and no more, and are bound by the same liabilities and no more, when before a jury or on a jury, as are all other citizens in all other relations, it then must follow that a Mason, who is a party to a cause, has no right to avail himself of the sworn services, or the undue bias which may determine a Masonic juror in his favor, more especially in a cause nicely balanced between a Mason and one not a Mason. It also follows that as a juror can have no interest in the result of the cause, so he ought to have no secret motive operating upon his mind, and inclining him to favor one party more than another, and therefore he has no right as the member of a society whose brother members he has sworn to aid, to sit on a jury, where by possibility he may feel bound to comply with that obligation to the injury of another party. So long, therefore, as men free from such secret obligations and affinity can be found to decide a cause, it is the right of a party, not a Mason, in a suit which one who is, to have a jury of men who have taken no oaths to each other, which are not openly enjoined by the laws of the land. Gentlemen triers, I thank you for your patient attention, though the main question involved in this challenge cannot, I apprehend, be decided on by you under the testimony. Yet I felt unwilling to have a verdict made up by you, without some statement of the legal grounds on which the challenge was made. Those grounds, I believe, will bear a close investigation. They present nothing novel, except the new application of old principles, and they involve a most important right to the citizen, the right of trial by an impartial jury. It is exceedingly important that the public confidence should not be destroyed in this civil institution, the value of which, like all others we enjoy, depends upon public opinion. End of section 76. Section 77 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Ebenezer Clough for Embracery. Boston, Massachusetts, 1833, Part 3. Mr. Parker, I did not intend to go into an argument in reply to the elaborate argument which has been addressed to the gentlemen triers on the other side. The objection had been taken wholly unexpected to me, and I do not conceive that the evidence in the case is sufficient to sustain the objection at all in this case, if indeed it could be sustained in any case. The counsel on the other side did not object to the juror because he was a Mason, but because if he is a Mason, he might be biased by the obligations he has assumed as such. Now all this argument amounted to nothing if the fact was not proved that the juror was a Mason. The gentleman had failed in his first step, and it was unnecessary to follow him beyond that. I agree to the law he cited, with the exception of the principle that suspicion of bias is to be taken as sufficient proof that the juror does not stand indifferent. But there is not a tittle of evidence that the juror is a Mason. The gentleman admits it, and withdrew his objection for that reason. Besides, if he were, to whom does he stand related as a Mason in this case? The Commonwealth is the party, and the Commonwealth is not a Mason. If the doctrine contended for were insisted on, it appears to me we must exclude anti-Masons as well as Masons, and we should soon be unable to try a cause for the want of a jury belonged to neither of these classes. The relation, so much insisted on, if it applies at all, must apply only where that relation subsists between a juror and one of the parties. It has nothing to do with this case. It was a novel scene, and one which the law could hardly have contemplated, that a citizen who is called as a juror to try others should himself be put on trial. He should not, however, as he already intimated, go into the argument because the objection was wholly set aside, by the fact not being proved on which alone the objection could be founded. Judge Thatcher, to the triers. I regret the necessity which has rendered it my duty to take the gentlemen from their business to impose an unpleasant burden upon them, but so far as the public justice was concerned, I am happy to have their aid in the important duty of impaneling a jury. The impartiality of juries should always be guarded with a watchful eye. The proceeding is a novel one, and I know of no case in this Commonwealth in which trials have been demanded by a party challenging a juror. The statute points out one mode of testing the impartiality of a juror on his own oath, but it does not exclude the mode plainly laid down by the common law, if the party claims its right to that mode. The defendant's counsel elected that mode to prove the bias of the juror by testimony alla undi, the common law being in force here. The only proper course appeared to be to appoint triers, as is the practice under the common law in New York, and you, gentlemen, were selected for that purpose, no juror having been impaneled. The first witness called did not establish the fact that the juror was a Mason. Mr. Hallett then offered Mr. Sargent, the juror, as a witness, but the court overruled it on the ground that was calling upon him to disparage himself. You have heard a long argument upon the grounds of this challenge. The gentleman disclaimed altogether challenging the juror as being incompetent because he was a Mason, and yet his only objection to him in this case is the bias founded on obligations he is supposed to have taken as a Mason. Is not this saying in one breath what he takes back in the next? But there is no evidence that the juror is a Mason, and if there were, I know of no law that excludes him in this case. The verdict of the triers. An officer was sworn, as in jury trials, to take charge of the triers, who retired to deliberate. They were conducted into court by the officer having been out 2 hours and 20 minutes. The clerk. Have you agreed, gentlemen? Mr. Pickering. We have. We find that Mr. Sargent is not disqualified. The clerk. Gentlemen, the court affirms your verdict. Daniel Sargent, the juror, was then called and sworn. Horace Baker was next called and sworn as a juror. Mr. Parker moved that the triers be now discharged as 2 jurors were impaneled, who must sit as triers if required. The triers were thereupon discharged by the court with thanks for their services, and the clerk was directed to pay their fees. October 14th. The jurors on the panel were called and sworn without objection from either party. They were Daniel Sargent, foreman, Horace Baker, Levi L. Cushing, Thomas Cushing, John H. Osgood, John M. Sexton, William W. Simpson, William T. Thayer, Gardner Tufts, Levi Warren, George Williams, Justin Andrews. The question of embracery. Mr. Parker. The cause now to be submitted to your consideration is one of a novel character in this county, and it is creditable to our citizens that no former indictment for this offense can be found on our records. In other countries, the offense is not novel. It is indictable by the common law, and is also prohibited by English statutes enacted centuries ago. There are also statute laws against it in some of the United States. It is a crime against public justice. It poisons the very fountain of justice. If there be anything valuable in our institutions, it is the trial by jury, a privilege deemed so important as to be secured to every citizen in every case. civil and criminal, by the Constitution of this Commonwealth. But to be of any value, the trial by jury must be carefully guarded from similar influence and corruption. The lives, liberties, property, and reputation of our citizens are protected by juries. All that is dear to us depends for its preservation upon the integrity, intelligence, firmness, and honest decisions of jurors. And I hope one advantage at least will result from this trial: the diffusion of the knowledge among the community of the rights, duties, privileges, and liability to punishment for misconduct of the jurors themselves, and of the enormity of the offense of attempting to corrupt them, all which will probably be discussed before the trial is over. The technical name of this offense is embracery, a term not very well understood out of the courts of law, but very well understood by lawyers, and it may be useful at the opening of this cause to you to give you clear ideas of its nature and criminality, by which you will be enabled to form an opinion whether the conduct of Mr. Clough, the defendant as set forth in the indictment, which I expect fully to prove by the evidence I shall introduce, amounts to the offense and subjects him to your verdict of guilty. I shall forbear, gentlemen, to make any unnecessary allusions in the trial of this cause to any facts or any feelings not belonging to it, and confine myself wholly to the law and the testimony. It seems to be a too fashionable practice of late to introduce into trials many things which do not belong to them, and much time is lost and much of the public money wasted by the excessive duration of trials, the length of which results from the irregularity of introducing foreign matter. The public prosecutor is instructed to save to the community all possible expense, and I have ever confined myself within the closest bounds of duty. I am aware this case is supposed to touch some of those party strings now in motion, and which at the present time agitate the public mind, and are particularly interesting on the eve of the political struggle. But whoever expects that, on the part of this prosecution, any partisan feelings, any political partialities, any private or personal motives are to be indulged, will be much mistaken. I have come here, as I suppose you gentlemen have come, with the single motive of discharging a public duty, a duty each of us owes to the Commonwealth, to all the people of the Commonwealth. We are here to do the solemn business of this court, to investigate a serious and highly important charge presented by the grand jury against this defendant, a heretofore respectable citizen, and always a warm and honest partisan, a trial before this tribunal of justice. We have nothing to do here with politics or parties. We are ministers of the law, whose conduct is to be regulated solely by our oaths and our consciences. We are not allowed to indulge our feelings, our partialities, our antipathies, our prejudices, or our wishes. Justice is impassive. It has no passions. It belongs to no party. It seeks only for truth, and when it finds it, it speaks the truth and the whole truth, and nothing but the truth, whoever it may affect, and administers the law upon that truth, in humble imitation of the deity, without respect of persons. The course I have marked out for myself on this occasion is, first, to read to you the definition of embracery from books of the best authority, both English and American, and secondly, to open the testimony by a concise narrative of the facts I expect to prove in support of the indictment. The authorities I rely upon are these: 4 Black, Com 140. Embracery is an attempt to influence a jury corruptly to one side by promises, persuasions, entreaties, money, entertainments, and the like. 1 Russell, on Crimes 277. Embracery consists in such practices as tend to affect the administration of justice by improperly working on the minds of the jurors. 1 Hawkins' Pleas of the Crown, Chapter 85, Section 1. It seems clear any attempt whatsoever to corrupt or influence or instruct a jury beforehand on any way to incline them to be more favorable to the one side than to the other by money, promises, letter, threats, or persuasions, except only by the strength of the evidence and the arguments of counsel in open court. At the trial of a cause is an act of embracery, whether the jurors give a verdict or not, or whether the verdict be true or false. The law prohibits everything which has the least tendency to corrupt a jury, or influence them otherwise than by evidence and the obligations of conscience. Hawkins, chapter 85, section 7. An offense of this kind subjects the offender to an indictment or action in the same manner as all other kinds of unlawful maintenance due by the common law. Bacon's abridgment, juries M3. Applications of this kind to a juror are to be watched with a very jealous eye. The rank of the applicant may give to them, however cautiously expressed, a commanding influence over the persons to whom they are addressed. In 11 Maud, Rep. 118, Herbert v. Shaw, Powell, Justice, said he remembered a case in the Court of Common Pleas when a stranger wrote to a juryman to consider that the plaintiff was a poor man, for which a new trial was granted and the writer taken up and committed. I cite the following case with the more satisfaction because I was referred to it by the argument of the opposite counsel before the triers. In 4-term Rep. 289, King v. Jolliffe, Lord Kenyon said, publishing the papers in question during the pendency of the cause at the assizes and in the hour of trial is not a minor offense. It is the pride of the Constitution of this country that all causes should be decided by jurors who are chosen in a manner which excludes all possibility of bias, and chosen by ballot in order to prevent any possibility of being tampered with. But if an individual can break down any of those safeguards which the Constitution has so wisely and so cautiously erected, by poisoning the minds of the jury at a time when they are called upon to decide, he will staff the administration of justice in its most vital parts. If the publication be brought home to the defendant, he has been guilty of a crime of the greatest enormity. 1 Borough 510 Rex v. Martha Gray. A libel had been published just before a trial with intention to influence the public and the jury. It was stated by the counsel on one side and consented to by the counsel on the other, that such practices were not only contempt of court and a high misdemeanor, but might invalidate the verdict, and the trial was put off on account of said libel, and the publishers prosecuted. Moore's reports 815, Jepps v. Tonbridge, and Wiseman. A question upon the title to real estate. The tenant caused a letter of instructions to be given to one of the jurors. It was read by one or all of the jurors, and was held in bracery and punishment followed. Noyes reports 102. Plaintiff made a brief of his case and delivered to some of the jurors before their appearance for their instruction, held to be in bracery and the party fined and censured. The King v. Opie, 1 Saunders 301. This was a case of information. Defendants were found guilty. Saunders moved in an arrest. Lord Hale refused to hear him, said he should bring error. Saunders, in his note, says it is an offense which deserves severest punishment, and refers to the English statutes restraining and bracery. American cases, 5-day Connecticut, Grannis v. Broughton. A witness talked freely with the juror about the merits of a case. A motion for a new trial or an arrest was made because the court would not compel the witness to testify to that conversation. He said it would accuse himself and refused. Court said it would. It was embracery, a crime of deep hue, polluting and corrupting the source and foundation of justice, and that it was immaterial whether embracery was committed by persuasion or bribery. Page 274. 5 Cowan 503. Gibbs v. Dewey. The court, after defining the cause of embracery, say a witness has no right to deliver any paper to the jury without the direction of the court. The act is as criminal in a witness as in a bystander. Any attempt by a witness to influence a jury in any other way than by the open delivery of his testimony is improper, and in judgment of law corrupt. In New York, embracery is an offense at common law and by statute. 7 Danes Abridgment 10. Embracery is an offense against public justice and offense at common law. Such being the nature and criminality of the offense of embracery, we are now to consider the facts set forth in this indictment and proceed to the evidence relied upon on the part of the prosecution in support of the charge against the defendant. I shall read to you a record of this court by which it will appear that at last July term there was an issue tried by the jury of trials between the Commonwealth by indictment for a libel upon Mr. Samuel D. Green on one part, and Charles W. Moore and Edward Seffy, printers and publishers of a newspaper called the Masonic Mirror, on the other part. That trial was begun on Saturday of one week and terminated on Saturday of the succeeding week, occupying the court 7 days. The arguments of counsel were closed about 2 o'clock on Friday, the 19th day of July, and the court adjourned to 3:30 in the afternoon, at which time the judge was to deliver his charge to the jury. It will appear by the record that Mr. Nathaniel Frothingham was one of the jurors impaneled to try that issue. Mr. Clough, the defendant in this cause, appeared to feel interested in that trial and attended, I believe, every day. In the course of the trial, he was called as a witness in behalf of the Commonwealth and testified in the cause, and when about to leave the witness's stand, he voluntarily declared with much emphasis, without any interrogatory calling for the declaration, that if he wanted to know whether he was an anti-Mason, he was. Mr. Green was attacked in the libel as an anti-Mason, and his moral character was much blackened in the publication. The witnesses against him were Masons, and some of them persons more or less alluded to in the celebrated Lockport trials in relation to the abduction of William Morgan. The witnesses in favor of Mr. Green were mostly anti-Masons, and the trial took such a course as almost to identify the defendants with the Masonic fraternity, and Mr. Green with the opposite party of anti-Masons, and much party zeal was manifested both by the witnesses and the counsel, and a great deal of contradictory and unreconcilable evidence introduced. I expect it will further appear in evidence that Mr. Clough had for many years been acquainted first with Mr. Frothingham's father, and afterward with Mr. Frothingham himself, that he lived in his neighborhood, that in former times when party spirit ran high between Federalists and Republicans, they belonged to the same political party, and often met together discussing the politics of the day, and that during a large part of the time of the long trial of Moore and Seffy in this hall, Mr. Clough sat in one of the settees within 4 feet of Mr. Frothingham's seat, among the jurors, and in full view of him, so that he must necessarily have seen and known Mr. Frothingham to be on that jury. It will also appear in evidence that Mr. Clough came to court that Friday afternoon, about half an hour before the court opened, that when Mr. Frothingham came into the door, Mr. Clough immediately called to him and gave him a pamphlet, and requested him to read that and let the jurors read it, and that Mr. Frothingham took it and carried it into the jury seat and deposited it in his hat, that the charge was then given by the judge, and when the jury went into their room, Mr. Frothingham carried the pamphlet into the jury room with him. I shall identify that pamphlet and prove it to be the one mentioned in the indictment, and shall read it to you to show you its anti-Masonic tendency and object, and its manifest bearing on the questions and evidence deemed important in that trial. Having proved these facts, nothing will remain but the inquiry for what purpose, with what motive, Mr. Clough selected that time and place to give Mr. Frothingham that pamphlet and why he did give it to him. The motives, intentions, designs of men are not otherwise to be proved than by the evidence of the facts, the words and actions from which they are to be inferred. No one can discover otherwise what another man's motive is. We are obliged to infer from the overt acts and proof circumstances what a man knows, and what his designs are, and prosecutions for passing counterfeit money, knowing it to be forged, or receiving stolen goods, knowing them to be stolen, and in the like offenses depending upon the scienter. We are obliged to infer the guilty intention from facts and circumstances proved at the trial. In the present case, you will have to judge for yourselves from all the evidence that will be submitted to you, under the conscientious responsibility of your own oaths, whether or not Mr. Clough had the intentions imputed to him by this indictment. If he had, he is guilty of the crime of embracery. If he had not, he is no more guilty than if he had given to the juror the New Testament, or a newspaper having no allusions to Masonry, or the cause on trial. I shall now call the witnesses. End of section 77. Section 78 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Ebenezer Clough for Embracery, Boston, Massachusetts, 1833, Part 4. The witnesses for the Commonwealth. John Augustus was in the gallery of the courtroom the day the judge charged the jury in the case of Moore and Sevey before the court was opened. 3 persons, I think, were on the north side of the room. 3 of the jurors were on the other side. Nathaniel Frothingham was one. They were in the jurors' seats. Mr. Clough was sitting on the same side, on the third settee at this end. Jonathan Pierce was with me in the gallery, saw Mr. Clough with a paper in his hand, a pamphlet-like. He offered it to Mr. Frothingham. Mr. Frothingham took the pamphlet with reluctance, and I saw Mr. Clough point with his finger to a particular place. He kept his finger there some time. Mr. F. took it, moved very quick, and put it into his hat which lay on the window. Cross-examined. Mr. Frothingham stepped out of the jury seat, and he and Mr. Clough had some conversation. I could not hear. He had a number of pamphlets of the same appearance. I saw him distribute them, saw him hand one to Mr. Fletcher, did not see Josiah Marshall or Ichabod Macumber. Know them both. Did not see Mr. Clough deliver a pamphlet to anyone before he delivered it to Mr. Frothingham. After the pamphlet was handed to Mr. Frothingham, I saw Mr. Clough hand one to Mr. Fletcher. I did not know Mr. Frothingham at that time, nor whether any of them I saw were jurors. When I saw Mr. Clough deliver the pamphlet to Mr. Fletcher, I did not think it improper. Jonathan Pierce was in the gallery with Augustus before the court came in. Saw Mr. Clough and Frothingham walking about in the courtroom. Saw C hand the paper to F, and Augustus spoke of it. Said he did not think it was right. Did not see Mr. Clough point to any part of the paper. Nothing was said between me and Augustus as to Frothingham being a juror. Mr. Parker read the indictment against Moore and Sevey, and the record in that place. Nathaniel Frothingham, recalled, was one of the jury on the case of Moore and Sevey. Have known E. Clough 47 years. Used to be of the same political party years ago. The pamphlet containing the Dexter letter is the one Mr. Clough gave me in the courtroom. Saw Clough sitting on the front settee. He said he had got something for me. He put both hands into his pockets, then into his hat. He said, "There, take that and read it, and let your friends read it." I immediately turned the paper over, saw what it was, and told him, "Mr. Clough, this comes with an ill grace from you to me." I then took it and put it in my hat and passed it to the jury box. Mr. Clough had been in the court every day of the trial and was sworn as a witness. He knew that I was one of the jury, could not help knowing it. I carried the paper into the jury room. Cross-examined. I do not recollect that Clough pointed out any passage in the pamphlet. I took the paper as an insult from Mr. Clough, I being a Mason, not on account of being a juror. stated in court when I was about to be impaneled as a juror in the case of Moore and Sevey that I was a Mason, had been a Mason 18 or 19 years, had seen the contents of the paper years ago in print. When Mr. Clough gave the pamphlet, he said he forgot that I was a juryman. I had taken the paper and told him it came with an ill grace. Do not say that he did not ask me to return it. Felt excited at the time and was considered it an insult to me as a Mason, not as a juror. Did not object to taking it. Nothing was said relative to the case then on trial. I had a conversation with Mr. Clough at my place of business the day the trial was over. Joseph Leeds was present. Found Mr. Clough at my shop. He said he wanted me to give up the pamphlet, and if it was not given up, Mr. Hallett told him he, Clough, would certainly be put in jail. Told him I might be willing to give up the paper. I looked in my pocket and could not find it. He said he had asked me in court to give him back the paper. I said, yes, you did. I made a statement of the circumstances to Mr. Campbell in the jury room. The court objected to going into the jury room. Mr. Hallett thought he had a right to go anywhere, into a church or a lodge if it was necessary to get at the truth, to clear his client. The place could not govern the legality of the evidence. The court was unwilling to inquire into matters that took place in the jury room. Mr. Hallett claimed the right to use all competent testimony without regard to any place where it happened, but proceeded on another point. Mr. Frothingham. I first mentioned the occurrence to Mr. Allen before I went into the jury room. Did not mention it to the judge at all. The paragraph that was not mentioned by the counsel is the one with the square and compass, calling on Masons to vote for John Brooks. A part of the paper handed to me by Mr. Clough had been read to me by the counsel as a juror in the case of Moore and Sevey. It was read in the argument. Did not know the fact when the paper was handed to me. The merits and demerits of Masonry and anti-Masonry were brought up in the trial. Clough said he wished me to read it and let my friends read it. That was the whole he did say. If he asked me to return it, it must have been at that time and before I put the paper in my hat. Mr. Hallett now insisted upon asking what Mr. Frothingham told Mr. Campbell. The court asked where the conversation took place. Mr. Hallett said he did not inquire where. If it was legal evidence, the place could not make it illegal. The court admitted the question in this form. What did you state to Mr. Campbell took place between you and Mr. Clough when he handed you the pamphlet? Mr. Frothingham. I made the same statement as before when I received the pamphlet, that when I came in, he called me to him and handed me the paper. I did state to Mr. Campbell that Clough asked me to give it back to him when I had turned and was going into the jury seat, before I had put it into my hat. The main question before the jury in the case of Moore and Sevey was the private carriage of S.D. Green. There was contradictory testimony on that point. The witnesses on one side were Masons, and on the other side anti-Masons, and so Masonry and anti-Masonry came up. The foreman. Some of the jury wished to know whether the witness means to say that Mr. Clough told him he had forgotten he was a juror. Mr. Frothingham. Mr. Clough said he wished I would give it back to him as I was turning from him. I did not incline to give it back. At the same time, he stated he had forgotten I was a juror. Then he did say he had forgotten it? Yes. Mr. Parker read to the jury the letter of Samuel Dexter and the call upon Masons which composed the pamphlet handed to the jury by Mr. Clough. Footnote. In the year 1798, Josiah Bartlett, Grand Master of the Massachusetts Grand Lodge, published under his own name in the Mercury and Palladium an attack on the Reverend Dr. Morse of Charlestown for calling the public attention to Professor Robinson's work on the connection of Masonry and Luminism. To this Masonic attack, Honorable Samuel Dexter, the great lawyer and advocate, replied in the following article, the original of which we have seen in his own handwriting. The eagle mind of Mr. Dexter penetrated Masonry at a glance, and the biting ridicule here Exhibit bears the stamp of his sarcastic powers. To the Grand Master of the Grand Lodge of Freemasons of Massachusetts, Sir, as you have twice written to the public in opposition to Professor Robinson and Dr. Morse, and a number of weeks having elapsed since your first favor, according to all the rules of epistolary etiquette, you are by this time entitled to an answer. This burden I have taken upon myself, and shall now give you my opinion and that of most of my informed friends. After having read your publications with some care, I confess I am at some loss to determine their object. Thus much, however, I can discover, that your wish is to prevent the good effect of the publications of those gentlemen respecting Illuminatism, as I fully believe their writings are important warnings to the public, and have a tendency to prevent the evils which that box of Pandora, the French cabinet, is pouring upon the world. I must disapprove of your efforts, though I am not very apprehensive of their success, lest you should complain that my object is as difficult to discover as your own. I tell you explicitly at the outset that my intention is to endeavor to convince you that after the concessions contained in your own publications, you are bound to desist from opposition, or relinquish all claim to the character of a man of probity and candor. In your last, you admit the existence of an order of Illuminatism in the following words. I pretend not to doubt the existence of this order, for there are documents in the professor's books which are satisfactory to render it probable. And you express your abhorrence of their reputed principles and detested practices. For what then are you opposing Professor Robinson? Because, like an honest man, he states and proves the existence of a horrible conspiracy against government, morals, and religion, which you confess does exist, and guards the unwary from being seduced. Why are you opposing Dr. Morse? Because he first recommended this work to the perusal of Americans, and thus prepared them to resist the contagion of Illuminatism, and afterwards defended himself when treated with scurrility for so doing. There can be but one answer to this, and that is that Freemasonry was unjustly attacked, and you merely defended that. This is not fact in any sense in regard to Dr. Morse, for he has never in the least degree implicated Masonry. On the contrary, he said everything that an honest man could say to allay the causeless jealousy of some of the fraternity. Must you, in faithfulness to Masons, oppose the opposer of Illuminatism, after all you have said against it? If so, you are called by a higher authority as a man and as a citizen, and in a voice of thunder to abandon Masonry as an unjustifiable institution. If it be otherwise, let the doctor quietly pursue his professional duties, for the crimes of Illuminatism are all that he condemns. But you have a singular objection against the doctor. Without examining his evidence or his arguments, you complain that he has occupied more than 11 columns in the Mercury. This is a new mode of managing a controversy, to count the columns in successive newspapers, and learnedly publish the aggregate to the world to enable them to appreciate his arguments. But I do not object to this on account of its novelty, for I have a due regard for original genius and useful inventions. And who can doubt the utility of this invention to those who can count better than they can reason? As to Professor Robinson, he expressly acquits the 3 first degrees of Masonry of the charge of criminality, and you have told us that these are all that exist in this country. At least there are no others under your protection. You say expressly, I pretend to know regular information beyond what the learned professor calls simple Freemasonry. Will you undertake to say that the higher orders of which you confess yourself ignorant cannot be corrupt? Will you oppose this naked assertion, confessedly founded in ignorance, to the talents and integrity of Professor Robinson, which you have explicitly acknowledged, and to the testimony which he produces? Though among the unenlightened in Masonry, on this subject I have equal information with all the most worshipful of your fraternity, and throwing out of the question such respectable authority and evidence as the name and documents of the professor. Let me ask you whether it be incredible that these workers of mischief, who are turning the world upside down, should avail themselves of the secrecy of Masonry to cover their conspiracy and the general diffusion of it through all civilized countries, to inculcate their poison. And may I not add that the principle of levelism, which enters deeply into Masonry, will comport with the hypocrisy of French despotism? Will you say, sir, that Masonry is incapable of being abused? In saying this, you say that it is contemptible. If it possesses any character, any force or efficiency, it may be applied to produce mischief. Witness the modern abuse of misapplication of the principles of civil liberty and philosophy. But I see the cause of your quarrel with the professor. He is a Mason, and publicly confesses that Masonry is a frivolous institution. A deadly wound, this, to the vanity of a man who hoped to derive some importance from being at the head of it in Massachusetts. If this be a mistake respecting the merits of Masonry, and contrary to all rules of evidence, a man is not to be believed when he testifies against himself, yet remembers that it does not render it proper for you to attempt from resentment to prevent the good effect of his publication, to obstruct him in the opposing vice and guarding innocence against contamination. But as a misrepresentation here might impair the public confidence in the professor and prevent the complete good effect of his book, let me, for a moment, examine whether there be not every reason for believing the charge true. I will first consider what is known publicly of the institution, then hazard some conjectures as to what is said to be unknown. The world knows that Masons have most windy titles, such as most worshipful, etc., etc., etc. It is known that their vanity prompts them to walk in formal procession, covered with trinkets that a well-informed savage would blush to wear. It is well known that they have many symbolic figures which were highly useful before men could read or write, and therefore probably are yet convenient to many of the brethren. It is known that with all these trinkets and symbols they follow the remains of a brother, looking as wise as the bird of wisdom, which no doubt greatly comforts the ghost of the departed. It is known that on certain days they meet together and eat plentifully, and if fame does not slander them, drink so too. But is it known that they have merely as Masons one object of useful pursuit? Other societies are formed for promoting arts and sciences, agriculture, navigation, humanity, religion, etc. But this society, though claiming existence, if I am not misinformed by the brethren, for centuries before creation, and extended through almost all nations, has never yet produced any known good to the world. But we are told all this is answered by the claim of inviolable secrecy. Strange society that blazons its follies to the world, but buries its virtues in midnight darkness. But, sir, you have no secrets, but mere ceremonies. I say this on the testimony of most respectable men who are Masons. I say it on your own testimony. And can secret ceremonies save the institution from the charge of frivolity? Can you, by accumulating in secret more baubles and more follies, excuse yourselves from the gewgaws and trumpery which are seen? I need not rest this denial of important secrets on testimony. The nature of the thing is stronger proof than witnesses can give. Amongst the weak and unprincipled, the intemperate, the offended, the revengeful Masons, which successive ages have produced in all nations and of all colors, it is impossible that any such secret should have been kept. And if this could be supposed, such a secret must be important to all men if important to any, and the withholding of it would be an instance of misanthropy, disgraceful to the institution. I know it has been said that the sublime principles of the unity of deity and moral philosophy are involved in Masonry, but these are principles which at this time are peculiar to no society. In these respects all the civilized world are now Illuminati. On these subjects, the blaze of light has obscured the twinkling of masonry, and this claim of merit, on that ground, reminds us of a part of their own ritual in which they burn candles to enlighten the meridian sun. As this ritual is said to be typical, perhaps this is the very thing intended to be symbolically represented. In short, sir, if there be no very important reason for upholding masonry at a moment like the present, there is a reason against it. The system of the destroyers of human virtue and happiness is to undermine in the dark the castle that cannot be carried by storm. Secret agency has overthrown all the republics of Europe, and an extended secret leveling self-created society, without any valuable object of pursuit, and embracing bad characters as well as good, cannot be the subject of approbation of an anxious patriot. The good man's fears will be still further excited in this day of dark intrigue, when all the fallen nations have first been secretly corrupted and prepared for destruction, by beholding an effect on this subject for which he can assign no adequate cause. Wonderful is the present revival and spread of masonry, and invisible is the cause that produces it. The public papers have informed us of new lodges instituted, or about to be instituted in Norton, Franklin, Concord, Reading, Watertown, Oxford, Brookfield, and several other towns in this Commonwealth. I have no apprehension that these lodges can become corrupt en masse, but they afford opportunity for selecting abandoned individuals to mislead the simple. They secure from public detection attempts at enlisting individuals in conspiracy, though such individuals should be incapable of being seduced. Thus, sir, I have done what Dr. Morse never did. I have ventured to call in question the utility of masonry. Perhaps I may be ranked with the professor in this respect and be charged with being an illiterate enthusiast. Though innocent of the charge, I shall be proud of my company. But at least the doctor, who has given no such offense, ought to be suffered quietly to enjoy the approbation of the wise and good, and of his own conscience for his able vindication of himself and the professor, without being disturbed by those who profess attachment to government and morals. One further remark appears necessary to prevent misconception or misrepresentation. Though I cannot, without further information, respect masonry, yet I highly respect many who have been initiated, and who are amongst my most valued friends. But it is a fact, unless all my experience deceives me, that the masons who are most respectable as men are the least attached to masonry. Such men daily take occasion to excuse themselves from bearing any part of the apparent frivolity of the institution, and speak of it in the same terms with Robinson. On the contrary, those who are very busy about masonry are generally men of light and frivolous minds, dazzled by tinsel, and having no substantial ground for public respect, wish, by unfounded pretenses, to impose on the ignorant, and excite the wondering stare of stupidity. S.D. In the year 1816, it so happened that this Samuel Dexter was the Republican candidate for governor, and run against the Honorable John Brooks, the Federal candidate. A few days before the election, Major Benjamin Russell, then Grand Master of the Grand Lodge, came out in the Sentinel with the following Masonic proclamation, and Brother John Brooks was elected by a small majority. From the Boston Sentinel, edited by the Grand Master of the Grand Lodge, to the Masonic fraternity. Brethren, it need not be repeated that the internal regulations of your benevolent order exclude all discussions of political dogmas, but every master knows that his public obligation compels him to discharge the duties he owes to the state with diligence and fidelity. When two candidates, therefore, present themselves for his suffrage, he is not bound to inquire to what party the one or the other belongs, but whether he is a good man and true, and faithful to the Constitution which he may be called upon to administer, and all other things being favorable, he is bound by every Masonic obligation to give his vote for the one who is a free and accepted brother, in preference to the one who is not. Brother John Brooks shall receive the vote of a master mason. End of footnote. The defense. Mr. Hallett was gratified to be able to say to the jury that in this case there would be but little controversy between himself and the learned counsel for the government as to either the law or the facts. The whole question for the jury to decide would turn upon the application of the facts to the law, and whether the law as laid down for the prosecution really existed in such form as to be at all applicable to the facts in this case. The acts and motive of the defendant were the main question for the jury. The counsel on the other side had relieved him from the necessity of reading most of the authorities which he had consulted as to the nature of the offense charged, by anticipating those authorities, and it gave him great pleasure to add that the felicitous manner in which that gentleman conducted a public prosecution, with as just a regard to the rights and feelings of the defendant and his counsel as to his public duties, also relieved him from a much more unpleasant task, that of engaging in that kind of personal controversy, which was but too common in the management of causes before a jury. The offense charged was a novel one, derived from no statute or no practice in this commonwealth, and the jury must look carefully to the definitions of it before they brought this case under them. He should contend first as to the law, that it was at best a matter of some doubt whether the offense as described in the indictment existed at all, or was punishable by law in this commonwealth. Second, that if it did exist, there could no more be constructive embracery than constructive treason, and that some overt, direct, palpable act must be shown, which act must be a corrupt delivery of money or a written paper, having direct reference to the cause and plainly intended to influence the juror. If any other act could come under the definition, it must be direct instructions, threats, solicitations, or promises. On this point only did he differ from the law, as laid down by the attorney for the government. Its application was not so general as that gentleman contended for. Third, that the paper delivered to the juror was a matter of long previous notoriety, having no direct reference to the case, and fourth, that there was an entire absence of the motive indispensable to constitute this defense. The doctrine of embracery had a bad parentage, for it originated in an odious tribunal known as the Star Chamber in the time of Henry VIII, etc. The first case appeared to be the one cited in Sir Francis Moore's reports, printed in 1663 in black letter, page 815. In that case, the court held that for any one but a party to solicit a juror to appear was maintenance, and for the party or anyone else to instruct the jury by writing or parole, or to promise them a reward if they would appear, was embracery. This must be the same case, cited by the attorney for the state from Noy 102. In that case, the juror was punished, as he should have been in this. The distinction between maintenance and embracery was so slight that no point would be made of that in the defense. Lord Coke's definition is this: when one laboureth the jury, if it be put to appear, or if he instruct them, or put them in fear, or the like, he is a maintainer, and he is in law called an embracer, and an action of maintenance lieth against him, and if he take money, a dicis tantum may be brought against him, and whether the jury pass for his side or no, or give any verdict at all, shall he be punished as a maintainer or embracer, either at the suit of the king or party. 2 Coke's Instit 369a. So Hawkins 2 411 describes the acts constituting embracery, any attempt whatsoever to corrupt or influence or instruct a jury by money, promises, letters, threats, or persuasions. Blackstone, Volume 4, 140 says, by promises, persuasions, entreaties, money, entertainments, and the like. 2 Russell 277 and 4 Bacon 598 are all the same. These are the English definitions. No case of a trial for embracery in this country has been found. The best definition is in 5 Cal 503. An attempt by either party or a stranger to corrupt or influence a jury, or to incline them to favor one side by gifts or promises, threats or persuasions, etc. And in 13 Mass. Rep. 218, it is laid down that embracery is where one laboreth the jury or instructs them or puts them in fear. In that case, a party interested had solicited a juror to find a verdict for one side, telling him he should have to pay the cost if it went the other way. These facts came out in court, and the verdict was set aside, but no one dreamed of an indictment for embracery. That discovery was left for the present grand jury of this court. Our fathers, though they brought the common law with them, did not adopt the Star Chamber doctrine of embracery, but on the contrary they decreed by an ordinance of the colony that, whenever any jurors were not clear in their judgments of conscience concerning any case wherein they were to give their verdict, they should have liberty to advise with any man they should think fit to resolve or direct them, before they should give in their verdict. 2 Ancient Charters 145. This was going rather too far, but it might fairly raise a doubt whether by this act the common law of embracery was not done away, and therefore cannot exist here, because it has never been revived in practice or by statute. Under these authorities, and all that had been read on the other side, he should hold the jury, upon their oaths to decide according to the law, strictly to the definition of embracery as implying direct practices of influencing a jury corruptly, either by giving or promising money, or menacing them or persuading them how to give a verdict, or instructing them in the cause beforehand. The facts in this case would show that the act of the defendant did not come anywhere within the limits of this offense. Mr. Hallett said he had a number of authorities to show that the behavior of the juror, Mr. Frothingham, in receiving the paper was extremely reprehensible. It should be understood that this offense, if it be one, is not all on one side, and the juror who takes is even more culpable than he who gives. But that consideration did not properly enter into this case, and he would proceed to call the evidence. End of section 78. Section 79 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Ebenezer Clough for Embracery. Boston, Massachusetts, 1833, Part 5. Major Benjamin Russell was editor and proprietor of the Boston Sentinel in 1816. As to the pamphlet handed to Mr. Clough with the address to the Masonic Fraternity, I never saw that paper before. A file of the Sentinel for 1816 was shown him, and his attention called to the paper of March 30th, 1816. On the first page of this paper is a large ship called the Massachusetts. Beside it, in double columns, is the federal nominations for the ensuing election in April, 2 days after. John Brooks for governor, etc. Directly under the ticket, and as if composing an address to the people to accompany it, appears very conspicuously the address to the Masonic Fraternity. This is the same as that printed in the pamphlet with Mr. Dexter's letter, with the exception of one word, obligates instead of compels. In this sentence, every Mason knows that his public obligation obligates him to discharge the duties he owes to the state. I did not write that. I unquestionably saw it. I recollect that it appeared. It was an electioneering article, written, I suppose, by my printer who was a master mason. I was Grand Master then. Presume I saw it at the time. Did not disclaim it in any subsequent paper. Presume it was written in retaliation of some other article. It was circulated generally and approved. I am proud of it. It is Bible doctrine, all other things being equal, to prefer a brother, and I am a little surprised that should have been brought against us. Considering the times, I think it was one of the fairest things that appeared. Mr. Hallett, was there an election pending, and was Samuel Dexter candidate for governor? Major Russell, there was an election, and it was a glorious triumph, too. I remember it well. Mr. Hallett, that address to the Masonic fraternity helped, no doubt. Major Russell, I hope it did, and hope it will again. Josiah Marshall was in the courthouse at the time referred to in the indictment. Saw Mr. Clough distributing papers, the Dexter letter, in the courtroom to several persons. He handed one to me and another to Mr. Macumber. My curiosity was excited by seeing him give one to a person I supposed to be a juror, and I asked what it was, and he handed me one. Saw no pointing to a passage. Ichabod Macumber saw Mr. Clough handing papers round to several. He handed one to Mr. Fletcher, Moore and Sevy's counsel. Mr. Fletcher said he did not care to take it. He had read it 20 years ago. He delivered it to me without any request on my part. Thomas Barnes. Have seen some thousands of this pamphlet, which were printed for circulation in 1830, and have had a great number in my hands within a year, and have distributed many copies. Many were circulated at the laying of the cornerstone of the Masonic Temple in this city. There are a great many anti-Masonic tracts, which are circulated gratuitously. The object is to give information on the subject of Masonry. Mr. Clough has often been employed to distribute those tracts. The Dexter letter was published in the Free Press in 1830. Joseph Leeds, on the day the court rose after the Moore and Sevy trial, was in Mr. Frothingham's paint shop. Mr. Clough was there. I asked Mr. Frothingham if he, Clough, did not ask him to give back the Dexter letter when he handed it to him in the courtroom. Mr. Frothingham said he did. Mr. Clough asked him why he did not let him have it. Frothingham replied, it was best known to himself why he did not. I heard nothing of going to jail or Mr. Hallett's advice. I might not have heard the whole conversation. Jeremiah Campbell was one of the jury in the trial of Moore and Sevy. Frothingham had a conversation with me respecting Mr. Clough's handing him the Dexter letter. The court. Was it in the jury room? It was. Mr. Hallett hoped he should be not prevented from bringing out all the evidence in the defense. The court asked what the object of the question was. Mr. Hallett replied, to show the conversations the witness Frothingham had with others at the time. The court, was the object to contradict that witness? Mr. Hallett said his object was to get at all the conversations on this subject, and the jury must judge whether it confirmed or contradicted the witness. He protested against being precluded from defending his client by any imaginary sanctity or secrecy attached to a jury room or any other place. Suppose a murder was committed in a jury room. Would the court exclude the testimony and suffer a man to be unjustly convicted for want of it? The court. The fact was sufficiently established that Mr. Clough did ask F. to return the pamphlet. Mr. Hallett said he meant to make it stronger and go a little farther. The court admitted the question, and the witness replied, Mr. Frothingham told me when he went into the jury room that Mr. Clough gave him the paper, which he showed there, that Clough, when he gave it to him, asked him to give it back, that he, Frothingham, refused, and said to Mr. Clough, I have caught you. I have caught you. Mr. Hallett, that is what I wanted to bring out, to show the spite of the juror. John Adams was printer of the Free Press in 1830. The Dexter letter was then published in that paper. It was also republished in the form he has shown, and 10,000 copies struck off for gratuitous distribution. Mr. Hallett, I think, gentlemen of the jury, that I might with safety to my client lay this case with you upon the law and the evidence, without adding one word. But the human mind is so strangely constituted, and is governed by so many different influences in the process of arriving at conclusions from the same premises that we can scarcely trust to our own convictions, much less can we judge of the convictions of others by our own. With the same facts before them, men come to exactly opposite conclusions. It is my duty, therefore, to take nothing for granted but to urge upon you all the considerations of importance which this case offers to compel you, upon your oaths, to decide according to law and evidence to acquit the defendant. I think I may fairly require it at your hands, as a duty you owe to him, to yourselves, and to the public justice. I beg you, gentlemen, for the sake of your own consciences, to be cautious how you suffer any course that has been taken in impaneling you as a jury, to prejudice you against my client. Even should any of you have been displeased by the challenge of one of your number, remember that displeasure will be no justification for a violation of your oath. Whatever wrong you may imagine others have done, it furnishes no excuse for you to do wrong. You have witnessed nothing in this trial but the exercise of a plain legal right to secure an impartial jury, a right deemed of vital importance in the administration of justice by a large portion of the community. I am happy in believing that from the manner in which this jury is constituted, my client has nothing to fear from that source. The question, and the only question for you to decide, is whether the defendant is guilty of this novel and almost imaginary offense with which he stands charged. I caution you against establishing a new crime and a new punishment in our code of laws. The common law is the sound rule of justice in most cases when applied to civil matters, but it is not fitted to the genius of our free government as an interpreter of crimes. It is a bloody minister of justice, and it stands recorded as a disgrace to the British Criminal Code that the catalogue of offences for which a citizen may be tried and punished is almost unlimited. At the same time, it is honourable to our institutions that so few acts which a citizen can commit subject him to a charge for crime. Surely, then, you will not, on light pretences, add a constructive offence to our code, especially where its utility is so extremely questionable as in this case. Guard the purity and impartiality of juries as strictly as you please, but do not undervalue the general good sense and intelligence of juries by supposing that they have no capacity or integrity to protect themselves, and that the law must interpose on every slight pretense of an imaginary attempt to influence them, and punish the stranger, while the juror himself is suffered to go unrebuked. Such must be the inevitable consequence should you, by any unforeseen process of reasoning, be brought to find a verdict of guilty in this case. The juror is a sworn officer of the court, and to him we must look for the responsibility of his acts. If he suffers himself to be tampered with, I think, therefore, that it should be the policy of the law to hold the juror accountable, and to resort to a punishment of those who may approach him only in plain, palpable cases of an attempt to corrupt influence and bribery. If there has been any offense at all committed in this case, it is the juror, and not the defendant, who ought to be on trial before you. What then is the offense which must be proved to have been committed before you can find a verdict of guilty? Has any real offense been committed? For after all, it will be much safer in a matter of so much doubt as this respecting there being any crime to commit, to look at the common sense of the case, instead of puzzling ourselves with loose definitions in old law books. What has been done, gentlemen, to cause this formal indictment by a grand jury, the arraignment of the defendant, and all the ceremony of a solemn trial, as if some mighty crime had been committed? Why, that venerable citizen there, honest, warm-hearted in every cause he espouses, accidentally handed to a man he had forgotten was a juror, and when the court was not in session, a printed letter which had been in existence 40 years, and an extract from a newspaper published 17 years ago. documents that had been circulated years before, all over the country, and of which hardly any man in the community who knows how to read could be ignorant. And no sooner was it handed than it was asked for back, the moment it occurred to him not that he had committed an offense, but that he might be doing what was not altogether proper. Follow out the evidence as it has been forced from the reluctant witness, the juror who was so sensitive about his honor, and instead of finding a crime, it is difficult to detect even an indiscretion. I did think myself at first that there might have been an indiscretion in the act, though I gave no such advice to the defendant, as the witness represents him to have stated. But the confessions drawn from the juror who took the pamphlet, confessions forced from him, it would seem, only after he had found there were two witnesses to testify to his admissions that Mr. Clough had forgotten he was a juror. These confessions and all the facts in the case do not leave even a charge of indiscretion against my client, nor has the slightest impediment been placed in the way of justice. It has rolled on as majestically and steadily as if this little pebble had never disturbed its surface. Instead of inclining the jury to decide as Mr. Clough is supposed to have sought to influence him to do, the juror seems to have availed himself of it to bring about an opposite verdict. I admit that in point of law it is immaterial whether the juror was influenced or not, to constitute the offense of embracery. But it is material that there should have been some more weighty grounds than any of the evidence discloses to warrant this arraignment of a citizen as a criminal, who has lived nearly to the age of 70 years, without a stain or a reproach upon his integrity. It is no small matter for a citizen to be thus lightly subjected to the public odium of an indictment, under pretense of vindicating the public justice, when it turns out that not the public justice, but individual rights and feelings have been wronged by this proceeding. The citizens have a right to be protected against such causeless prosecutions for mere imaginary offenses, of the existence of which not 1 in 10,000 out of the legal profession had any conception. I know the maxim is that ignorance of the law excuses no man, but that ignorance must apply to a law which has been properly promulgated, and which the citizens have the means of knowing. One of the Roman emperors was famed for posting up his laws so high that the people could not read them, and then punishing them upon this maxim: ignorantias legus neminem excusat. This law of embracery is pretty much the same kind of a law. It has been buried up in the old law books, and after remaining disused in this commonwealth for centuries, it is now dug up to charge my client with an offense he never dreamed of committing. And for this cause, he finds himself arraigned before you. If one of you had risen in your sleep and assaulted a man, and the next morning woke up and found yourself put on trial for the offense, would you deem it just that you should be held accountable for such an act? And yet, in point of motive, you would have been as guilty in that case as the defendant is in this. I protest, gentlemen, in behalf of every citizen of this community, against the irresponsible and causeless manner in which that respectable and aged citizen had been dragged here on such slight pretense and arraigned before you as if he were a criminal. I attach no imputation whatever to the Commonwealth's attorney. The grand jury, I am sorry to learn, find their bills at their own suggestion, or at the suggestion of others, and he but perform his duty as the prosecuting officer. It was reserved to the present grand jury of this court to establish the dangerous practice of indicting citizens upon the anonymous communications of secret malicious informers. It has been stated to you in the course of this trial that Mr. Clough was indicted in consequence of an anonymous writing sent into the grand jury room without their knowing whence it came. Upon this malicious representation, doubtless of some political or personal enemy, the grand jury proceeded to call the witnesses pointed out by the secret informer, all on one side, with no opportunity allowed to the defendant to save himself from the mortification and expense of a public indictment, and the first knowledge he has of the secret proceedings of his enemies against him is a summons from an officer to appear and answer to a charge for having committed a newly discovered crime, which he and scarce anyone else in the community ever before heard of as being a crime. Such a course of proceeding cannot be congenial to our free institutions, to a government of laws. What man is safe from disgrace if, upon the anonymous representation of a secret enemy, backed by one or more malicious or corrupt witnesses, he can be privately denounced to a secret tribunal like the grand jury, and the first knowledge he has of a suspicion of guilt against him is a summons to answer to an indictment. True, he can defend himself. He may be acquitted. But is it nothing to be indicted on a charge of violating the laws? Are experiments upon the feelings and characters of citizens to be tried in this way, at the suggestion of every malicious informer? No, gentlemen, such is not the true spirit of the institution of a grand jury, and I appeal to you to do what you can by your verdict in this case, to rebuke this new system of secret information, which has crept into our administration of justice, and which seems to be directed against a particular class of citizens. The history of Venice, which once professed to be a republic, contains an illustration of this mode of anonymous prosecution, which appears to me not a little applicable to this case. A secret tribunal there had their lion's mouths by receiving anonymous charges. Through this medium, whoever was prompted to denounce any man could gratify his malice, and the unsuspecting citizen suddenly found himself under arrest as a criminal. Gentlemen of the jury, we live in a free country. Let us see to it that no lions' mouths are erected here. Footnote. Moore, in his travels in Italy, describes this contrivance of the Council of Ten. The Ducal Palace at Venice is an immense building entirely of marble. Under the porticos you may perceive the gaping mouths of lions to receive anonymous letters, information of treasonable practices, and accusations of magistrates for abuses in office. The same writer adds, while you admire the strength of a constitution which has stood firm for so many ages, you are appalled at the sight of the lions' mouths, gaping for accusations, where innocence seems exposed to the hidden attacks of malice. John Adams, in his defense of the Constitution, page 66, speaking of aristocratic republics, alludes to this mode of anonymous accusation as destructive in a free government. In Venice, he says the lions' mouths and the inquisitors were engrafted on the Council of Ten. This terrible tribunal was sovereign in all crimes against the state. 3 chiefs were appointed monthly by lot to open all anonymous letters found in the lions' mouths, seize the accused, take examination, and prosecute the prisoner. End of footnote. But the main question for the jury in this case is the acts and motives of the defendant. Without a direct, palpable, corrupt motive, you cannot find the offense charged in the motive you attempt to infer. Must be the only possible motive that can be inferred from the acts. You have nothing to do with suppositions or hypotheses. If you doubt that the motive was corrupt, you must acquit. For in this case, above all others, the motive is the essence of the offense. In a charge of homicide, the motive qualifies the crime, so that the act of killing does not constitute murder, unless the party had murder in his heart. In the offense of embracery, the motive cannot qualify the act. It either establishes or destroys it, but without the motive to corruptly influence the juror, the act is nothing. Look at the indictment. See in what round terms the defendant is charged here. Wickedly and unlawfully intending and devising to hinder a just and lawful trial. Unlawfully, wickedly, and unjustly did corruptly move, desire, solicit, and persuade. Did unlawfully, unjustly, and corruptly give and deliver with the unlawful intention aforesaid. This is the charge, and it is all made out of the little facts that a printed letter of Samuel Dexter, which was 40 years old and had been distributed all over the country, was accidentally put into the hands of a juror, out of court, by a citizen advanced in life who had forgotten it the moment that the person was a juror, attempted to take it back the moment that fact occurred to him, and who had no suspicion that it could be transformed into an offense, a letter which had no direct reference to the cause on trial, other than a general dissertation on Freemasonry and Illuminatism, accompanied with a Masonic address from an old sentinel, exhorting the Masons to vote for Brother John Brooks. These are the facts, and out of these trifling circumstances has grown this public parade of a trial, and the attendant trouble and expense to the state, with the causeless injury done to the feelings of the defendant. Had the principal witness for the government, who prevaricated so much on this trial, told the whole truth at first, I cannot believe this indictment would have ever been heard of. There is a fatal variance between his testimony here and the indictment, which is sufficient to destroy all the grounds of the prosecution. The indictment alleges that the defendant asked the juror to read the letter and to let others of the jurors read it. This furnished some pretense to apply the delivery to the case on trial, but the witness, if he stated so to the grand jury, does not come up to the mark here. He now tells you the request was to read it and let his friends read it, meaning anybody. It surely did not apply to that jury, for it is certain there was not much friendship among them. Were citizens to be held to such strict construction as this in their innocent intercourse with jurors, out of their seats? As well might a carrier who should lead the morning advocate at the door of a juror be indicted for embracery, as this defendant. His Honor the Judge on one occasion delivered the book of statutes to a jury by their request. He unquestionably did right, but if this is embracery, that was. On Monday, while the sworn triers were hearing the evidence upon the challenge of one of your number, you saw a member of the bar go up and address them. He forgot they were triers, and so far in the same capacity as jurors. Was that embracery? I think, gentlemen, that an anonymous letter with as willing a witness as the juror in this case might trump up an indictment out of that transaction. The lion's mouth might do it. Mr. Halliday went into an examination of the testimony. He alluded to the self-contradiction of Mr. Augustus, who swore he thought it improper for Clough to deliver the pamphlet, though he then knew nothing about Frothingham being a juror. He pointed out the prevarication of Frothingham in withholding the most material fact and finally disclosing it, when compelled to do so, and inferred from this and his exclamation, I have got you, a malicious disposition to injure Mr. Clough. This fact and others also proved the terms on which the defendant and Frothingham stood. That Mr. Clough knew him to be a bigoted Mason, and being himself a man of good common sense, it followed that Frothingham was the last man on the jury the defendant would have attempted to influence by giving him a pamphlet against Masonry. But the only tendency of the Dexter letter was to make anti-Masons, and admitting the defendant's design was to make an anti-Mason of Mr. Frothingham. It did not follow that could have influenced his verdict, because anti-Masons on that jury consented to a verdict in favor of Masons. The whole act, therefore, admitting all that was alleged, amounted to nothing more than an attempt to make an anti-Masonic convert by Mr. Dexter's letter. The counsel trusted the jury would not hastily make this a crime, because if they did, the grand juries and courts would be able to do no other business than to try anti-Masons for attempting to make their fellow citizens despise Masonry. He should certainly claim the honor of coming in for his share of this new crime. In conclusion, gentlemen, I caution you against mistaking the gratification of private malice for a vindication of public justice. There is no possible good that can arise from fining or imprisoning a venerable citizen on such pretenses as these. A man whose life has been marked for honesty and warm-hearted zeal in the cause of equal rights, and who, after serving the public faithfully for 17 years in the customs of this city, has earned an honorable poverty by giving up his bread rather than surrender his principles to secure the favor of men in power. Gentlemen, I will detain you no longer. My client is safe in your hands. End of section 79. Section 80 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Ebenezer Clough for Embracery, Boston, Massachusetts, 1833, Part 6. Mr. Parker, gentlemen, although the evening has commenced and we are to surrender this courtroom within an hour to some other assembly, I have deemed it proper not to avail myself of the liberty of the court to postpone my address to you until tomorrow, as it is by some thought to be a disadvantage to a defendant to let the arguments of his counsel take the hazard of being forgotten overnight, while those on the part of the government after an adjournment are pressed on, a jury fresh and vivid in the morning, just before they retire to deliberate on a verdict. And I am happy to think that my duty will not require me to detain you long, by the few remarks I intend to submit to your consideration. Notwithstanding the long and elaborate argument which you have just heard from the defendant's zealous counsel, I shall occupy half the length of time he has taken, because it will be wholly unnecessary. I consider the case a very simple one for your decision, there being no dispute about the principal facts, no difficulty as to the law, and no discrepancy in the testimony. But before I proceed to the consideration of the merits of the cause, I beg leave to notice what has fallen from the gentleman about the lions' mouths in Venice, as it implies an unjust imputation upon the administration of justice in this commonwealth. That invention was an instrument of tyranny and cruelty, and bears no analogy to the institution of a criminal prosecution by the grand jury. It is true that the grand inquest too often proceed on anonymous communications, but never unless such communications point out the sources of lawful evidence, and they make no presentment until known witnesses openly appear and give oath and testimony before them. The form of a grand jury's oath, as prescribed in the statute, is the guide to his duty, and he is diligent inquiry of offenses, as well as true presentment to make. Anything that comes to his knowledge in relation to crimes, from whatever source it comes, is to be considered, and if sufficient evidence can be found, the grand jury must proceed. But there is that regard to duty, that consideration of the rights of the persons accused, that intelligence, discrimination, and sense of probity and justice, prevailing always in some or all of the citizens who compose from time to time the grand inquest, that frivolous, unfounded, malicious, or unjustifiable presentments are rarely or never made. It is true persons are not unfrequently found not guilty by the jury of trials of the charges presented in indictments, but this is because the grand jury are obliged to proceed ex parte. They hear but one side, no explanations, evidence on the part of the accused, and do not undertake finally to settle the question of guilt, but only determine whether evidence enough, or probable cause enough, appears to convince them that public justice requires the party accused to be put on trial. Besides, when they do make a presentment, is informally made, the offense clearly, precisely stated. The accused has notice of it. He is called upon to make his answer, consulted as to the time when he will be ready for trial, and every facility and fairness extended to him to enable him to make his defense. Do these proceedings resemble the lions' mouths, the practices of the Inquisition, the Venetian cruelty and injustice? In no particular, and you will not suffer yourselves to be prejudiced and misled by the gentleman's oratory or historical allusions. You will not favor this defendant upon any supposition that the indictment against him and his trial bear any analogy to proceedings which animated in dark ages out of the lions' mouths. I will also notice, before I go to the merits of this case, some statements of the defendant's counsel in relation to the law concerning embracery in this commonwealth, to which I cannot consent, and which may have a tendency to produce an improper impression on you. He is referred to case argued and determined in the Supreme Court of this state, and reported in the Book of Authority. In that case, which was a civil action, the court set aside the verdict and granted a new trial, because one of the parties unlawfully and privately practiced upon and labored one of the jury, which was fully proved in open court, and yet that party was not prosecuted for embracery. Therefore, argues the gentleman, in this commonwealth such conduct in a party is not an indictable offense. It was known to the court, and the opposite party had proof of the fact, and yet no indictment. Therefore, it must have been the opinion of the highest tribunal in this state that such conduct is not indictable here. This argument proceeds upon several fallacies. First, that every known crime is prosecuted, which is far from being the case. And second, that nothing is a crime which is proved before the Supreme Court, and happens not to be indicted. In the trial of civil causes, the prosecuting officer is seldom there, unless engaged as counsel by one of the parties. If there, it is not his duty to make a complaint to the grand jury. He is not a grand jury to make inquiry after crimes. His business begins after a grand jury have ordered a bill drawn. And when in a civil suit, misconduct is proved in court, it is not the practice of the judges to send for the prosecuting officer and call his attention to the offense, nor do they make any official communication to the grand jury. Now, if the gentleman's argument proves anything, it proves too much. He certainly will not pretend that adultery is not a crime in this commonwealth, and yet not a term of the Supreme Court passes without some divorces being decreed for the cause of adultery, and still the adulterer and adulteress commonly remain unindicted. Of course, if his argument is sound, then he has proved that adultery is no crime and is not an indictable offense in this state. There was another inaccuracy in matters of law in the gentleman's argument. He urged upon you that there was a fatal variance between the allegation in the indictment and the proof in this particular. The indictment states that Mr. Clough solicited Mr. Frothingham to read the printed paper and let others of the jury read it, whereas the evidence proved the solicitation to have been to let his friend read it. Now, if there is any variation, still it is immaterial. To embrace one of the jury is as certain an offense as to embrace them all. It is an equal crime. The intention was to influence the jury by irregular means. The manner was immaterial, whether by subjecting the paper to the eyes and understanding of each juror, or by communicating the ideas and arguments which were on the paper to the minds of the other jurors through their ears by the statement of one or more who had read it. Besides, Mr. Frothingham testified there was one other Mason beside him on that jury. Mr. Clough probably knew it, and he was the friend alluded to by Mr. Clough. By the law, therefore, there is no difficulty established in this particular, but I am not quite certain whether Mr. Frothingham said friend or friends in the plural. If friends, then doubtless all the other jurors were intended by that expression. In point of law, this supposed variance is a matter of no importance. I shall trouble you, gentlemen, with no further remarks on the law. The authorities I have read must have made you sufficiently acquainted with the nature of the offense, and the passage in Mr. Dane's abridgment, as well as common sense, must convince you that in this commonwealth, as in every other civilized community, such conduct as is imputed in the indictment to Mr. Clough must be criminal and indictable. Every overt act alleged in the indictment being proved, your principal duty will be to satisfy yourselves what was Mr. Clough's motive and intention in giving Mr. Frothingham that paper. The case turns on this point. To ascertain it, there are many circumstances which clearly indicate it, and I will call your attention to them. You must derive your knowledge from this circumstantial evidence, which often is the most satisfactory to the mind, that is found in judicial trials. First, what is the tendency of the pamphlet delivered to the juror, accompanied with the urgent call to read it? It is an essay upon the follies and dangers of Freemasonry. What was against that institution was supposed to favor Mr. Green's character and credit, and support his side of the cause, and also to disparage Moore and Sevey, and thus operate upon and influence the jurors. Had the pamphlet that tendency? Most manifestly. It is apparent on the paper itself, which is written with talent, strong common sense, much biting sarcasm, and happily expressed ridicule, and sent forth into the world by an author of great celebrity and influence. You cannot doubt the tendency of that paper. If any additional proof was necessary, you have it in the fact proved here, that in the trial Mr. Hallett, who did the Commonwealth the favor of arguing that cause in its behalf, with great skill, perseverance, power, and talent, in the course of his argument read passages from this pamphlet, not as evidence, but as weighty argument, to the jury he was then addressing. Here then we have his opinion of the tendency of the pamphlet, notwithstanding all his argument to the contrary today. It helped Mr. Green's side of that prosecution. It was introduced argumentatively against Moore and Sevey. It affected that issue. It had a bearing in that cause. This certainly is enough to prove the tendency of that pamphlet. You cannot hang a doubt upon this point. It certainly was well calculated to influence the jury to one side of that case, and against the other side, and this Mr. Clough well knew. Next, it is said that Mr. Clough is a man of good common sense, shrewd and zealous. Now, such a man does not act without motive. Whenever he acts, he has a design, an object in view, and his measures are well adapted to his ends. He is an active and warm partisan, and just such a one as would be very forward in promoting his party views, and ready to take measures to ensure success to his party. These are circumstances worthy of your consideration. Then Mr. Clough had been an intimate political friend of Mr. Frothingham, meeting him every week, discussing party questions for nearly 20 years. He might have thought himself justified in presuming to value on Mr. Frothingham's friendship, and upon his own personal influence upon Mr. Frothingham. He knew, too, that Mr. Frothingham was a juror, then about to go out and decide upon the case. The feelings of Mr. Clough were engaged in the trial. He attended every day, and went on the stand honestly and openly avowed to what side he belonged. What his wishes were as to the result of that trial, everybody in court clearly saw. They were abundantly apparent. His whole personal influence was thus brought and put forward to influence the juror. All these are circumstances throwing light upon his motives. The time when to give the pamphlet, and when it was in fact given, was not the result of accident, but of calculation, of deliberation, the exact moment most proper to produce the effect intended, the time waited for, chosen, though most appropriate to influence the jury. What is the history of that pamphlet? Written more than 30 years ago for a special purpose, it is reprinted in vast numbers in 1830 for another purpose, and sent to all the four winds of heaven for distribution. It is now grown scarce again, remaining only in a few hands. Mr. Barnes had a few stowed away in his garret or elsewhere, almost forgotten, and Mr. Clough had a few. It is said Mr. Clough is an anti-Masonic tract distributor. Be it so. Was there no other time to give such a tract to Mr. Frothingham than just at the close of a most tedious trial, lasting a whole week, in which a vast mass of conflicting testimony had been put in, and the arguments of counsel had occupied a day or two, upon all which the jury were to deliberate, with their minds distracted by opposite statements of witnesses and lawyers. Was such a time a season of leisure for a juryman to quit the consideration of so difficult a case and read tracts and letters that did not relate to the case? Would any man of common sense at such time, and Mr. Clough is a sensible man, urge upon a juror to read a book upon a subject not relating to the matters, which then demanded the full exercise of all his intellectual powers? Can anyone believe this? The time, then, selected from among all the days of that week, from among the weeks, months, and years which have elapsed since the publication was printed, and since Mr. Clough has become a tract distributor, the time thus chosen clearly indicates the motive of the man who then gave it. Had it been given before that hour, it might not have got into the jury room. There are also other marks of design. No other such tracts have lately been distributed. They were getting obsolete and were hunted up for this occasion. Mr. Clough has not been proved to have distributed any other tract, nor at any other time. He brought it to the courthouse expressly for Mr. Frothingham at that time, to be read in reference to that trial, and gave it to the only man through whom he thought he could get it to the jury. Mr. Clough came before Mr. Frothingham that afternoon to the courtroom. Others also were there. There was no offer or attempt to distribute the pamphlet before Mr. Frothingham arrived. He called Mr. Frothingham to him, told him he had something for him. It was not ready for distribution until Mr. Frothingham came to him. No attempt to take it from his pocket, to search for it, nor to give it till then. Mr. Frothingham was the first person he gave the paper to. Mr. Marshall asked for one because he saw Mr. Clough give one to a man on the jury. That circumstance excited his curiosity to see what it was. It is an afterthought, the suggestion of ingenious counsel, that it was given in common course of business as a tract distributor, and to Mr. Frothingham accidentally, as to others. The time, the place, the circumstances, the manner, what was said, and what was done, also the special particular intended object, and there was sagacity, shrewdness, calculation, object, motive, all manifested on the spot. Besides giving the paper to him, why ask Mr. Frothingham to read it then? If necessary to give it then, why did not Mr. Clough say, "Take this, read it at your leisure after the trial is over, when your mind is at ease and not occupied in the discharge of a very solemn and difficult duty"? Why not such the language of Mr. Clough? Because that would not promote his object. It would be too late for his purpose after the trial was over. Can anything be more plain and clear than this? Let me ask also who was the friend, or friends Mr. Clough alluded to whom he wished Mr. Frothingham to give the paper. Nobody can doubt, under all these circumstances, he meant his fellow jurors. No other friend was named. No other persons were mentioned or alluded to. Such indeed are the strong and numerous circumstances manifesting design, calculation, object, and motive in Mr. Clough, that to get rid of the effect of them, his counsel is obliged almost to stultify the old gentleman, to attribute to him forgetfulness, loss of memory, action without motive, zeal without knowledge, the infirmities of age, and so forth. But there is much inconsistency in this, because he himself avows his client to be a man of good common sense, honest, frank, and warmly engaged in partisan warfare, and we all know that this latter description is just. No credit, then, can be given to the declaration that he had forgot Mr. Frothingham was a juror. He had seen him through the whole trial, every day, sat but 4 feet in front of him, frequently talked and joked with him in the courtroom before the judge took his seat, on different days, and was familiar with him for years before. 'Tis impossible to believe he could have forgot a fact that stared him in the face so constantly. The excuse is lame, and was made only after Mr. Clough had received a severe rebuke from Mr. Frothingham. Then he perceived his mistake and made the best apology he could think of, in the silly pretense that he forgot he was on the jury. He was strongly urged to consider it as a fact of great importance by Mr. Clough's counsel that he asked Mr. Frothingham to give him back the paper, and a fact clearly indicative of his innocence. For myself, I think it of no importance in his behalf, but on the contrary, an acknowledgment of his guilt. The offense had been committed. Suppose a man had forged a check and fraudulently passed it, and got that money for it, and afterwards, fearing a detection, and sensing that he had committed a crime, should succeed in paying the money back and getting back the forged instrument. Such a state of things would avail him in mitigation of sentence, but the act was done. It was complete. The crime was perpetrated, and the very repentance he manifested was proof positive of the deed. If a man had shot another and got back the bullet, the evidence of his guilt might not be the same, but his criminality is in no wise diminished. To state a more analogous case, suppose instead of a printed pamphlet, Mr. Clough had said to Mr. Frothingham, "Come here, I have something for you. Here is a $50 bill. My wishes are for Mr. Green's success in this trial. Do what you can for him, and get your friends on the jury also to do what you can for him." And suppose Mr. Frothingham had replied, "This comes with an ill grace from you, my old friend and companion. You should have known me better than to insult me with a bribe in such circumstances. Do you think I am so sunk in depravity, so mercenary as to sell my honor, my conscience, my integrity, my oath, and do injustice for money? I despise you and scorn your money." And suppose Mr. Clough had said, "Oh, I forgot you were a juror. Give me back my money." And Mr. Frothingham had said, "No, now I have got you. I'll keep your money to give it to the grand jury as evidence of your crime." Can anybody think that asking for the money back in such a case would be any proof of innocence? Surely not. Gentlemen, I perceive my time is out. I have many other things in my mind to say to you, but I will not detain you. The cause depends upon what you believe was in Mr. Clough's heart when he delivered this paper to Mr. Frothingham, what his motive and desire were. You have a responsible and important duty to perform. You are to act on your oaths and your consciences. You are not allowed to consult your feelings to be governed by compassion, nor to excuse Mr. Clough because he is old or poor or has been unfortunate. If he had the corrupt motive alleged in the indictment, you must say so. There is nothing in the language of the indictment deserving the severe remarks of the defendant's counsel. If Mr. Clough intended to bias and influence the juror, contrary to law, in manner set forth to the indictment, such an act deserves all the epithets therein bestowed on it. It was wicked, unlawful, unjust, corrupt. But if under all the circumstances of this case you can conscientiously acquit Mr. Clough, there is no man in the community that will be more ready to congratulate him than I shall be. End of section 80. Section 81 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Ebenezer Clough for Embracery. Boston, Massachusetts, 1833, Part 7. October 13th. Judge Thatcher. The offense on trial is happily so rare in our Commonwealth that the learned attorney for the defendant seemed to doubt whether it had an existence, or was punishable by our law. You would therefore expect some information from the court on that point. If the indictment did not present to the jury a clear description of an unlawful act done by the defendant, it would fail in its office. It charges that Ebenezer Clough, with the intention to pervert the public justice, did, in the trial of an indictment in this court, at the last July term thereof, in which the Commonwealth, upon the complaint of Samuel D. Green for his supposed libel on him, was one party, and Charles W. Moore and Edward Sevey were the other, deliver a printed paper to Nathaniel Frothingham, one of the panel of the jurors, who was sworn to decide on the issue, and did urge him to read the paper, and to let others of the panel read it, with the unlawful intent to influence and incline them, in that trial, to be more favorable to the side of said Samuel D. Green than to said Moore and Sevey, which paper the juror received from the said cloth, and did carry into the jury room. This is charged to have been done by him knowingly, before the jury had been instructed by the court, and before they had retired to agree on a verdict. I understood the indictment to describe an act that fell within the general description of the offense which is known in law by the name of maintenance, which is, says Sir Edward Coke, the most dangerous enemy that justice hath. It signified in law a taking in hand, bearing up, or upholding of quarrelsome sides, to the disturbance or hindrance of common right, and it is twofold, one in the country and another in the court. The third species of this offense which is done in court is, when one laboureth the jury, if it be but to appear, or if he instruct them or put them in fear, or the like, he is a maintainer, and he is in law called an embracer, and an action of maintenance lieth against him. Whether the jury passed for his side or no, or whether the jury gave any verdict at all, yet shall he be punished as a maintainer or embracer, either at the suit of the king or party. Coke on Littleton, 368a. The doctrine of the common law on this subject had been repeatedly recognized by our Supreme Court. From this passage, and from the various authorities which the industry of the learned counsel on both sides had read from, books ancient and modern, I infer and instruct you that an act unlawfully done to influence a jury, who are engaged in the trial of a cause, as by promises, threats, bribes, solicitations, or instructions, whether written, printed, or verbal, in disparagement of one of the parties and in favor of the other, was an offense against the law of this Commonwealth. The practice of the court, both in civil and criminal trials, is founded on the law of the land, and is evidence of that law. And when the law orders a thing to be done, and the manner in which it shall be done, it implies a prohibition of everything inconsistent with it. A strict adherence to the rules of law, both in respect to the forms of trial and the canons of evidence, is of the utmost importance for the protection of the innocent and the establishment of right. These rules may sometimes operate to screen an offender from justice, but the law less regards the punishment of the guilty than the safety of the innocent. The wrongful conviction of an innocent man would be a stain upon the public justice. The offense is being described in an indictment, fully, plainly, substantially, and formally, and the party accused having pleaded to it. The issue is joined, and a jury is thereupon to be impaneled in court to try the fact in controversy, according to the law and the evidence which shall be given to them. The jurors, who are judges of the case, are returned by lot, but either party may challenge the jury for legal cause, either the whole panel for partiality or other fault in the officer drawing or returning the jury, or any individual on the list, and it is the duty of the court to be satisfied that the jurors are competent and free before they are sworn. But the presumption is generally that jurors are free, and it is for the counsel of either party to suggest any legal exception or ground for doubt or inquiry. The proceedings upon the first day of the trial must have impressed you with the importance the law attaches to the ceremony of impaneling the jury, who are to be as free and impartial as the lot of humanity will permit. The defendant's counsel challenged the foreman for favor, or bias, as it is called, upon the ground that he was a Freemason. He elected to prove the fact by other testimony than that of the juror himself. The Act provides that the justices of the respective courts shall, on motion from either party in a suit, put any juror upon oath, whether he is in any way related to either party, or hath formed or given any opinion, or is sensible of any particular interest or prejudice in the cause. And if thereupon it shall appear to the court that such juror does not stand indifferent in the cause, another juror shall be called or returned, and be placed for the trial of that cause in his stead. Act of 1897, Chapter 140, Section 9. The defendant declined moving that the jurors should be put on oath, and prayed that the fact might be settled otherwise. I had recently in another trial expressed my opinion on this ground of objection, and was desirous for the satisfaction of the public justice that it should be settled with the utmost solemnity. I therefore appointed two eminent counselors, equally distinguished for their learning and integrity, to try the question according to the method of the old common law. Although the process of appointing triers to decide upon the indifference of a juror was an entire novelty in the practice of this court, and was not known to have been resorted to in other courts of the Commonwealth, yet unwilling to deny to the citizen what might, in some cases, be deemed a valuable privilege, well known and described in the common law, and never expressly altered or repealed by the legislature. I directed that course in this instance. The trier so appointed was sworn and proceeded to settle the question, though with much reluctance on their part. The witnesses were examined, the counsel argued the question before them, and the court expressed its opinion on the law, as in other trials, and they, after careful deliberation, returned a verdict that the juror stood indifferent. The members of the profession are undoubtedly competent and most qualified to settle a question of this kind, and when called upon, it was considered a duty they owed to the law, which they, on their part, are indebted for much of the distinction they enjoy in the society of which they are members. The issue being thus joined and the jury or judges duly constituted, the accused may defend himself in person or by counsel, in which latter case he communicates freely with his counsel, by whom his defense is presented to the court. In every case, the Commonwealth must make good the charge by testimony of witnesses, sworn and examined in open court at the trial, and by other evidence, or the accused will be entitled to be discharged. Either party may except to a witness. It belongs to the court to determine whether a witness is competent and testifies under a proper legal and religious sanction, and to exclude all illegal and irrelevant testimony. The jury are to hear the testimony, the arguments of counsel, and the instructions of the judge in open court. Nothing is to be communicated to them in evidence or by way of argument, but in open court, and in presence of both parties. No stranger may interfere in the trial of a cause to affect the event in any way. Such interference is never necessary for the ends of justice. Whatever is done is to be done by the parties or by their counsel, and under the eye of the court. No one may speak to a juror in court without permission of the judge, and after the jury have retired to agree on their verdict, they are still under the custody of the court. No one may then have access to them in their conclave, not even the judge, except in presence of the parties. No communication whatever, says the late Chief Justice Parker, in expressing the judgment of the Supreme Judicial Court in the case of Sergeant V. Roberts, 1 Pick 337, ought to take place between the judge and the jury after the cause has been committed to them by the charge of the judge, unless in open court, and where practicable, in presence of both parties, so that the rights of parties on trial, both in civil and criminal cases, are regarded and protected with great jealousy from intrusion and interference. Justice, it is true, is or ought to be blind to the persons of the parties, but she sits in open court, where the light is freely admitted, and nothing is done or permitted to be done clandestinely. Every human trial, says Lord Erskine, ought to take care to administer justice as we look hereafter to have justice administered to ourselves. The jury would next consider whether the accusation was established against Mr. Clough in point of fact, which must depend on the statements of the witnesses, and on the credit which was due to their testimony. On this point, the testimony of Nathaniel Frothingham, the juror, corroborated and supported by all the other witnesses, both for the Commonwealth and for the defendant, seemed to establish the fact beyond any dispute that the printed paper described in the indictment was, during the trial, given by Mr. Clough to the juror, by whom it was received and carried into the jury room. But if the paper was in itself not applicable to the case, and not calculated or designed to affect the minds of the juror, or to render him more favorable to one side and less so to the other, it would not amount to an offense. For it is charged that the act was done in disparagement of Moore and Sevey, and to render the juror more favorable to Samuel D. Green. This made it necessary for the jury to have a general idea of the case, which was on trial at that time, so that, on reading the paper which was delivered to the juror, they might see its connection with that case. The record of the case of the Commonwealth against Moore and Sevey had been read, from which, and from the other testimony, it appeared, though the indictment in that case was for a supposed libel on the private moral character of Samuel D. Green, yet that he was identified with the anti-Masonic party, and that the defendants were identified with the fraternity of Freemasons, that the witnesses were taken from those two parties, and that the merits of Masonry and anti-Masonry entered largely into the consideration of the case. It was the right and duty of the jury to read the printed paper, and to judge from its import whether it was calculated to have the influence upon the jurors which is alleged in the indictment. If it was the evident tendency of that paper to render Masonry contemptible, and its disciples and advocates obnoxious, it had a tendency, so far, to establish the accusation against Mr. Clough. The writer speaks of Illuminatism, and the mischiefs which it had perpetrated in France under the veil of Masonry. He insists that the Masonic institution is frivolous, that it has done no good to the world, although its branches reach throughout its wide extent, that, while it blazoned its follies to the world under pompous names and ceremonies, it buried its virtues in midnight darkness. Not that all Masons are corrupt, but that bad men get into the society and mislead the simple. One cannot read the piece without acknowledging the ability of the writer, and though we may not be convinced by his argument, we shall not fail to be struck with his eloquence. It is not charged in the indictment, nor is it material to inquire whether the jurors were influenced by this paper or not. The question to be settled is upon the mischievous tendency of the paper and the corrupt intention of the defendant to do wrong when he gave it to the juror. If he intended that the juror should read it, and that it should influence his judgment on the trial, it was an unlawful act. Even if the paper contained nothing but truth, was material and pertinent, and might have been read in evidence, still for a stranger to deliver it to the juror clandestinely, without the knowledge of the parties and the permission of the court, was an unwarrantable interference with the regular course of a judicial trial, and was the offense which is charged in the indictment. Nor will that offense be washed out and atoned for by a request from the party that the paper should be returned to him when he found that he had made a mistake, and that his imprudence was likely not only to fail of its object, but to involve himself in trouble. The offense was consummated by the act done, coupled with the unlawful intention. But it is for the jury to decide not only on the act done, but on the intention of the defendant. If they believe that it was on his part an act of inadvertence, that he had forgotten at the moment, as he declared, at the time that Mr. Frothingham was a juror, and requested him immediately to return the paper before he had read it, and before it had done any mischief, it would seem that he discovered his error in season, and repented of it, and therefore that the act was free from the intention to pervert the public justice, which constituted its criminality. It is not your duty to indulge in a severe construction of the acts of the defendant, if there is room for the exercise of a charitable judgment. You may take into consideration his advanced age and his general good character, though at the same time you are not to forget what was urged by the attorney for the government, and even admitted by the defendant's counsel, that he was an ardent friend and a warm partisan. The verdict of the jury is not to depend on the question whether mischief was done, but whether it was intended. You are to attend to the unlawful act, its violation of law and order. If you believe that the defendant did it designedly, you must find him guilty. If you deem it accidental and free from a corrupt intent, it is your duty to acquit him. The verdict of acquittal. At 5 minutes before 10, the jury retired, and at 6 minutes after 10, having been out 11 minutes, they came into court with the verdict of not guilty. Footnote. The following is extracted from Judge Thatcher's charge in the case of Warren Sevey for a libel on S.D. Green, and is the opinion alluded to in the preceding charge. Neither the common law nor any statute, said Judge Thatcher, excludes Freemasons from serving on a jury or from testifying in any cause, but it excludes any person from either whose pecuniary interest is directly concerned. At a period in which party spirit greatly prevails, and in a country where opinion is free, if a man is to be deemed incompetent as a witness or a juror because he belongs to one political or religious denomination rather than to another, perhaps a very great majority of the community and some of its best citizens would be excluded from assisting in the administration of public justice. The Calvinist and Unitarian would exclude each other, and both would join to exclude the Universalist. The Mason and the Anti-Mason would exclude each other. It would be impossible to impanel a jury or to try a cause. The objection is not, therefore, to be considered in the nature of a peremptory challenge. It is unknown to our law as such. It comes under that denomination of objections which exclude a juryman who does not for some cause stand free, or indifferent between the parties, propter effectum. He must stand indifferent as he stands unsworn. Whether a juror is indifferent is to be settled by the court, and our statute says that the juror may be put upon oath to ascertain this fact. But I should not be free, after examining the juror on his own oath, to permit witnesses to contradict him. The challenger must elect either to abide by the results of the examination of the juror on the voir dire, or to rest his challenge on the evidence of others. If a man should admit on his voir dire that he belonged to a secret society in which he had voluntarily sworn, on his admission, to prefer the members of the society to strangers in all cases, and to support them in their cause whether right or wrong, this would go to his indifference. But if he should add that he now did not consider that oath as binding on his conscience, that he felt it to be his duty if sworn as a juror to decide according to the law and the evidence, and without respect to the persons of the parties, I know of no law to exclude the juror. But the oath so voluntarily taken is not binding on his conscience. In fact, it would be contrary to duty and to good conscience for him to render a verdict under the influence of that oath, against the truth and justice of the case. It is a temptation to his conscience, I know, but if a court should set aside the juror for that cause, it would be an admission on their part that the oath was binding. To show by evidence that the juror was a member of such a society, and that he had voluntarily taken such an oath, would not be sufficient, in my judgment, to exclude him, because I should be bound to say that such an oath was contrary to conscience and duty, and that it was not binding on him, and that I was bound to believe that upon his being so instructed, he would disregard the oath. But the case would be otherwise, if the juror had taken the oath in reference to the case which was to be tried, because that would show that in the case he was not indifferent. Many Masons have publicly renounced Masonic engagement and society from a conviction that the engagement was not binding upon them. I certainly could not reject a seceding Mason on account of having formerly taken such engagement. I am bound to believe, in the first instance, that every citizen will act according to right and duty. If he has committed an error, that he will correct it, when so properly advised. but even a seceder may labor under a prejudice, and so not be indifferent in a case where a Mason is one of the parties, and therefore such a seceder might not be a free juror. End of footnote. End of section 81.
Section 82 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Dr. Valorous P. Coolidge for the murder of Edward Matthews, Augusta, Maine, 1848. The narrative. Dr. Valorous Coolidge was a young physician in the town of Waterville, Maine, of good reputation and with a flourishing practice. But notwithstanding this, he was always in need of money, borrowing it wherever he could and at any rate of interest. At the trial, more than a dozen witnesses testified that he was indebted to them for money lent in sums from $50 to $400, and that about the time of the death of Matthews, he offered $500 for the use of $2,000 for 6 months. Dr. Coolidge knew that Edward Matthews, who was a trader, had gone to a neighboring town with a drove of cattle, and that he would return with a lot of money, made repeated inquiries as to how much he would probably receive, and asked the barkeeper at the hotel where Matthews boarded to let him know when he returned. Matthews came back, but the doctor did not see him for several days. There were several private interviews between Matthews and Coolidge on Wednesday and Thursday, and in the afternoon of the latter day, Matthews received $1,500 from the Taconic Bank, and after 8 o'clock at night, remarking that it was time to go to Dr. Coolidge's office, was seen to go in that direction. The next morning he was found dead in the cellar under Dr. Coolidge's office. 2 deep cuts were on his head, some black and blue spots about his throat, and his boots were clean, though the streets were muddy at the time. At the coroner's inquest, Coolidge was examined with other witnesses and stated that Matthews had been at his office twice the day before for the purpose of borrowing $200, which he wanted to make up the sum of $2,000 he had promised to raise. The last time it was a little after 8 o'clock at night when he received the money, of which $100 was in a note he had received of one Doe. He denied that he had written any note to Matthews the day before or at any time. There was a post-mortem examination of the body, conducted by Coolidge. When it was proposed to examine the stomach, it was taken out by Coolidge and the contents emptied into a basin. They smelt strongly of brandy. A few minutes afterwards, he remarked to a bystander that they had better be removed, as they might scent the room. They were accordingly taken out, and after remaining a while behind an old hogshead, were locked up in an ice house, whence they were taken on the following Monday and delivered to Professor Loomis for examination. When Coolidge was asked on Friday evening if the contents of the stomach had not better be examined, he inquired if they had been preserved, and on being told that they had, he replied that they had lain so long nothing could be ascertained from them. These contents were carefully analyzed by Professor Loomis and found to contain prussic acid by several tests. Several physicians who were present at the post-mortem examination also testified that the liver, lungs, spleen, and brain indicated the action of prussic acid, and that they perceived its peculiar odor. The medical men further thought that the wounds in the head, not having been attended with inflammation, were probably given after death, with a view of preventing suspicion of the real cause. Coolidge was now strongly suspected of the murder and was taken into custody. It was then found, and it was proved in court, that on the 17th of September he had written to Boston for an ounce of hydrocyanic prussic acid, as strong as it can be, which he received, and that on the 19th of September he also wrote to Hallowell for an ounce of the same acid, as strong as it is made. This acid, when used in medicine, is commonly diluted to 2%. The pure acid is seldom called for. Dr. Coolidge previously had in his office some of the diluted acid. On Monday, after the murder, a boy found in the top of Coolidge's sleigh a gold watch and chain, which were proved to be the same as those worn by Matthews the Thursday before. They were wrapped up in white paper, which was of the same description as some found in Coolidge's office. Coolidge endeavored to persuade 2 witnesses to conceal from the coroner's inquest that he wished to borrow money of them, having himself stated to the jury that so far from wishing to borrow money, he had lent Matthews $200, and to one witness he proposed to give $50 and declared he was a ruined man when he could not succeed. Many minor circumstances corroborated the inference from these strong facts, but the testimony of Thomas Flint removed every shadow of doubt of the prisoner's guilt. Flint was a student in Dr. Coolidge's office, and he stated that about 9 o'clock on Thursday night, when he was going to bed at his boarding house, he met Dr. Coolidge, who requested the witness to go to his office with him. When there, he said, "I am going to reveal to you a secret which involves my life. That cursed little Edward Matthews came in here and went to take a glass of brandy and fell down dead. He now lies in the other room. I thumped him on the head to make people believe he was murdered." After some consultation, they decided on carrying the body to the cellar, to remain there until it was discovered the next day. The next day he found in the office a note from Coolidge, requesting him to sweep the office carefully, which he did, and removed some signs of blood. About noon he saw the doctor charge Matthews with $200 lent, and he handed him a sum of money, requesting him to keep it, saying the jury might ask to see his pocketbook, and he did not know but there was too much money in it. After the examination of the body, Dr. Coolidge told Flint, while in the office together, that there was $1,000 under the carpet, beneath the iron safe, which he wished witness to take care of. In the evening, the doctor seemed to be greatly agitated. He took the money he had given Flint, selected some of the bills, put them into his pocketbook, and gave the witness others from the pocketbook. The money was put in one of a number of jugs in the office, and the doctor requested Flint to sleep with him that night. The next day, he seemed unwilling to receive back the money, but afterwards went to the office, broke the jug, and threw the notes into the stove. Flint stated that a letter produced to the coroner's jury from Coolidge to Matthews, requesting the latter to call at his office on Thursday night, he had withdrawn from the bag on Friday night and destroyed. The doctor told Flint there was a bottle at his office that had contained prussic acid which ought to be destroyed, and that the bottle which had come from Boston should be filled up, for some of it had been used. He also desired that the brandy bottle should be rinsed and the water in the sink thrown out. He also requested him to take the watch from his sleigh and throw it into the river. Flint admitted that when before the grand jury he did not state anything about the money, the watch, or washing out the stains from the floor. In consequence of this variance in Flint's testimony, the counsel for the prisoner endeavored to invalidate it. The jury, however, after a deliberation of 24 hours, returned a verdict of guilty, and the prisoner was sentenced, according to Maine law, to be hanged after the expiration of a year spent in hard labor. The trial. In the Supreme Judicial Court of Maine, Augusta, March 1848. Honorable Ezekiel Whitman, Chief Justice, Honorable Ether Shepley, Honorable Samuel Wells, Associate Justices. March 14th. The trial of Dr. Valorous P. Coolidge for the murder of Edward Matthews at Waterville, Maine, on the 30th day of September, 1847, commenced today. The indictment contained 4 counts. First, for the murder of Matthews by striking him on the head with a stick of wood. Second, third, and fourth, for committing the murder by administering prussic acid to Matthews in a glass of brandy, from the effects of which poison he died. S. H. Blake, Attorney General, and Lot M. Morrill for the state. George Evans and Edward Noyes for the defense. The court met at the courthouse of the county, but finding it altogether too small to accommodate the large number of persons desirous of hearing the trial, immediately adjourned to the Reverend Dr. Tappan's church. The church is a very large one, capable of containing perhaps 1,500 persons, yet it was filled as soon as the doors were thrown open, the galleries principally with ladies. The prisoner, when brought into court, appeared calm and collected. His face exhibited signs of health. He was dressed with scrupulous neatness, in a black frock coat, black pants, and vest. His appearance was that of a young man, about 25 years of age, evidently a man of the world, one who had been accustomed to the better classes of society. His face bore strong marks of intellectual activity, and one would at once imagine his habit to be thoughtfulness and deep study. The following jurors were chosen: Francis F. Haynes, Joseph B. Allen, Hiram Averill, Brown Baker, Jonathan Clark, Daniel Cunningham, Orrin Doust, David Elliott, Isaac Farr, Harrison Gould, William Green, and Harrison Ham. The indictment was read to the prisoner, to which he pleaded not guilty. End of section 82, read by Martha Weller, Champaign, Illinois, January 31st, 2024. Section 83 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3, by John D. Lawson. Trial of Dr. Valoris P. Coolidge for the murder of Edward Matthews, Maine, 1848, Part 2. Mr. Morrill, Gentlemen of the jury, the offense with which the prisoner at the bar stands charged is one of the most important known to the law. In approaching an examination and inquiring into it, your duties and responsibilities are corresponding to the magnitude of the crime charged. I need not press upon your attention the solemnity, dignity, and importance of your office. You are selected to maintain the public laws by convicting the guilty or acquitting the innocent. The oath that has been administered to you contains an epitome of the duty required of you, at once the guardians of the public peace and of the rights of the prisoner. You are to try the issue presented to you, unaffected by any motives but those which should influence conscientious and rational minds. You are to examine the question of the innocence or guilt of the prisoner without fear, favor, affection, or hope of reward on one hand, and without the prejudices arising from hated envy or malice on the other. The crime of which the prisoner is indicted is murder of the first degree. You are to inquire, and by your verdict ascertain whether the prisoner murdered the deceased, and if so, whether he committed the act in accordance with a settled purpose or design to do it. If you shall so find, he is then guilty of murder with malice aforethought, which is murder in the first degree. The principles of evidence applicable to this prosecution are equally plain. In entering upon the introduction of evidence on the part of the government, it is admitted to be a settled principle of law that in proportion to the magnitude of the crime charged is to be the care and caution of the jury, with respect to the nature and amount of testimony necessary to procure conviction. But while you regard this as a pertinent rule of evidence, you must remember that your oaths require you to listen and decide impartially, uninfluenced by sympathy or prejudice. The burden of proof is on the government. Before you can be called upon to convict, all reasonable doubts of the guilt of the prisoner must be removed from your minds. The presumption of law is that you have formed no opinion as to the guilt or innocence of the prisoner, who is entitled to the presumption of innocence until found guilty. But while you will faithfully regard these cardinal maxims of the law, you will also bear in mind that it is a perversion of these maxims if, from compassion, sympathy, weakness, or other improper influences, you allow the prisoner to escape because he may possibly be innocent, when by the law and the proof, the probabilities of his guilt are certain. You are to expect and demand satisfactory proof, and what in law is considered full proof is that measure of evidence which satisfies the mind of the jury of the truth of the matter charged, to the exclusion of all fair and reasonable doubts. You are not to expect absolute mathematical or physical certainty. This, in all judicial investigations, is utterly unattainable and is not required. When the proof is full and clear, for the jury to acquit upon light, trivial, and fanciful suppositions and remote conjectures is a virtual violation of their oath of office, and is no trifling offense against the best interests of society, to the hindrance of public justice, and to the encouragement of offenders. In this, as in all like prosecutions, a portion of the testimony will be that denominated in law circumstantial. That is, although the government may not be able to produce and put upon the stand a witness who saw the prisoner administer the fatal potion, we shall prove other distinct facts, and which facts shall be so connected with the fatal fact that by their own natural force they will irresistibly produce conviction upon your minds that the individual connected with these latter facts must have been the guilty agent. The secrecy with which crimes of a flagrant character are generally committed is such as renders detection and proof of the overt act quite impossible. And yet, there is such an intimate coincidence in events that no event of moment can possibly happen without evolving circumstances of such conclusive tendency as to force conviction and to exclude all reasonable doubts. The vestiges which the commission of crime always afford form a chain of circumstances which lead unerringly to the offender, and by which he may be traced and ascertained. With this statement of general principles, I will proceed to detail to you the evidence, which I doubt not will satisfy you of the guilt of the prisoner, and under circumstances exhibiting a cool depravity unparalleled in the history of crimes. The first inquiry most naturally suggested is, was the deceased in fact murdered? This is denominated in law the body of the offense, and is often a point of great nicety and difficulty. Such were the circumstances under which the body of the deceased was found, and such the marks of violence upon it, that you will have no difficulty in concluding that the crime of murder had been committed. The deceased left the Parker house at about 8:00 p.m. in health, and in the morning was found dead in a cellar, the body resting on a pile of wood, the head bearing marks of repeated violent blows, and the pockets rifled of money and a watch he was known to have had on the evening previous. The indictment charges the murder to have been committed by administering to the deceased a certain deadly poison. Also, that he was murdered by the infliction of blows upon the head by a stick of wood. These charges must be proved in substance as alleged, and it is in compliance with this principle of law If in the charge of murder by a certain kind of poison, the proof is of death by a certain other poison, or by a compound of poisons, or if death by blows with a stick or club of wood, or if the proof be death by blows inflicted with a broadsword or a hatchet, the only inquiry then will be whether the deceased fell by the hand of violence by blows inflicted on the head, or by secret poison, or both. Was the death caused by poison? We shall show to you, gentlemen, that a large quantity of the most deadly poison, of the kind charged in the indictment, hydrocyanic or prussic acid, was found in the stomach of the deceased, a quantity sufficiently large to have produced death, that the presence of such poison was found in the brain of the deceased, as well as in other parts of the system, as would be natural to expect from the subtle and diffusive nature of the poison if death had been produced by taking it into the stomach in any considerable quantity, that at the post-mortem examination, effects of poison and of the peculiar character charged to have been employed were apparent in various parts of the system, as indicated by the morbid appearance of the coatings of the stomach, the discoloration of the blood, and other indications peculiar to death by this kind of poison. From these facts and the peculiarly deadly nature of the poison, it is probable that death resulted almost instantaneously with the introduction into its stomach. So destructive is this poison to animal life that the smallest quantities prove almost instantaneously fatal. Was death in any way caused by blows upon the head? We shall show you that there were deep gashes upon the head, the scalp lacerated, and the skull fractured, as if blows had been inflicted with the edge of a stick of wood. The blows were in reality probably inflicted by the edge of an unground hatchet, and were supposed to have been sufficiently violent to produce death, but probably not sudden death. These wounds, however, gave indications of having been inflicted after death. There were also marks of violence upon the throat, as if it had been clutched severely by a man's hand. From these facts, it may be assumed that death was produced by the poison, and that the wounds upon the head were inflicted after death, probably to avert suspicion from deceased having died of poison, and to raise a suspicion that he fell by the hand of violence in the street. The facts, however, may be inconsistent with the hypothesis that the poison was relied upon as the principal agency. The blows may have been inflicted the more readily to dispatch him, and the marks upon the throat the effect of clutches there to prevent any scratches in the struggles of death. Having shown that the deceased was murdered, and the manner, the next important inquiry is, did the prisoner commit the act? When the act of murder has been proved, the motive which the accused may be supposed to have had to commit the deed, whether of intent or otherwise, is proper to be considered by the jury. The law supposes an intimate connection to exist between a man's motives and conduct, and in judicial investigations, it confides to the experience of the jury to infer the motives of the accused from his acts, also to infer what his conduct would be likely to be from the motives by which he was known to be influenced. We shall show such acts and conduct on the part of the accused as to indicate a most pressing want of money, that he evinced great embarrassment in his monetary affairs, and shall also prove such shifts and extravagant offers by which to raise money as would naturally lead to most extraordinary and desperate measures to procure it. That he offered one man on the day before the murder $500 for the use of $2,000 4 or 5 months, to another man, a short time before the murder, he tried to obtain $1,000 and offered for its use 6 months, $500. That he negotiated with deceased on the day of the murder and the day before the sum of $1,500 and was to pay $400 for its use 10 days. We shall show various other unsuccessful attempts to obtain money, all under enormous offers of usury, and also that for the last year or two he had borrowed of numerous individuals various sums, large or small, as he was able to obtain it, and upon terms indicating most pressing need, and that latterly all these offers were made under injunctions of profound secrecy. That he was indebted and involved for borrowed money not less in amount than $3,000, and that his various applications and offers seemed to show a necessity for 2 or 3,000 more. Whether thus involved from extravagant and improvident expenditures, or from speculations with Dr. Potter, as he often declared, or from other speculations which he was not willing to disclose, may not perhaps be particularly important, but it will be your province to inquire into them. If the prisoner was incited by the powerful motive by which I have supposed him to have been governed, and by which he was urged on, how was this desire to be gratified by the murder of the deceased? The deceased had what the prisoner desired, what he had tried to negotiate for. He had $1,500 and a gold watch, had them that afternoon, had procured it from the bank on an agreement to let the prisoner have it, and he, the prisoner, knew all this. If he had the motive, and that motive was avowed by the knowledge of the fact that deceased had the money, the inquiry then is: had the prisoner the means to accomplish his desire? Had he the poison? We shall show you that on the 17th day of September, 17 days prior to the commission of the deed, he sent to Hallowell for 1 ounce of prussic acid, and the order read to have it as strong as it can be made. This was received the next day. On the 19th, he sent to Boston for 1 ounce of the same acid, as strong as it could be made, and between the 21st and 25th received that, with a letter describing it as the strongest kind and containing a caution as to its use. Hydrocyanic acid is little used in medicine, and the prisoner had, when he sent these orders, a large amount already on hand of a diluted quality, fit for medical uses, and prepared in the only proper manner for such uses, a quantity quite sufficient to have lasted him a lifetime. He sent for and received such as is not used for medical purposes, and could not have been needed or intended for such uses. It is not usually found in the concentrated form he desired in the apothecary's shops. The hatchet also with which the blows were given will be produced here. Having the means, the motive, and the object, had he the opportunity? Deceased was known to have been under an agreement to meet the prisoner at his office that evening at about 8 o'clock. We shall show that he was known to go in the direction of the office, with the expressed intention of going there, that he did in fact go there between 8 and 9, that the situation of the office is such that the prisoner was secure in his purposes, being in the second story, that the tailor's shop under the office was closed and vacated before 8 o'clock, that the adjoining tenements are so situated that he was free from interruption from that quarter, and that noise could not be heard from one tenement to the other, that he would not be interrupted by his students, one of them, Mr. Dingley, and the office boy living across the river at considerable distance, and had gone home for the night at about 8 o'clock, at the request of the prisoner, who said he had a private engagement with a man at the office to arrange about procuring a subject for dissection, that the body could be readily conveyed from the office to the place where it was found, that in the back room, where his medicines were compounded, he kept brandy, of which deceased drank on the day of his death at 3 o'clock in the afternoon, that on the same shelf from which the bottle of brandy was taken was an empty phial, which had contained prussic acid, and another which had a portion of the acid still remaining. Here was the phial, which contained the prussic acid for medical purposes, as was also the unground hatchet. We shall show you also that this was a scene with which deceased had been made familiar by former invitations, and to which he had been specially invited that evening under injunctions of profound secrecy. He would approach it with an incautiousness induced by former visits. Thus artfully had all things been arrayed, nothing there which could excite suspicion, and yet the opportunity in time, place, means, and other favorable circumstances was complete. There sat the brandy bottle out of which the deceased had drunk in the afternoon, inviting him now as then. But the contents of that phial, then full, now empty, had been commingled with it. In the language of the prisoner, he went to take a glass of brandy and fell down dead. Thus fatal and sudden was the effects of this compound. In connection with this, we shall show that a few minutes before 10 o'clock, probably after the fatal deed had been performed, the prisoner was seen on a back street in the rear of the building, probably calculating the difficulties of getting the body to the river. That about this time he was seen coming from the direction of his office and passing up the platform in front of the sitting room in William's Tavern, turned, looked in, saw Flint, his student, with other members of the family, then retraced his steps without going in. That after this he came into the front entry, met Flint there on his way to his bedchamber, and requested him to go with him to the office. Flint did go, and returned a little after 10 o'clock, but the prisoner came in late. That he arose the next morning by 4 o'clock, and was seen coming from the direction of the stable, where afterwards was found the watch which belonged to the deceased. Having shown you the opportunity, I shall now show you that he sought the opportunity, and planned and arranged for it. The deceased was known to the prisoner to be in Brighton with a drove of cattle. He is known to have made special and repeated inquiries as to how much money deceased's drove would sell for, how much he paid for it, when he was expected back, and made arrangements with the barkeeper of the house where he boarded, and where the stages with the passengers from the west always stopped, to let him know when deceased arrived, for he was anxious to see him before he went to Clinton, where he had a partner. Deceased arrived on Saturday, but was not seen by the prisoner until the following Wednesday. He then met him in the street and invited him to his office. He went there secretly, and the prisoner was overheard to enjoin secrecy on him. Prior to this, the deceased had put his money in the bank. We shall show that the prisoner proposed a negotiation with deceased, by which it was arranged that the deceased should obtain for him from the bank $1,500 on the security of his books. All of this being arranged, deceased on Thursday received a note from the prisoner to meet him at his office at 8 o'clock in the evening for the purpose of closing up the agreement. Having detailed to you the proof that a murder has been committed, the manner in which it was done, and the prisoner's motives, objects, money, and the opportunity of doing it, and is seeking the measures and opportunities, there is another species of proof to which I propose to turn your attention, and to which the law attaches the utmost importance, namely, the conduct and declarations of the accused after the murder, and when it is known to him that he is suspected. The law scrutinizes the conduct of the accused so critically that it is made a presumptive proof of either guilt or innocence, and that conduct is an attempt to avoid suspicion by concealing evidence of his guilt, by fabricating false and contradictory statements, by the destruction and removal of proofs tending to show who was the offender. These are such artifices as are commonly, according to experience and the maxims of law, resorted to by the guilty. We shall show you not only that the prisoner has attempted to conceal the evidence of his guilt, not only has he fabricated false and contradictory statements, but that he repeatedly attempted to suborn witnesses to testify for him. Before the inquest, the day after the murder, he denied that he had attempted to negotiate money with anyone, when he had in fact been in negotiations with Gilman and Gray. He denied that he had any arrangements with the deceased for money. We shall show that he had. He denied that he wanted an interview with the deceased on Wednesday. We shall show you that he sought an interview, visited him in the street, and had such interview with him that night in his back office. We shall show you that when he knew that John Matthews had said he wanted money of deceased for speculative purposes with J. Potter, he went to George Gilman, of whom he had attempted to negotiate money, professedly for the same purpose, and by offers of large sums of money and other inducements, endeavored to persuade him to go before the inquest and state that he had not wanted money of him, that he attempted to induce Gray to do the same thing, that when before the inquest he stated that he let deceased have two $100 bills on the night of the murder, and not being able to show where he got but one, he went to William Hill and tried to induce him to go before the coroner's jury and swear that he let him have one of the bills. He denied that he had any agreement with the deceased for money, or wanted any of him, or that he had an appointment at his office with him on the evening of the murder, or that he had written him a letter. He carried on what he supposed to be a secret negotiation for money, and was to assign to him his books, which assignment deceased was known to make. He had in fact written the letter to deceased to meet him at his office that night. When by the post-mortem examination it was ascertained that poison was found in the stomach of the deceased, he caused the acid bottle to be destroyed and the brandy bottle to be cleansed. When Flint went into the back office and found the deceased lying upon the floor dead, he was told by the prisoner that he had fallen in an epileptic fit while drinking a glass of brandy, that he had beaten him on the head to carry the idea that he had fallen by the hand of violence in the street, and that he must assist in getting him from the office, or they would be suspected of having murdered him, that after various proposals to carry the body to the river and the street, it was finally arranged to deposit it in the cellar, where it was found. That the prisoner went below to clear the way, came up, and carried the body to the place where it was found, that he afterwards returned and removed all traces, as he supposed, of the murder, and remarked that all was right, that Flint then went to the tavern, and not long after the prisoner followed, that on Friday afternoon, after the disclosure the deceased was to let him have money, he told Flint there was $100 under the carpet under the safe, and which he desired him to remove. That after physicians had reported prussic acid in the stomach of the deceased, he told Flint the empty phial had better be broken, and requested him to replace the other on the shelf and fill it up with water. At the same time, to throw the watch which had belonged to deceased into the river. We shall show that at the post-mortem examination, the prisoner took the direction, removed the stomach, examined the wounds on the head, and pronounced them fatal. That he poured the contents of the stomach into a bowl, remarking that they scented of brandy and had better be thrown away. Thus, unconfounded by the deed, with impious and bloody hands, like the guilty and murderous Macbeth, he bends up each corporal instrument to the terrible feat, and with unshrinking fratricide baffles the searching suspicion of the lookers-on, and aims to put beyond the reach of proof the agencies he had employed in the execution of his baneful project. End of section 83, Read by Martha Weller, Champaign, Illinois, February 1st, 2024. Section 84 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Dr. Valorous P. Coolidge for the murder of Edward Matthews, Maine, 1848, Part 3. Evidence for the prosecution. David Shorey. I keep a shop under the office formerly occupied by the prisoner. Saw the body of deceased on morning of October 15th, lying on the wood with the feet out a little way of the door in the cellar. Between 8 and 9 o'clock. A number of persons were present. The door was very heavy and made to swing inward. Could go back no farther than it did, on account of wood piled behind it. It is a door made of 2 parts. The body was removed while I had gone to my shop. Did not recognize the body, though I knew deceased. The hat was lying nearby. Noticed that deceased had on boots which appeared to have been newly blacked. Looked as if a person might have walked in them a short distance. There was a black coat on the body. The brace on the pants was unbuttoned, and the vest and coat had the appearance of being pulled up. The door which leads to this stairway was fastened on my side with an iron bolt. On the doctor's, I think, with a bolt and lock. The doctor kept medicine and fuel in the cellar, and the door was left unfastened to accommodate him passing and repassing. Don't know at what time my help left the shop on the night of the murder, but they came to my house a few moments after 9. 3 men and 5 females who compose my help came to my house at a few minutes after 9, together with 2 boys. The boy who opened my shop in the morning was at his work taking off the blinds when I arrived. Cross-examined. The partition between the 2 shops is lathed and plastered on both sides. A door leads into my press room, the control of which rests with one of my lads and is fastened when the shop is closed. They usually stay in this back shop until 9 o'clock. Found the chairs in the morning as I had left them the night before. Had been cutting a coat and left about 7 o'clock. Left the coat partly cut. Found it in the morning precisely as I left it. Found the door of my back shop unhooked in the morning, as had been frequently the case for some time. March 15th. Joseph Hasty. Saw the body of deceased on the morning after in the wood cellar. The body was in a sitting position on the wood, facing the door. A man in the street might have seen the body. Noticed that his boots were clean. Took the body out of the cellar alone, and then discovered that the body was that of Matthews. Saw him the day before at the Parker House, and on the evening of the same day in front of the Parker House in a wagon. Noticed that he had his gold watch chain on at the time. I afterwards saw the body in Williams' Tavern. Clothes on deceased were not muddy when I saw them. They were the same he usually wore. Cross-examined. Mr. Tufts, Mr. Simpson, and about 30 others were at the cellar when I arrived there. Do not know whether David Shorey had been there when I arrived. Left the body with other persons and returned about an hour afterwards. There were 1 or 2 pairs of steps from Shorey's back shop to the cellar. Phillips' store is a half store, very narrow. Saw no members of Mr. Williams' family in the tavern, but saw Dr. Chase, another gentleman, and the driver. The froth on the mouth of the deceased was of a yellowish color. The streets were muddy on Thursday evening. David Bronson. Saw the body of the deceased on my return from the Supreme Court. Was in a building in the rear of Williams' Tavern at which I breakfasted. Did not know the body at the time. There were present about a half-dozen individuals. The body at the time was lying upon the wood, so near the door that the head was resting upon the edge of the door. A tarpaulin hat partly on the head so as to partly cover the eyes. From the right nostril a membrane projected about half an inch. The coat was raised up close under the arms, as if someone had been lifting it. Hasty asked me if the body could be removed before a coroner's inquest was held, and replied there was no objection, but that all the circumstances ought to be carefully remembered. Discovered no soil upon the boots or any indications of the body having been dragged there. Cross-examined. There had been no attempt to remove the body before my arrival, it having been supposed improper by the persons present to disturb it. Cyrus Williams. Saw the body of Edward Matthews on Friday morning in the doorway of the cellar, between 7 and 8. Some half-dozen persons were present when I arrived. It lay in a partly doubled-up position, with one arm over the head. The dress was drawn up considerably. The clothes were clean. The body could not be readily seen in passing by it. Did not enter the cellar. Examined wounds on head. Saw no watch on the body at the time, but do not know that the jackets were examined. Was present at the coroner's inquest, and saw the stomach removed by Dr. Coolidge, put into a wash basin, and handed to Dr. Thayer. Dr. Thayer took the basin, smelt of it, and said it had a strong smell of brandy. Dr. Coolidge said that I had better take it out. It might scent the room. Took the contents, carried them down the back stairs, and hid them behind an old hogshead. They remained there some time, and then were put into the ice house, and kept there until called for by Professor Loomis, perhaps 9 or 10 o'clock a.m. Dr. Plaisted was present when I delivered the contents of the stomach to Professor Loomis. The contents were under lock and key in the ice house, and I had the key in my pocket. Cross-examined. Mr. Sewell came in the evening, asked me if the contents were thrown away, told him they were not. He then asked me to put them in the ice house, told no person where I had put the contents of the stomach until they were locked up in the ice house. There was nothing in the ice house but sawdust. Delivered the contents in the bowl to Professor Loomis. My hostler had lost the key of the stable which fitted the lock of the ice house and could not find it. Therefore, could not open the ice house when I took the bowl from the room where the coroner's inquest was held. Do not know who called the physicians and held the post-mortem examination. Think it was Simeon Kelly. Accompanied the body when it was taken into my hall. The hogshead was an empty one lying on its side. The basin was not covered in any way when I left it behind the hogshead. It was a common earthen wash basin. Think I took it from the hall. Dr. Coolidge had boarded with me about 4 years and kept horses at my stable. He had an extensive practice, to which he attended carefully. His general standing was good, has been my family physician since he boarded with me. It was known when I took the contents of the stomach out of the house. The place I deposited the contents of the stomach was not observable by passers-by, yet it was approachable. The wash bowl was a glazed white one which had been used a year or 2. Professor Loomis. Received from Mr. Williams a bowl on Saturday noon, October 2nd, at about 9 o'clock. A whitewash bowl containing a liquid. Several persons were present at the time. Dr. Plaisted and M. Shaw. Took it from Mr. Williams at the head of the stairs. Dr. Plaisted suggested that it be put in a bottle. I and Dr. Plaisted went to his shop, put the contents into a bottle, and then to my laboratory. From thence to Dr. Boutel's, taking the bottle with me, kept my eye on the bottle all the time, and allowed it out of my hands but in 1 or 2 instances. Was directed to analyze the contents of the bottle and applied chemical tests to it first for ascertaining if there was a presence of prussic acid. A portion of the contents was found to exhibit indications of prussic acid. The test was common copperas. A second portion was tested in a different manner and gave the same result, a presence of prussic acid. Made another test with the third portion, commencing with nitrate of silver, lemon caustic, which gave a curded precipitate. That indicated prussic acid and several other substances. On Monday there was an examination of the brain, a part of the liver, the lungs, a kidney, and the spleen. The substances then examined had the same appearance as the portions of the body examined before. The spleen was very much softened. The brain was found to be very much softened. A knife was passed through it several times, and the interior found to be white. When the thorax was opened, detected a peculiar odor, which I have no doubt was prussic acid. Have found that prussic acid, when thrown into the stomach in considerable quantities, will produce death in from 3 seconds to 15 minutes. An acid which I made of half the strength of the pure acid, put into the eye of a cat, produced death in 10 seconds. The quantity was less than a drop. Am not able, from experiment, to say how soon death would be produced on a man. In one instance, a dog ran, after taking the acid, about 19 feet and fell dead. A shriek might be produced from the effects of the acid, but when injected into the stomach, it would be the death shriek. The acid always produces on the stomach dark spots, and generally a discoloration of the liver and lungs. The blood in the veins is always rendered fluid. Have not always discovered odor from bodies so poisoned, but have observed it about 60 hours after death so produced, when ejected into the stomach with brandy. Cross-examined. Have had considerable experience in morbid anatomy. Have never been a medical student, but have frequently seen dissections performed at the Medical College in Philadelphia. Morbid anatomy is not a part of my profession, but anatomy and physiology are sciences I teach. Have attended post-mortem examinations, but am not aware of an instance where death was caused by poison or apoplexy. Know of no instance, and know of no authors who say that prussic acid may be produced in the stomach by heat. Knew very little about prussic acid until called upon to make the experiments I have described. In none of the substances which I analyzed from the stomach of deceased did I discover brandy. The oil of vitriol could not be mistaken for hydrocyanic acid. This was the first time I ever experimented on a human subject to ascertain whether death was produced by poison. Have heard that a dose of brandy will kill a cat, but am not aware that it was ever a fact. Dr. Plaisted saw the body of Edward Matthews on Friday about 9 o'clock in Williams' yard and observed 2 cuts on the head. Next saw it in the hall of Mr. Williams' house, and at this time observed another cut, also a fracture of the skull. Dr. Thayer, Dr. Coolidge, and Mr. Flint were present. The scalp was not removed. The cut on the top of the head was perhaps half an inch long, and as deep as it could be before hitting the bone. The flesh was not swollen. Dr. Coolidge removed the stomach. It was filled with food partly decomposed. The wounds on the head were the result of 3 distinct blows. Examined the body again on Sunday in the presence of Professor Loomis, Dr. Thayer, Dr. Boutelle, and Dr. Noyes. Removed the scalp. Found the brain very much congested, of a bluish color, and emitting a prussic acid smell. The liver, the lungs, and the spleen were more congested, and exhibited a more bluish tinge than I ever before saw at a post-mortem examination. Saw Mr. Williams give the bowl containing the contents of the stomach into Mr. Loomis's hands. Professor L took it and went with me to my office, where we put it in a clean bottle, and he proceeded with it to the college. I did not see it after, observed 2 or 3 small cuts on the thigh of the body inside the leg. Cross-examined. Dr. Coolidge and Mr. Flint made the incisions on the body, observed a smell of brandy emitted from the stomach, but no other smell. Have frequently seen the coatings of stomachs where persons have been addicted to drinking brandy, but this one exhibited a different appearance. The examination in the hall was by order of the coroner. Am not able to say how much brandy was found in the stomach, but supposed at the time there was enough to have produced intoxication, say 1 glass. Never bought, sold, and never used prussic acid, but there was a bottle, perhaps half full, in my shop, which had been placed there by a student some years ago. Am not conversant particularly with the smell of the acid. Dr. Noyes. Saw the dead body of Edward Matthews on Sunday morning, 3rd of October last. Dr. Thayer, Dr. Boutel, Dr. Plaisted, and Professor Loomis were present. On opening the body, the lungs did not collapse. The right cavity of the heart was found empty. The blood flowed freely from the arteries that were opened. Observed it was of a dark color. An odor the same as that proceeding from prussic acid was distinctly noticed to be exhaled from the brain and the stomach. Noticed that the spleen was highly gorged with blood. The tongue at the first examination was protruded from between the teeth, and the eyes were considerably dilated. Noticed the marks of fingernails upon the left side of the throat. Cross-examined. Have attended postmortem examinations where death was by apoplexy. They resembled this case in some particulars, more especially as regards the fluids. Am not acquainted with morbid appearances where persons have died of intemperate habits. It is stated in the authorities that the brain sometimes or always exhales an odor as of prussic acid. Physicians sometimes keep prussic acids, druggists generally. It is an article of medicine and of different degrees of strength. Dr. Hubbard. The ordinary tests of prussic acid are to reduce it to the form of prussiate of iron, second, cyanide of copper, and cyanide of silver. There are sensible properties of prussic acid. Its odor is one, and I think it about as reliable as would be the testimony of any 3 human witnesses on a certain point. Where death produced by this acid in large quantities should expect to detect the odor on opening the body in almost any cavity. 1 grain would produce death in 1 or 2 minutes. A grain of concentrated acid, which would be equal to 50 grains of medicinal acid. I should not expect to detect the odor of the acid in the brain so soon as in some other parts of the system. There is no distinctive phenomena by which I should judge the death to have been caused by this acid sooner than by the general bluish cast of the internal organs. Its operation on animals is very quick, producing immediate death. The odor of the acid can be discovered 64 hours at least after death. The medical faculty do not use it generally. Am not aware whether it deteriorates by age, but writers say it is very perishable. The medicinal acid is that generally kept by the apothecaries, and is 2% of the pure article. Not usual to find it in other forms than in the diluted state. Have heard a description of the wounds said to have been inflicted on the head of the deceased. Think they were inflicted after death. If I were to discern the odor of prussic acid, I should feel certain that such an acid was there. Have never discovered the odor of prussic acid from the brain of a person who died from other causes. But some authors say such is the case. Have never known the acid formed by decomposition of substances of themselves. But such statements are made by some of the authorities. I know nothing of prussic acid ever being generated in the stomach as a natural process. Some 30 years ago, this acid was used with great confidence in consumption and pulmonary complaints generally. I once witnessed a case where brandy and prussic acid were administered together, and 14 hours after, and also 40 hours after, there was no smell of brandy in the stomach, but there was a strong smell of the acid. Cross-examined. I know that Dr. Coolidge was in the habit of keeping a larger assortment of medicines on hand than almost any other physician of my acquaintance. Brandy has little or no effect on prussic acid. Should expect to find in the stomach of an habitual toper some changes, but the liver always exhibits marked appearances of the effects of intoxicating drinks. Have known Dr. Coolidge 3 or 4 years. He had an extensive practice, and as a citizen I never heard aught against him. He was esteemed humane, and I always thought him so. Dr. Noyes recalled. Saw the bottle which Professor Loomis had at Dr. Boutell's office. I took the bottle, removed the cork, and on smelling the contents, detected an odor of prussic acid. Cross-examined. Was once a student in Dr. Coolidge's office. Know that he was in the habit of keeping prussic acid on hand, a larger quantity than is usual with physicians. Dr. Thomas was a student with Dr. Potter at Waterville. Dr. Coolidge maintained a good character, and I know nothing against his character for humanity. Have heard reports prejudicial to his character since this tragedy. Dr. H. H. Hill. I am not much acquainted with the effects of prussic acid on the system. A small proportion of physicians in practice keep it, diluted to about 2% of the pure article. Cross-examined. Never attended the post-mortem examination of a human subject killed with prussic acid. Should expect to find the lungs of a person who died of a kind of rum fit, somewhat gorged with blood. I have examined good authorities, Guy, Christison, but find nothing which would lead me to suppose prussic acid is generated of itself from vegetable matter. The odor of the volatile oil of bitter almonds is similar to that of prussic acid, and the only thing which might, in my opinion, be mistaken for it by the smell. William Toby. Prisoner was in my debt at the time of his arrest, to the amount of something over $100. I hold 2 notes against him, one for over $40, the other $50, and have an account against him. In March last, he wanted to borrow $500 of me, which he said he would keep 5 years at 10%. Did not loan the money. He wrote me a letter desiring it. Sometime after, I let him have $40 in his office, at which time he wanted more, say from $400 to $500, and said he would give me a note when I gave him more. He enjoined from the first commencement secrecy about the matter, asking that I would let no one know it. Saw the prisoner on Saturday following the murder in his office. Asked for the money. He said it was impossible for him to pay it, that he was in trouble, and wanted me to rest easy until he got over his difficulties, that he had $10,000 or $15,000 on his books, and that I was perfectly safe. I wanted security, but he said he could not give it, as he had agreed to give securities to Matthews, and was liable to be called on at any moment. Made several attempts during that forenoon to get into the office of Coolidge, but found the door locked. Cross-examined. There was nothing said about Matthews in connection with the securities spoken of. Called to get my pay in consequence of the suspicions which attached to Dr. Coolidge, and found him much excited. Have been very familiar with him. Prior to the accusation, knew no harm of him. He practiced in my family and in my neighborhood. David Smiley. The prisoner is indebted to me by note something short of $200 for money borrowed in June last, I think. His character was good, so far as I knew. Isaac Britton. Prisoner is indebted to me by note for borrowed money, something like $200. Once met prisoner and asked him if he knew the note would be due shortly. He said he did and asked me if I wanted it. I told him when the interest was promptly paid, I sometimes let notes lay over. He paid me the interest on the day the note was due, and I never have spoken to him since about it. His general character is good, so far as I am aware. David Moore. Prisoner is indebted to me by 2 notes, which are in the hands of Dr. Noyes, awaiting dividends. One of the notes was for $25, the other for $100. Prisoner did not want it known he was receiving money. Warren K. Doe. Prisoner is indebted to me by note $100. The note is dated September 25th, 1847, and is on demand. Since this affair happened, $8 has been endorsed on the note. The indebtedness is for borrowed money, which was loaned him at Waterville. His character is good. John R. Philbrick. The prisoner owes me $150, for which I have his note, given in 1845. The interest, 12%, has been paid, but nothing on the principal. The character of prisoner is good. James A. Goodwin. Prisoner was indebted to me on the 20th of September in a small amount. Previous to that, I had a note against him for something like $180, given in the winter and payable on demand. The note was given to settle an account for clothing. Job Richards. Prisoner owes me between $400 and $500 by notes. Nothing has been paid on these notes with the exception of $100, which was paid by letting me have a horse. There was no injunctions of secrecy concerning the loan or loans. No, nothing against his character. He has had an extensive practice in my neighborhood. Robert Drummond. Prisoner owes me $100, for which I have his note given in June last. It was for borrowed money and made payable on demand. The prisoner practiced in our family, and I never heard anything against his character. Augustine Perkins. Am cashier of the Taconic Bank at Waterville. On the 30th of September, the prisoner had 2 notes, one for $100 and one for $150 in the bank, which had been overdue 6 or 8 months. They have been taken up since by prisoner's sureties. On the 30th of September, Edward Matthews had a note discounted at the bank for $1,500. The blank on which the note is written was procured on Thursday at about 10 o'clock a.m., and in the afternoon I paid the money to Edward Matthews. Prisoner paid up the interest on his notes when called upon, and said he would take up the notes they held very soon. Charles R. Phillips. Prisoner owes me about $83, $64 of which is by note, given in March 1847, and running on demand. Keep a furnishing store at Waterville. The prisoner applied to me for $500 in July or August last, for 6 months. But as he wished me to keep it a secret, I concluded not to let him have it. He offered me 10% for the use of it at one time. He had hired considerable money of me 2 or 3 years ago, in sums from $1 to $100. The last I loaned him was $100 in June, which has been paid since. Nothing was said about interest, but when he settled, he throwed down a small amount, which might have been the legal amount or not. James F. Gray. Prisoner is not now indebted to me. In September of 1846, he borrowed about $200 of me, payable on demand, and it was paid in January last by process of a suit which I commenced. He was to give me 12% for the use of the money. He applied to me in August or September last for enough to make out $1,000 with what he owed me then, at the same time saying he wanted about $300 in all to send to Dr. Potter, as he was going into a land speculation with him. He offered me $500 for the use of $1,000 6 months and told me he would secure me with his books. By assignment or some other lien, he asked me to say nothing about the desired loan, as I think he said he did not want people to know he was engaged in speculations. This conversation was between 2 and 3 weeks before the death of Matthews. At the door of prisoner's office, met him again when he asked me about the loan, and told him I was not sufficiently acquainted with business matters to do it. He did not wish the conversation known. He asked me again about the loan on the day that the body of deceased was found. Met him as he was coming from the coroner's inquest. Went with him to his back office. He closed the door and locked it, and we were left alone. He put his hand on my shoulder, and as we walked to the window, he started back and asked me if I thought those 2 men were watching us, pointing to 2 persons who were sitting on a log back of the office. I replied that I guessed not. He then asked me if I had been at the coroner's inquest. I told him I had not. He said he had, and feared he would be suspected. I had lost the notes for the money he owed me, and asked him to renew them, having had his promise the day before that he would do it. He replied that he was excited and could not do it that day, but would the next, and asked me to say nothing about his application for money to send to Dr. Potter. I was about leaving the office when he desired me to stay, and asked me that if I should go before the jury, what I should say I had been in the office for. I told him I didn't know. He desired me, in case I should go before the jury, to say I was there for the purpose of having my lungs examined, but I replied that I was pretty healthy and people would not believe it. He mixed a bottle of medicine and gave it to me. I put it in my pocket and went out. I gave the bottle to Mr. Shaw, the owner. Cross-examined. I am a boatman, sometimes hired and sometimes on my own hook. Was in the village of Waterville on the night of the murder. Left Mr. Sprague's, went to the storehouse down by the landing at about 1 o'clock. I then went to Williams's, and from there to my boarding house, and went to bed at about 2 o'clock. Was asked by the coroner, when before the jury, where I was on the night of the murder. Was in the back office with Dr. Coolidge half an hour or more. While there, Coolidge told me he was suspected of the murder. Said something about finding brandy in his stomach. I did not any time ask Coolidge what I should say before the jury, nor did I tell him that I was also suspected or anything of the sort. The warehouse I went to is about 20 rods from Williams's Tavern. I rode down in a wagon. While at the storehouse, I got brandy and drank it. Had the key to the warehouse, and the brandy drank was from my bottle, which I kept there. I was at Getchell's party until about 1 o'clock in company with some ladies, one of whom I have since married. At about 1:30, while going towards the warehouse, I saw Mr. James Hill just coming off of the Taconic Bridge. At the time I was in the office with Coolidge, I did not know that I was suspected, and had no conversation with him respecting suspicion attached to myself. Charles Gilman loaned the prisoner small sums of money about the 1st of June, 1846. He has applied at various times for small sums, which I did not loan. He owed me nothing at the time of Matthew's death. Eben Shaw was called as coroner to summon a jury on the body of Matthews. During the examination, noticed a discoloration on the throat of the deceased, more visible on one side than the other. There was a cut across the thigh of the pantaloons below the pocket, which appeared to have been made with a knife. Also noticed that the pocket had been fastened up with a breast pin, and afterwards forced open, as was shown by the pin still remaining. A man called Howe informed me that he had discovered some money in a woodpile, and I, with a number of the jury, went to the spot, and the money was taken out in our presence. The amount of money found was $150. A watch was exhibited to me, but I do not recollect by whom, but my impression is Mr. Allen brought it in. A boy named Butterfield came in and testified that he found it. There was an appearance of blood upon the back of the watch and on the key when I first saw it. The crystal was also shattered. Observed boots of deceased and noticed that they were clean, giving indications of having been newly blacked. A hat was brought in, which they said was found on the head of deceased, that had blood inside of it. While the prisoner was making examinations on the head, heard him say that he discovered a fracture in one part of the head, which, in his opinion, was sufficient to produce death. Joseph Nudd. There are certain files in my possession which were found in Coolidge's office in Waterville. He here exhibited 2 small glass bottles. They were found in a small closet between the shelves, where were usually kept his most costly medicines. The bottles have been in my custody ever since. 3 letters were shown, which witness said were in handwriting of the prisoner. Noticed marks upon the throat of the deceased. I saw the body in the cellar where it was discovered on the morning of the murder. Saw the body removed. Noticed a frothy substance which seemed to come from the nostrils and side of his mouth. Prisoner had left some bills with me to collect some time before this, from June to August, or about that time. Assisted in taking an inventory of prisoner's property after the murder, the nominal amount of which, in personal property, was not far from $1,600. This included medicines, etc., but not his books. Paid a note which prisoner owed to Lorenzo Crowell, to Mr. Smith, which was over $200. I paid this about the last of January, I think. An account book was shown, which witness said was prisoner's. There is a charge here which I know, reading thus: Edward Matthews, doctor, to cash lent $200. See no date to the charge. Was requested by the coroner to go to the office and get this book. Went there, told Coolidge my errand, and he opened the books and showed it to me. He asked me what they said about his book, and what he ought to say. Replied that if it were my case, I should state the truth. This charge was the last one on it. I was in the jury room when he stated that he had loaned Edward Matthews $200, which were charged on his books, but that he took no note. Cross-examined. Went to Coolidge's office at the request of the Attorney General with him. He, the Attorney General, was there nearly all day looking over papers, etc. Miller M. Payne. Recognized the chain on a watch shown me to be the one worn by Edward Matthews, but could not recognize the watch. About 15th August, Matthews swapped another chain for this one. The watch which Matthews wore would compare with this one very well. Have seen this chain a number of times. George Gilman. Prisoner applied to me for a loan of money on the street one day. He accosted me with, "How are you, George? How are you off for money?" Told him I was poor. He said he wanted to make a raise of $2,000, as he was going into a speculation with Dr. Potter. That he had been in one speculation by which he had made $3,000 or $4,000, and was going into another. He said he would give me $500 for the use of $2,000 3 or 4 months. I then left him, and presently, while passing his office, he called me and said I had better try and raise that for him, that it would be a good chance for me. He afterward called me and said he should want the money in the course of a month. He has asked me before to loan him small amounts of money. Talked with prisoner on Saturday morning, following the death of Mr. Matthews. Told him that when I heard that he had applied to Edward Matthews for money, I told him that he had applied to me. He said that he did not request money of me, but that he told me there might be money made at the West or South, and asked me if I couldn't fix it somehow so. I told him that I should state it as it was. He then exclaimed, "My God, I'm a ruined man! George, if I can only get rid of your evidence, I'm clear. I was going into no speculation with Dr. Potter, and I never wanted money of Matthews. I am doing $20 worth of business a day and have no use for money. My reputation will clear me." He said he must get rid of Potter, and also said, "My God, it is too bad for an innocent man," that he must get rid of my evidence if he could, that he would give anything to do it, and spoke of making me a present of $50. He wanted me to state before the inquest that the conversation he had with me was that we might make good speculations west or south. Cross-examined. Was 21 years of age May last. Had dealt in horses to the amount of $2,000 or $3,000 a year. Had a capital of $500, perhaps $700, most of which was borrowed. Don't know where I could have raised $2,000 at the time Dr. Coolidge applied to me for money, but I think he desired such a loan and hoped to get it of me. Was very intimate with Dr. Coolidge. The doctor did not seem to be very much alarmed at the time I saw him, but was very anxious I should go before the coroner's jury and testify as he desired. Am now in the hide and leather business in New York, in company with Mr. Miles. I put in $5,000 capital. When in Waterville, I collected rents for my father, who owns real estate there. When before the coroner's jury, did not state the conversation behind the stairs, as I did not feel like it. My father let me have the $5,000 which I put into the firm. End of section 84, read by Martha Weller, Champaign, Illinois, February 3rd, 2024. Section 85 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3, by John D. Lawson. Trial of Dr. Valorous P. Coolidge for the murder of Edward Matthews, Maine, 1848, Part 4. David Layton had a conversation with prisoner on Saturday after the murder. I went into the office previous to this, where was also Mr. Richards. Said to the doctor, "What an awful thing this murder is." The doctor said, "Yes, I have lost mother, brothers, and sisters, but never had anything to affect me like this." Asked the doctor then if he had heard anything new on the subject, and he said he had not. He then touched me on the shoulder, and I went into the entry with him, when he said, "I suppose I have got to prove where I got $100 bill I let Edward Matthews have, and have forgotten. Will you allow me to say I got it of you and not deny it?" William W. Goodwin. A letter was shown witness. Have seen it before. First saw it in September last, 2 or 3 days before the 21st. It was presented to Mr. Burnett. I am an apothecary, do business for Mr. Burnett at Boston. The order was executed by me in part, and afterwards found among the old papers and rubbish in the cellar. The letter was read by Mr. Morrill and is as follows. Waterville, September 17, 1847. Dear Sir, shall I have the pleasure of making you acquainted with Mr. Phillips, a gentleman from this village. You will give him an abdominal supporter measuring 27 inches above the hip bones. Give him that kind that you think will be best. The patient suffers much from a bearing down, and charge the same to me. Also wish you to send by express the rest of those tubes. 1 ounce of hydrocyanic acid as strong as it can be, 1 bottle of cologne, opt, 1 pound zinc muriate iron. Also any new preparation that will be worthy of trial. Yours respectfully, V.P. Coolidge. Joseph Burnett, Esquire. Sulfate quinine, 2 ounces. Measure around the hips, 25 inches. Around the small of the back, 25 inches. Perhaps all this measurement will not be needed. Joseph Burnett, number 33 Tremont Row, Boston. Mr. Goodwin. Mr. Burnett put up the shoulder braces. The hydrocyanic acid I put up myself. Recognized the bottle, which was a dark-colored one. The liquid is colorless, but was put in this bottle to protect it from the light, which injures it. It is of the strongest kind. We imported 4 ounces of it. This is 1 ounce. This kind of acid is never sold for medicine. The ordinary medicinal acid is much weaker. The demand for this kind of acid is very small. We imported it for the eye and ear infirmary, where I suppose the vapor of it is used, but I do not know in what manner. The bottle is about 2/3 full, nearly or quite the quantity we sent. The handwriting on the bottle is my own. Don't remember of ever selling this sort of acid before, except in one instance. That was to a physician who wished to experiment on animals. We have only the manufacturer's mark to indicate that it is the strongest kind of acid. When I poured the acid from the large bottle into this one, the vapor was very perceptible and produced giddiness. Cross-examined. I have frequently handled this kind of acid in its medical form. We put it up as often as once a week. It is used by the best physicians in Boston and elsewhere. All the medicinal acid is put up in ounce bottles and labeled minimum dose 1 ounce. That is the strength we always expect to find it. Don't know that we have ever sent any of the acid to the eye and ear infirmary. Fort on the bottle means fortissimus, which is strong. It generally means, as applied to our business, the strongest, or as strong as it can be. Benjamin Wales. This letter was received by me on the 18th of September last. I'm in business at Hollowell. Waterville, September 19th, 1847. Dear Sir, will you send me 1 ounce of the strong hydrocyanic acid as strong as it is made? If you have not the strongest, send as strong as you have. Yours, etc., V.P. Coolidge. Gave a bottle of the acid to the same man who gave me the order. Bottles shown were not like the bottle I put the acid in. The degree of strength was not put upon the label. Consequently, I suppose it was the medicinal acid, which is 2% strength. Had it been otherwise, I should expect to see it marked on the label. I knew Dr. Coolidge, but had never before executed an order for him. William N. Phillips was at prisoner's office on Sunday, 13th of September. Went to carry a measurement of my wife's person to have him sent to Boston for a supporter. He was writing when I went in, went with him to the back office, and took up a bottle which he said was a very powerful poison, prussic acid. He said if he should put 1 drop of it on my tongue, I should fall dead as quick as if struck by lightning. He said he had tried it on a cat. After finishing his letter, he read to me that portion referring to my own business. The letter shown, I think, was the one I carried to Boston and delivered to Mr. Burnett. Received the supporter and ordered the other things to be sent by express. After my return, he was one day standing at my desk, writing a direction for some cough medicine, and asked me how the supporter suited. I told him very well. I then asked him if he had got his things, and he said yes, all right. This was on the 29th. Know that he had an extensive practice. His education was as good as that of young men generally, but I have heard hints thrown out relative to his conduct. Dr. Jonathan A. Smith lived in Vassalboro, had a small quantity of prussic acid of prisoner in August last, which I received of him at his office. I could not tell how much acid there was in the bottle from which he poured. I supposed this to be the medicinal acid, as I recollect the odor, and it was prepared for a patient, so he told me. Augustine Perkins recalled. The bills shown me were of the same denomination, and the same bank as some I had let Edward Matthews have. They are on a Providence bank, and are not generally circulated here. Franklin Dunbar. I live in Windsor. The prisoner is indebted to me in the sum of $100. On 30th of September last, he owed me $300, $100 of which was borrowed in January 1846, and a note given, on which nothing has been paid. He borrowed in the June following $400, has since paid it, after the note was given at the time the money was borrowed. Coolidge remarked that he would give me 10% interest. Cross-examined. Have known Coolidge a long time. His character was good, so far as I know, and his practice in my neighborhood very extensive. J. A. Goodwin recalled. Prisoner called on me in April last for $400 and said he was willing to pay 10%. Have loaned him small sums at several different times. When he applied to me, I told him he could get the money very easily of Mr. Daniel Moore. He said he would rather get it of me, as he did not want people to know he hired money. Erastus Butterfield. Am about 13. I found a watch on Monday, 4 days after Mr. Matthews' death, in Dr. Coolidge's sleigh top. Several persons were present at the time. The sleigh was right over a little office in Williams's shed. Climbed up over the carriages and got into the sleigh when I found the watch right between the swell and the seat. Cross-examined. There were cushions in the sleigh when I found the watch. I was looking for nothing in particular, but was with some other boys looking around. Beside the sleigh, there was old stovepipes and one thing and another in the shed. There was some person that went up into the shed before I did, but he did not stay long. Oliver Payne was a member of the coroner's jury, saw the body of the deceased in the cellar the morning after the death, observed that the neck handkerchief was a little drawn up out of place, found in the pocket of deceased a small knife, a memorandum book, and some articles of perfumery, saw no money, pocketbook, purse, or handkerchief in the pockets of deceased, saw 3 rakes on one side of the throat, which looked like the rakes of fingernails. They were about 3/4 of an inch wide and 1 1/4 inches long. They had a reddish appearance, but did not bleed. Should think the skin was raked off. There was a cut in the leg of the pantaloons below the pocket, and a bent pin in the side of the pantaloons pocket. Also 2 or 3 slight cuts in the flesh of the thigh. Daniel Moore, Jr. The prisoner was indebted to me in September last by 2 notes. One for $125, dated in October 1845, the other for $100 in November 1845, both for money loan. Addison Smith. This is prisoner's signature on paper shown me. They are statements which were made before the coroner's jury by Mr. Coolidge. The paper was read by witness and is in substance as follows. I saw Edward Matthews yesterday afternoon about 2 o'clock. Near Charles Matthews' store. He asked me if I was going into my office. I told him I was. Soon after he came into my office, he wanted to hire some money of me, $200. Said he was going to let 2 gentlemen have it who were speculating in lands at the West. He did not name the gentlemen, nor where they were from. I said to him, I have not the money to spare. I had rather you would get it somewhere else. But I said, if you cannot, I will let you have it. I did not let him have it at that time. He said if he could not get it anywhere else, he would call again at 8 o'clock, and wished me to be at the office. He took a glass of brandy, which set in a row with other medicines, and went out. This was about 3 o'clock in the afternoon. He was in my office from 5 to 10 minutes. I do not know which way he went from my office. I next saw him a few moments after 8 o'clock in the evening. I did not see him between the times above mentioned. When I saw him in the evening, it was at my office. He then came in and said, Doctor, I must have that money, and I will pay you in the morning. I let him have a $100 bill that I had of W.R. Doe of Sebasticook. I do not recollect on what bank the bill was, and $100 in other bills, making $200. He then took his money out of his pocket and counted it. He had $2,000, including the $200 he had of me. He then put the money into his pantaloons pocket, wrapped up in a paper. Matthew said, I have now got the compliment for them and am ready, and immediately stepped out of the office. I soon followed him, and when I passed out of the office, I saw Matthews in company with 2 gentlemen with cloaks on, before David Shore's shop door. As soon as they saw or heard me, they moved off down street, towards Stevens's store. I saw 2 men, that I supposed to be the same above named, near Goodwin's store, the same evening before I saw them in company with Matthews. They were strangers to me. I had never seen them before. I was not so near as to distinguish their faces or describe them. I was in Dow's Tavern in the evening about 7 o'clock. I stepped in to see the register. I saw Charles Matthews in the door. I think I did not have any conversation with him at that time. I might have said good evening the day before, that is, the day before yesterday in the afternoon. I had a conversation with Edward Matthews about signing a note at the bank with him. It was at my office. He came in and said, "I have got some money to raise," and said, "Will you sign a note with John Matthews for $1,500 to the bank?" I said no at once. It was 4 or 5 o'clock in the afternoon. No one was present. Deceased wished to keep the business a profound secret, wished me to tell no one for my life, meaning both the purpose he wished the money for and the fact that he had applied to me to sign the note. I never received any letter from Dr. Potter informing me that I could make a great speculation, and never communicated any such fact to deceased. I think I received one letter from Dr. Potter within 2 months. Not quite 2. Certainly not more than 1. Have not within 1 week past received any letter from a person in Cincinnati. In the letter I had from Dr. Potter, he spoke of speculation and said if he had $500, he could make $4,000 in 6 years. I once swapped notes with deceased. He had my note for a safe I bought of him, and I gave him for it a note against Hodgdon. In a few minutes after, I left the office as I have before said. I returned to it once afterwards in the course of the evening, say at about 9 or half past 9. I again left the office and went into Williams' Hotel to call Mr. Flint. I wanted him to look up some cases in the books. He returned to the office with me. Mr. Flint stayed there about 1 hour and went away about 10 or 11. I soon after left the office and went to bed at Williams's. This morning at 4 o'clock I went to Mr. Bassett's in Winslow. I returned, and at 6 o'clock I started to Skowhagen. I had no call last evening to visit my patients abroad. I did not write any note to deceased last evening or at any time. Deceased did not solicit me to become interested with him in any speculation. When deceased was in my office Wednesday afternoon, he appeared to have drank too much. I did not notice he was under the influence of liquor at any time yesterday. I received a letter day before yesterday from my brother in Greenwood, Mississippi. I have had a consultation with George Gilman about a speculation, but did not solicit him to join me in it. It was in relation to land west and south. I do not recollect that I asked him to lend me money. I have looked for letters from Dr. Potter since I testified as above in relation to letters from him, and find none later than April. I have received letters from him since that time, but cannot find them, nor can I tell how recently I have received them. I have my day book, which I now exhibit. I made the charge of $200 to deceased this morning after I returned from Skowhagen. V.P. Coolidge. Mr. Smith. This narrative was made from answers to interrogatories put principally by Mr. Boutell, and I believe is just the language he made use of. He sometimes adopting the language of the question, sometimes making use of language of his own. All his testimony was taken down, for the reason that at that time he was suspected of the murder, or supposed to have more knowledge of the affair than some others. He knew that he was suspected, and told that he could have any witnesses called to testify where he was on that night. He left at a certain point of his examination and went to his office for some letters. On his return, he brought his day book and exhibited it, saying that he made the charge of $200 against Matthews since he went out. But of this I will not be positive. The doctor's testimony was read to him by me after he had related it, and he pronounced it correct. Elbridge L. Getchell saw prisoner and Edward Matthews on Wednesday afternoon, September 29th, opposite the store of Mr. Phillips. I wanted to see Mr. Matthews, and therefore hailed him. He came across, and while I was in conversation with him, Dr. Coolidge came up and told him he wished to speak to him. He left me and went in the direction of Dr. Coolidge's office, in which direction also the doctor had gone a few moments before. Benjamin Eyre was at the office of Dr. Coolidge Wednesday afternoon, September 29th, saw Mr. Dingley and Mr. Flint, asked them where the doctor was, had been there but a short time, when Edward Robinson opened the door and looked in. While I was in the front office, Dr. Coolidge and Edward Matthews came out of the back office together, and Matthews entered into conversation with myself and the others present. The doctor went down the stairs, remarking that he was going to Winslow to see a sick child, but returned and called Mr. Matthews out of the door. They were together a minute or less. When Matthews opened the door, and I heard the doctor say to him, "Keep dark, all right," or something to that amount. Cross-examined. I think the expression was "keep dark." Matthews was in my store on Thursday afternoon an hour or more. He was lively and social, but I could not say whether he had been drinking. Saw him again just before dark, going up the street. Had not seen him in my store often. Think this was the first time he was ever in it. I observed that he had on a watch when in my store and a gold chain. Watch and chain found in the sleigh were exhibited, but witness could not identify them as belonging to the deceased. When I saw deceased in the evening, he was passing Taconic Block, going up street. Julius A. Bartlett. Saw Edward Matthews on Thursday at about 6:30 at Mr. Chick's store, opposite William's Tavern. We had some conversation together, walked leisurely along by the Parker House, down to Mr. Smith's store, the building a few doors below prisoner's office. We returned back on the same street, and when very near the Parker House, he crossed and spoke to some person. He then proceeded further along, went into Mr. Chick's store, and I into the barber shop. A man named Carter was with me. We both, Carter and I, had on cloaks at the time. Knew prisoner from having met him several times in company, but had no intimate acquaintance with him. Think he had never seen Carter before. He is a classmate of mine in college. Ripley P. Simpson. Saw deceased at the Parker House on the Thursday evening before his death, in company with some other young persons. Noticed that he had his boots blacked at the Parker House that evening. A little before 9, he left the Parker House and went in the direction of prisoner's office. Do not know precisely what time it was when he left the Parker House, but the 9 o'clock bell rang a few minutes after he left. Cross-examined. It was rather a dark night. Think the streets were quite muddy. There is a private avenue leading into Main Street, but it is somewhat further than the regular street. A. F. Tilton. Identify a watch shown me as the one thrown down from the shed back of William's Tavern by the boy Butterfield. It was enveloped in this paper when thrown down. After discovering what it was, I carried it up into the hall where the coroner's jury were in session. Mr. Shaw, the coroner, took the watch from my hands when I carried it into the hall. Cross-examined. The watch was thrown upon the ground from the height of 10 or 12 feet, and I picked it up. Am unable to recognize the watch from the blood on the back of it. The stains are not so deep now as they were when I first saw it. Have known Dr. Coolidge more than 3 years. Knew nothing against his general character prior to this transaction. George Lincoln was in Mr. Shorey's shop in Waterville on the night of 30th September, and left soon after the 8 o'clock bell rung. Some young men were with me in the shop until we left together. There were 5 girls in his employ who worked in a room above. The room I was in was on a level with Dr. Coolidge's office. During the evening, heard persons ascending and descending the front stairs, who I suppose went into Dr. Coolidge's office. Herrick Barton, on the night of the 30th of September, was in Mr. Shorey's front shop until nearly 8 o'clock. Closed the front shop before he left in the evening, and then went upstairs. Did not go into the lower shop. Locked the door and hung the key up on a nail. The girls had left the upper shop prior to this. James Hill. Saw prisoner on the night of the death of Mr. Matthews, on the street next to the river, which runs parallel with Main Street, in the rear of the buildings occupied by the prisoner. He was going north, and I in an opposite direction. Joseph W. Freeman. Saw Dr. Coolidge on Thursday night about 9 o'clock on the platform of Williams' Hotel. He came there, looked through the sitting room window, passed off the platform, and went away. John Bowles. Saw Dr. Coolidge on evening of Thursday under Mr. Williams' hall. Was there greasing the axle trees of a coach as he came up and passed me on the left, and went towards the door which leads to the bar room. As he passed, I said, "Hello, doctor." He replied, "Hello," and passed on. This was at about 9:15. Nelson Adams saw Dr. Coolidge on Friday morning after the death of Mr. Matthews at Williams' barroom at about 4:00. He was coming from the direction of the stable and from the shed where the watch was found. He called John Boyles and said he wanted his horse. George L. Robinson saw the prisoner at about 11:00 in the evening. He came into the barroom and asked me to call him at 6:00 the next morning. Next saw him at about 4:30 the next morning as he came into the barroom and desired me to order a breakfast for him. The week before the death of Mr. Matthews, the doctor asked me if I knew when Mr. Matthews would be home from Brighton. He also inquired if I knew how much money he took to buy cotton with. I told him I understood he took $200 from the bank. He told me that when Matthews came home, he wished me to let him know, as he wanted to see him on his return. On the Wednesday before his death, saw Matthews in the street and went to the office to tell the doctor. At one time, he said he had lent Matthews some money that he did not take a due bill for and felt uneasy about it. This was, he said, the reason that he wished to see him. Asa Fernald was in Dr. Coolidge's office on Thursday forenoon and saw Mr. Flint, Mr. Dingley, and Getchell the office boy. While I was there, Mr. Matthews came in and remained a short time. I saw Matthews take nothing from the safe or any other place in the office. Edward S. Getchell, am 13 or 14 years of age. Saw Edward Matthews in Dr. Coolidge's office on Thursday, but do not know what he came there for. When I came to the office the next morning at about 8:00, did not build a fire, but noticed that there was a fire in the stove. First saw Dr. Coolidge that morning drive up to Williams's and get out of his carriage. Saw a spot on the carpet near the door which opens into the back office, and called the attention of Mr. Flint and Mr. Dingley to it. Mr. Flint stooped down and scratched it with his fingernails. The spot was as large as my 2 hands. Saw a hatchet there, the one I was in the habit of using to split up my wood with. Amasa J. Dingley saw Mr. Matthews in prisoner's office on the afternoon of Wednesday prior to his death. He came in with Dr. Coolidge and went with him into the back office, the doctor locking the door behind them. He, Matthews, stayed there a short time, then went out, the doctor soon following him. Was then a student in Dr. Coolidge's office. I came to the office the next morning at about 9:00 and saw a spot on the carpet. Cross-examined. Did not remain in the office usually in the evening, except on Tuesday evenings. Do not know whether the office had been swept or not on the morning I saw the spot on the carpet. William Howe saw Mr. Flint on the evening of the 30th of September last in the sitting room of the hotel at about 9:30, and was in his company 20 or 30 minutes, when he left and went into the front entry which leads towards the barroom. He had a lamp in his hand when he left the room. I found on the 4th of October last in the woodshed a quantity of money tucked down by the side of a joist stud. The amount was $155. It was in a position where it might have been seen without removing anything by any person looking that way. Cross-examined. Flint and Emily Williams were playing backgammon in the sitting room when I went into it. Flint went out first, and in about 5 minutes Miss Emily followed. Charles K. Matthews saw Edward Matthews at the Parker House a little past 8:00 on the evening of his death. We were together at a small party here. Said he supposed it was time for him to be going to Dr. Coolidge's office. He then left, and that was the last I saw of him. Saw him at the barber shop at about 6:00, the last time prior to that. Previous to this, I had seen him at my store. He came to my store the first time in the forenoon, having a letter with him, which was from Dr. Coolidge, as I know from the signature. Edward put it about his person somewhere, and I did not see it again. Have seen Dr. Coolidge write prescriptions and know his handwriting. Paper shown me is a note given to the bank for money received. My name is upon it, and was signed there in the presence of my father and Edward Matthews. After I had signed the note, Edward took it and went out of the store, going in the direction of the bank. When he came back to my store in the afternoon, he had a pile of money in bank bills. Did not examine the money, but there appeared to be a large amount. He remained in my store a very short time then. Before this, while in my store, he wrote an instrument on a blank, which was a blank for a mortgage of personal property. It was filled out as would be any instrument for conveying personal property, looked over his shoulder as he read the instrument to me. He then put it about his person, and that was the last I saw of it. Edward was in my store at the time he wrote the instrument referred to, an hour or an hour and a half. He put the money he showed me in his pantaloons pocket. Saw him pin up one of his pantaloons pockets while in the store. Cross-examined. I saw Dr. Coolidge write a prescription once at my boarding house, and know it was his writing from the peculiar style of the letters. Saw some letters which Dr. Botel said were in his hand, that he saw him write. Have also seen other writing of his since then, since the instrument was written. Have a distinct recollection of seeing Edward Matthews put the money into his pocket and pin a pocket. It was in the evening when I went to the Parker house. Looked at the pile of bills Edward had, but did not count it. He took a piece of paper in my presence and wrapped up the bills, previous to putting them in his pocket. Am a cousin to the deceased. William Matthews. Am editor of the Yankee Blade, Boston. Am brother to the deceased. Am administrator on his estate, and have custody of his papers. Found among his papers a mortgage of an interest in the Yankee Blade, conveyed to Mr. Norris, one of the partners. He was in business with Philander Sewell of Clinton, or about commencing business with him. He had been residing with his mother at Waterville previous to his death. Charles K. Matthews recalled. Mr. Morrill. What were the contents of that letter? Mr. Matthews. The portion that I distinctly recollect was, "Come to the office this evening and arrange that business, but reveal it not for your life." The latter part underscored with a very heavy dash. I looked over Edward's shoulder as he was reading the letter, but the first part did not make impression enough on my mind to cause me to say whether I read correctly or not. Philander Sewell. Live in Clinton, was in partnership in trade with Edward Matthews, in a small drove of cattle, which he took to Brighton. About $1,800 was paid out for the drove. Saw the deceased at my house on Wednesday night. On the Thursday morning following he left, previous to which, however, he took a book of forms and looked for some forms of assignments, and saw him open the book at the place where were forms of assignments and mortgages. The book, The Businessman's Assistant, he took with him. Next saw him stretched on a board in Mr. Williams's hall. John Matthews. Mr. Evans. Have you been in attendance here during the examination of the other witnesses? I have been here for the last 2 days. Mr. Evans. Then I move that he be not allowed to testify. Chief Justice Whitman. Mr. Matthews is a competent witness. Mr. Matthews. Saw Edward Matthews on the afternoon before his death in Charles Matthews' bookstore, also the same day in the forenoon at the same place. This is a note on which my name appears as principal with Edward Matthews. Saw Edward Matthews writing at a desk. He showed the writing to me. It was a mortgage deed. I signed this note in the presence of my son at his bookstore. Once held a note against prisoner for $100 for money borrowed, on which he agreed to give me 12% interest, and so wrote the note, but I objected to that and the interest was stricken out. Saw a prisoner on the day after the death of Edward in the street and walked with him to Williams's hall. When I asked him if Edward Matthews was in his office the night before, he said, "Yes, he was in my office twice." I asked him if he came there to loan him, the doctor, money. He said, "No, he came to borrow money, and I loaned him $200, which I did not take a due bill for, but charged it on my books, as he said he should pay it the next morning." End of section 85, read by Martha Weller, Champaign, Illinois, February 7th, 2024. Section 86 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Dr. Valoris P. Coolidge for the murder of Edward Matthews, Maine, 1848, Part 5. Thomas Flint. On Thursday evening, the 30th of September, between 6 and 7, went to the office. Dr. Coolidge came in, and we talked about procuring a subject for dissection. Dr. Coolidge said he had made arrangements with Charles Stackpole to procure the subject, that he would probably be there at 8 in the evening, and if he did, said he wished me to leave. At about 8, the door of the office being locked, someone came and knocked. The door was not opened, and shortly the doctor asked if I supposed that was Charles. Shortly went out of the office to my boarding house, Mr. Williams's, where I found a child who had a blistered head, examined the child, and sat down to play backgammon with Miss Williams. About 9 o'clock, took a lamp and was going to bed when in the entry met Dr. Coolidge, who said he wished me to go to the office with him. He blowed out the lamp, went with him. He unlocked the office and I went in first. There was a dim lamp on the stand. After he had locked the door, he said, "I am going to reveal to you a secret which involves my life. That cursed little Ed Matthews came in here and went to take a glass of brandy and fell down dead. He now lies in the other room. I thumped him on the head to make people believe he was murdered." Dr. Coolidge asked me what we should do with him. Replied that I did not know. He then said we must get him out of the office, and said he wished he was in the river. Told him I did not think we could get him there. It was rather bright. A place back of the building was then spoken of, but finally I told him we could not safely carry the body farther than the cellar. That was as far as I would go. He said he feared it would be found. Told him it would probably be by 7 o'clock the next morning. He took the lamp and went to the door of the back office, went into the back office with him, and saw an old pair of drawers lying folded up, on which was an impression made as if by a man's head. Near the drawers was a spot on the floor which had the appearance of blood partly wiped up. Then passed on to the back window, which was raised as high as it could be. Front of this window was a temporary counter, and between this and the window saw the body. Dr. Coolidge took the lamp and went down into Shorey's shop and opened the door. After he returned, he asked me if I did not think it best to put something around the head. Told him I did not know, but it was. He then took the body from behind the counter, noticed that the hat was pressed hard on the head. He said it was best to take off our boots, which we did. Noticed that the arms were stiff. We carried the body in that position downstairs. When we had got part way down, the body slipped and the coat was drawn up partly over his head. The arms were also drawn up. We carried the body down through Mr. Shorey's shop and left it on the woodpile near the outside cellar door. Dr. Coolidge then took the hat off and let it remain near the head. We returned to the office. Dr. Coolidge took the lamp, went below to see that all was as before, and returned. After he wiped up a spot from behind the counter and took the towel and the pair of drawers and put them in the stove, he then asked me what it was best to do. I told him to go on with his business and let the matter come out if it would. He said, "They can't suspect me, can they? And my popularity is too great." He said he was going away to Skowhegan, and told me I must come to the office before breakfast and see how things were, that there was a cask in the closet which ought to be headed up. I then started to go home and asked him to go with me, but he said it was not best that both should go together. Went home, and as I was going in, met George Robinson, who asked me where the doctor was. I told him he would be in by 10:30, and asked him what he wanted of him. He said there was a Mr. Morse who wanted to see him. He remarked that it was nearly 10:30 then, took a light, and went to my room. Shortly, Mr. Baker, my roommate, came in. When the first bell rung in the morning, I got up and went to the office, where I found a note requesting me to sweep both offices, that he had found a shirt button there. I destroyed the note and then swept the offices. Saw the same spot of blood I had seen the evening before, also a spot in the mop-board under the window. Saw some aromatic substances on the floor. Went to the head of the cask and saw some spots of blood on that, which I rubbed off. heard someone open the post office, replace the cask, and put a hoop which had been knocked off into the stove when I noticed there was a fire. Went to my breakfast, and on my return saw Edwin Getchell, the office boy, sweeping the carpet. He noticed the spot on the oilcloth carpet near the old case. Told him he might sprinkle it and sweep it up. Went out of the office. On my return, Edwin called my attention to a spot on a piece of woolen carpet near the inside door and bookcase. Examined the spot and found it was blood. Also saw on same a few hairs in the blood. Between 11 and 12 saw Dr. Coolidge in his carriage near Dr. Thayer's office. Dr. Thayer was then talking with him. Went back to the office, saw Dr. Coolidge charging Edward Matthews with $200. He took the account book and went out of the office, saying he was going into Mr. Williams' hotel. Remained a short time when I was summoned to attend a coroner's jury at the hotel. Before I left, Dr. Coolidge came in and handed me a sum of money from his pocketbook and asked me to put it in my pocket, saying they might ask to see his pocketbook and did not know but there was too much money in it. Shortly after, they were assembled in Mr. Williams' hall for a post-mortem examination. Dr. Coolidge sent me for his instruments to perform the examination with. I brought the instruments, and they were used in the examination. Was sworn with Dr. Plaisted, Dr. Thayer, and Dr. Coolidge. Dr. Coolidge did the cutting, and I assisted him when he desired it. After he had finished, I sewed up the cuts which were made, and was then sent out of the hall. Some time after Dr. Coolidge's return from Skowhegan, he gave me a letter to destroy, which I did, tearing it up and throwing the pieces in the street. After the post-mortem, I put the money which Dr. Coolidge had given me into a wood pile in Mr. Williams' woodshed. After they got through with the post-mortem, went into the office, and Dr. Coolidge came in. He said there was $1,000 under the carpet under the iron safe, and wanted me to take care of it. But he thought it would be safe in my trunk. After supper, removed a part of it, which I put in my pocket, and with a quantity of money which he had given me in the afternoon, put in a crevice near the door. In the evening saw Dr. Coolidge, and he told me that he wanted a part of that money. Mr. Williams told me that I had better go to the office, that Dr. Coolidge was there taking on, and I had better go and quiet him. Found Dr. Coolidge very much agitated. He wished to see Dr. Thayer. Went to Dr. Thayer's house and called him. He went with me to the office and talked with Dr. Coolidge a short time, when he appeared more calm. Dr. Thayer then left, and Dr. Coolidge went to the house in company with Mr. Baker. Went to the house shortly after. Dr. Coolidge went to his room, asking me as he went to sleep with him. Hesitated, but finally went to his room. He took the money he had given me, selected some of the bills, put them into his pocketbook, and gave me others from his own pocketbook. We then went to bed and talked about taking care of the money, and concluded it would be safe in a jug kept in the office. Don't think either of us slept much that night. In the morning, I put the money in a jug in the office. In the afternoon, I returned. He transferred his property to me, the business being done by Mr. Baker and Mr. Chandler. He went to the office, broke the jug, and threw the money into the stove. Next morning, I and Getchell examined a hatchet that was in the office, but found no decided marks on it. I brushed a cloth on the bookcase near the door and discovered a small spot of blood upon it. That night, after I and Dr. Coolidge had gone to bed, he importuned me very strongly never to record what I had discovered. The conversation turned upon the evidence before the coroner's jury. On Saturday night, the chief conversation was about a letter which was written to Edward Matthews and testified to before the coroner's jury. Asked him if that letter was in existence, and he said that it was not, that on Friday night he went down and took it from the bag and destroyed it. The next day, Squire Noyes was called in as his adviser. On Monday he, Dr. Coolidge, told me there was a bottle at the office that had contained prussic acid, and that it ought to be destroyed. I asked him what bottle it was, and he told me one that I had not seen. I replied, if no one has seen it, why do you wish it destroyed? He said William Phillips had seen it, told him that Squire Noyes thought the bottles had better be left on the shelves as they had been. At his urgent request that I should fill up the bottle that came from Burnett, I went to the office, filled up the bottle out of the one that came from Hallowell, threw the cork with other old corks away, and destroyed the Hallowell bottle, then put the bottle, which came from Burnett, on the shelf, but subsequently put it into my trunk, having heard it suggested that in his rage Dr. Coolidge might destroy himself. The doctor told me the brandy bottle ought to be rinsed and the water in the sink thrown out. Took the cork out of the brandy bottle, but did not rinse it. The water was subsequently thrown out. On Sunday night he told me that he wished I would take the watch from his sleigh in the loft and throw it into the river. This I declined to do, telling him I would follow no further, but that matters must come out as they would. On Monday of the week following, the doctor's books were transferred to Squire Noyes for the benefit of the doctor's creditors, the papers transferring the property to me having been destroyed. Often when he was with me, he urged me not to divulge what I knew, and on no occasion expressed fears that I might so divulge. Cross-examined. Am in my 24th year, have resided at home most of the time or attended school at North Yarmouth, with the exception of the time I have been with Dr. Coolidge at Waterville. Have spent 5 months in Philadelphia, attending medical lectures. Partly disclosed to my father, a week after the murder, the facts I have testified to today in my room at Williams Hotel. I afterwards disclosed some part of it to Mr. Baker as we were coming down here. First gave an account of what I was doing on Thursday evening before the grand jury. Told them that I was in the office on that evening examining books in order to get a correct idea of an important case the doctor had at Skowhegan. Don't recollect what was afterwards asked me particularly. Was under oath, did not state there what I have stated today. A second time, when before the grand jury, I signed a paper containing the testimony I had delivered. When before it the first time, did not state to the jury anything about the money, the watch, or about washing out the stains from the floor. Don't recollect that I told this matter to anyone before I told it to my father. Have never had a guarantee that I shall not be prosecuted in this case. General Simmons and my father have told me that if I would testify in this case, all the leniency would be shown me which the circumstances would allow. Know nothing of how Dr. Coolidge came to send to Boston for the acid, and first saw the bottle and opened it when it arrived by express from Boston. Smelt of it to satisfy my curiosity. It was labeled prussic acid. We went down with the body in the dark, having no light. Dr. Coolidge was ahead when we started. Could not see the body after we laid it on the woodpile in the cellar. We had to stoop a little in going on to the woodpile. The hat of deceased was on his head when we went down the stairs, but was taken off by Dr. Coolidge and laid beside the head, as I know from having felt of it as it lay there. Don't know that I ever gave anybody a different account of the manner in which the body was carried downstairs. Don't recollect that I ever told any person it was taken down in a sack. Know nothing of the deceased ever drinking brandy in Dr. C.'s office. Noticed on Thursday that about 1/3 of the brandy was gone. Think it was empty on Friday morning. The bottle was replenished from time to time out of a jug we kept under the counter. Think I filled it on Wednesday myself. We had frequent use for brandy. On Thursday noon it was about 1/3 gone. Do not know who used it. It was Getchell who called my attention to the spot of blood on the carpet. Found a few hairs in it stuck together with dry blood. The spot was about the size of a man's hand. Was before the grand jury twice. Mr. Moore gave me no assurance of security. Mr. Baker slept with me in the same bed Thursday night. Got up first, but do not recollect whether he was awake or not. Had some conversation with Baker after we went to bed, but can't tell what we talked about. Did not sleep at all that night, nor did I get up during the night. Heard noises in the house quite often, but can't say they were unusual noises. Heard the stage when it went as I supposed. Went partway down Shorey's back stairs in the morning when I went to the office to see how things looked. Never counted the money given me by Dr. Coolidge, and don't know the amount. When I exchanged money with Dr. Coolidge, he said he wanted me to take some foreign bills and give him river bills in exchange, as they would be less suspicious if he wanted to use them. Had never seen the bottles of acid that came from Hallowell. Was inquired of by several persons at the coroner's jury as to whether I knew anything about the death of Matthews, but did not inform them. Think it was on Wednesday that the doctor expressed the most fears that I should divulge. Emily Williams. Saw Thomas Flint at my father's house on Thursday evening at about 8 o'clock in the sitting room. There were several present, among them a gentleman and lady with a child. Between 9:30 Mr. Flint went out of the room, or just as he was at the entry, Dr. C. came in and said, "See here, you." They both went out of doors. The doctor spoke as if he was in a hurry when he addressed Mr. Flint. Professor Champlain. Called upon Dr. Coolidge at one time to get him to give something for the college. Said he could not give anything then, as he had a large amount of money to raise and send to Dr. Potter, with whom he had entered into a speculation, that if the speculation turned out prosperously, he would give something handsome to the college. He also named, as an additional reason for not subscribing to the fund at that time, the probability of going abroad soon. Subsequently, he desired I should say nothing about the speculation with Dr. Potter or of his intention to go abroad. Samuel Doolittle. Saw Dr. Coolidge on Friday following the death of Mr. Matthews, and asked him if the contents of the stomach had not better be examined. He asked me if they had been preserved, and I told him they had. He replied that they had lain so long nothing could be ascertained by them. Joseph Freeman. I saw Edward Matthews on Thursday evening at about 8 o'clock as I was going into the bar-room of Williams Tavern. He was passing out of the bar-room under the hall in the direction of the Parker House. Mr. Noyes. Gentlemen of the jury, the government having concluded their testimony, it now becomes my duty to open the case for the defendant. The prisoner at the bar, gentlemen, stands charged with one of the most heinous offenses known to the laws, and you are set apart from your fellow men to adjudge impartially as to the guilt or the innocence of the accused. You are well aware, gentlemen, of the prejudices which have existed in this case, and you are here to adjudge of the accused by the evidence only, always according him innocence until proven guilty. On the 30th of September, it has been shown to you that the deceased was about his business in the streets of Waterville. At 8 o'clock, he was at a social party at the Parker House. He left there, and in the morning his body was found in the cellar under Mr. Phillips' store. Let us look further into the matter. The prisoner was at his office in the evening of Thursday. He was seen to go to his boarding house, look into the window, and was afterwards seen in the public streets. Now, gentlemen, I propose to discuss this matter without taking into consideration the testimony of Thomas Flint. I shall have something to say on this matter before I close. But to review the testimony of credible witnesses, and such as the law declares to be such. The prisoner at the bar, gentlemen, is a man of common sagacity. He is charged with the most heinous offense, and the act is alleged to have been committed in a building in a public street, at an hour when the rooms all around that in which the murder is alleged to have been committed were full of persons, in the pursuit of various employments. Do you believe a man in the possession of his senses could commit an act of this nature when he was liable to interruption every moment? For it is proven that there were several keys to the office, and these keys in the possession of various persons. If indeed you believe the death to have been produced by a secret and deadly poison, are you satisfied that it was not an accidental death and not a premeditated one? But let us review the evidence here. Mr. Noyes then reviewed the tests which had been applied to what he said purported to be the contents of the stomach and endeavored to show that they were not certain tests, placing considerable stress upon the testimony of Dr. Hubbard as well as that of Professor Loomis. He also referred to the uncertainty of the contents of the stomach not having been meddled with after taken from the hall and placed overnight in the open air. Had not, inquired he, some chemical action taken place in the substance in the wash bowl while standing there? He was certain changes had taken place, for when the matter was taken from the stomach, there was a presence of brandy enough, as shown by the evidence, to produce intoxication. And when the same matter was placed in the hands of Professor Loomis, no brandy was found. As to the odor which proceeded from the brain and throat of the deceased, he stated that it was a certain fact that the extracted oil of bitter almonds has an odor precisely like that of prussic acid. No odor was noticed when the body was opened in the morning, and there was an inconsistency in supposing that had there been prussic acid in the body at the time, an odor would not have been discovered by the learned physicians present. I would be willing to rest the case here were it not that such a mass of circumstantial evidence of a vague character has been introduced, touching on so many various points that I feel bound to go over the whole ground, notwithstanding the government had entirely failed to connect a chain of circumstances which could bear upon the prisoner. In all considerations at present, however, I do not propose to touch upon the testimony of Thomas Flint. It sometimes happens that innocent persons, when suspected of crimes, will take undue means to clear themselves from suspicion. Gray, it has been shown, would not have testified against Coolidge had he not been suspected himself, and it could not be supposed that when conversing with Gilman he, Coolidge, under the excitement he was then laboring, could have been over-particular in the language he made use of. It was a circumstance of little moment and ought not to be seriously considered. The next thing that the government attempts to prove is that the prisoner had the means. We grant it, but the means were such as every physician on the river ought to have in his possession. 10 drops of the medicinal acid would have produced death. Then should the circumstance of having procured other acid be considered? He had poison enough always, and the fact of a physician with a large practice buying a bottle of hydrocyane, it seems to me ought to go for nothing. As to finding the deceased's watch in the prisoner's sleigh, how easy it would be for any person to put it there, in order to throw suspicion on the prisoner. It was utterly impossible that the body of deceased could have been taken down through Shorey's shop, more especially by the cutting board, without disturbing the cloth lying on the board. We shall show you, gentlemen, that this witness Flint, with the oath of God upon him, has sworn on more than one occasion that he knew nothing of this transaction. We shall show, too, gentlemen, that he has given a different account of the transportation of the body to the cellar. He has lied before the grand jury, or he has lied here. If he had been convicted of perjury, the law of the land would exclude him from the stand here. He has not been so convicted, and is therefore allowed to testify. But the fact that he has lied under oath goes to so affect his credibility that you have no right to convict on such testimony. We shall offer you evidence that the prisoner was not in want of money when he is alleged to have committed this deed, that he had due him at the time over $6,000, that he was in excellent credit, not pressed by anybody, and that his business, so far from being on the decline, was rapidly and permanently increasing. The prisoner never asked Gilman and Gray for such sums as they testified to. It was mere idle talk. There was nothing in these circumstances which could convey the least suspicion of a motive for the commission of this grave offense. We shall show that from youth up the prisoner has maintained a most respectable standing in society, has been considered a humane, a moral, and upright citizen, one on whom no suspicion of crime had ever before rested, and who could not be suspected in this case but from a variety of unconnected circumstances of little or no weight. End of section 86, read by Martha Weller, Champaign, Illinois, February 8, 2024. Section 87 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Dr. Valoris P. Coolidge for the murder of Edward Matthews, Maine, 1848, Part 6. Evidence for the defense. Oliver Payne was one of the coroner's jury. Thomas Flint was examined on Friday and also on another occasion. The first examination lasted about half an hour. He stated at this time that he had no knowledge of the murder of Edward Matthews or any circumstance connected with it, that he saw nothing about the office to raise suspicion that the murder was committed there, that he saw Matthews in the street once after his return from Brighton, but that he did not see him on Thursday evening, that he was in the office himself until 8 o'clock, and that he then went to Williams's Tavern, played backgammon until 9:30, that he then took a light and was going to bed when he met Dr. C., and went with him to the office, where he remained until about 10:30, looking up medical cases in the books in reference to a case the doctor had at Skowhegan, that the doctor was sitting at a table with him, also that no one else was in the office, called again before the jury on Saturday, and interrogated with regard to what he saw about the office, with regard to a letter also. He declared that he had seen nothing to throw suspicion on the doctor, and that he knew of no circumstance which would lead to the detection of the murderer. All of his testimony was not taken down on either occasion, as Mr. Smith stated it was strictly negative and not necessary to be recorded. Joseph Marston was one of the coroner's jury and heard the examination of Thomas Flint. He was minutely examined as to his knowledge of the murder in any respect, and he replied that he knew nothing about it. One reply that he made was that when he went to the office after having been called from Mr. Williams's, he found the office lighted as usual and the door to the back office open. He said he saw nothing unusual on the floor, said he could give no information of any character which would lead to the detection of the murderer, said he was employed on that evening in hunting up cases in the books, and that the doctor was sitting with him at the table. Benjamin Eyre resided in Waterville at the time of the death of Matthews, and frequently heard Flint say that he knew nothing about his death. These replies were frequently repeated, from Wednesday to the Thursday of the following week. He said he had no knowledge whatever of the affair, and could give no information with regard to it, was frequently with him and the doctor at the hotel. I saw Flint on the morning that the body was found back of the building. Someone suggested that the body might not be dead. Mr. Flint went to the deceased, took hold of the hands, said they were cold, and that the person was dead. Cross-examined. I frequently interrogated Mr. Flint as to his knowledge of the murder, because suspicions had rested on the doctor, and I told Flint that I wanted the facts to come out. Samuel Brown. I reside in Buckfield, new prisoner when he was a student of medicine with his uncle. He remained until he came to Waterville, with the exception of a time while he was attending medical lectures at Hanover. His character was very good. He kept school once in our town. John Simmons. Reside in Canton in this state. Have known the father of the prisoner 25 years. Prisoner was born in Canton, and I knew him from his birth till he left for Luckfield in 1841. He lived with his father most of the time until he was 20. He obtained his education at the town school and of his uncle, who was a literary man. In his early years, he worked on his father's farm and acquired and maintained an unblemished character. Isaac W. Wheeler. Flint told me at this time that they put a sack over the body before taking it downstairs. Daniel Baker. I had conversation with Mr. Flint at the time the coroner's jury was held, frequently, and he invariably told me he had no suspicion as to the murder. On some morning after Sunday, called on Mr. Flint at Mr. Williams's for the keys of Dr. C.'s office. He gave them to me, and at the same time asked me if I would pour out the contents of a pail which stood in the office. I went to the office with Mr. Chandler, unlocked the door, found the pail, but did not pour out the contents. I went to Mr. Flint and asked him why he wished the contents thrown out, and he said because that a fortnight before he had experimented with prussic acid, and some of it might be in the pail. I think he, Flint, poured out the contents of the pail afterwards. Mr. Flint and I came from Waterville here together to go before the grand jury. When about 4 miles from this town, he said, "I suppose I have got to testify against Dr. Coolidge," but did not say what he should testify. I asked him if he knew anything personally of the crime alleged, and he said no. Cross-examined. When Flint and I were riding together, he said he had got to testify against the doctor, that the crime was enormous, and he thought it must come out, that perhaps the doctor would have to be hung, and that it was rather a hard case. He said, I recollect, that he knew nothing personally of the affair. I have no recollection of ever having said to Flint that to testify what he knew would be disastrous, but did say to him that we were bound to tell all we knew. On Monday night, I slept with Dr. Coolidge in his room. On Tuesday night also. On Wednesday night, Dr. C., Mr. Flint, myself, and Mr. Eyre were together in one room. On Thursday night, I slept there with Dr. C. and Mr. Eyre. When people came to the door that the doctor did not wish to see, I tried to keep them out of the room, more particularly those that came on professional business. Have no recollection of ever having said it would not do for the doctor to talk with people, as he might commit himself. On Saturday, I wrote a bill of sale conveying Dr. C.'s horse to Mr. Flint, at Mr. F.'s request. The parties were asked particularly if this was a bona fide sale, and they replied that it was. The bill of sale was burned on Thursday in the presence of Mr. Flint, and I think in the presence of Dr. C. also. It was burned because it was deemed a lawful way of getting rid of the instrument. The property was then disposed of by assignment. Charles E. Stewart. I reside in Gardner, and saw deceased at Gardner on the morning prior to his death. Also saw him the evening before in a room smoking and playing cards, gambling. He had a considerable sum of money, which I saw him exhibit once during the evening. Have seen the deceased gamble on other occasions than the one mentioned. Cross-examined. The watch shown I identify as the one I sold deceased at Gardner in August last for $75. I took a note for the payment, all of which has been paid except $5. Henry Smith. Saw deceased at Gardner the evening previous to the night of his death, at the Cabosi house. Think he was intoxicated. Was 10:30 or 11 o'clock when I first met him, and about 2 hours after when I left him. Didn't see him exhibit to anyone besides myself any large sums of money. When I first saw him, it was at the door of the house, and he invited me to his room. John Shackford, who is now in Boston, was in the room also, together with my clerk, a man named McCarty. Recognized the watch shown me. Mr. Evans showing a watch. Did that ever belong to you? I can't say that it legally ever did. What sort of an ownership did you ever have in it, or when? Well, sir, I own it now. I won it of Edward Matthews in a bet. What did you bet against it? This piece of property that I hold in my hand. How many bets did you make? 1. Who were the umpires? Edward Matthews and myself. Mr. Noyes. Am attorney in the case. Was present on Monday or Tuesday evening at the office of Dr. C., in company with Mr. Flint and Mr. Evans. Flint was asked if he was present in the office on the Thursday evening of the death, and he said he was, and pointed out the place where he sat and where Dr. Coolidge sat, stated that on that evening the blinds and the curtains were open. We then went into the back office, and he pointed out where the acid bottles, as he said, sat on the morning after the death of deceased. There was something in the brandy bottle which looked like brandy, and which he said was brandy. He told us that the bottles were exactly as they had stood the day before, said nothing about having removed any bottles, and said, I think to one of us, that he found nothing extraordinary in the office in the morning after the death. Am assignee of prisoners' effects for the benefit of such persons as become creditors to him within 30 days prior to the date of assignment. The assignment was made without my knowledge. March 20th. Mr. Evans desired to read from medical books some passages in relation to the effects of chemical action on prussic acid, which he said would go to show that witnesses who had testified here had not read all that was contained in those works relating to the matter. The court decided that reading from books other than books of law was not admissible, on the ground that the authors of those works were not under oath when they were written. Mr. Evans said that he would not undertake to say that the practice in the courts of Massachusetts and New York was more correct than the practice here, but that in those courts such readings would be admitted. Chief Justice Whitman replied that he adhered to his decision and intimated that Mr. Evans had made use of improper language. Mr. Evans disclaimed any intention of casting imputations on the court, but argued the right to read from the authors he had mentioned. The court adhered to its original decision. Mr. Noyes read the statements made before the coroner's jury of Thomas Flint, A.G. Dingley, and George L. Robinson. Mr. Evans stated that a large number of witnesses were present who would testify to the good character the prisoner had uniformly borne. But the state agreeing that such was unquestionably the case, the defense gave notice that the cause should rest here. March 21st. Mr. Evans. I am now about to perform, gentlemen of the jury, as best I may, the last duty which devolves on me in behalf of the unfortunate man at the bar, the last that I or any person will be permitted to say in his behalf, and would to God that duty devolved on other lips than mine. I feel deeply the awful responsibility which rests on me and you, and I have not failed to notice the impression made on your minds by the proceedings before this court. You will enter upon the case, gentlemen, having in your minds what is the duty of the government. You are not to weigh the preponderances of evidence, but to be convinced beyond all doubt of the guilt of the prisoner, before you can be called upon to pronounce that awful verdict which shall consign him to an ignominious death. This case presents many extraordinary circumstances. That the deceased came to his death on the night of the 30th of September, there can be no doubt. That there was an attempt made by some persons or person to convey the idea that he was murdered, there can be no reasonable doubt. But whoever heard of a murderer attempting to emblazon his guilty work upon the public mind? Whoever perpetrated that awful deed attempted and used all the means in his power to fix suspicion on others. Do you believe, gentlemen, that the prisoner at the bar would have taken the course it is alleged he has taken in order to fix suspicion on himself? Do you see any motive he could have had in the commission of the deed charged, and he, a man of ample means, enjoying the confidence of the community, and always having sustained the most unblemished character? The whole transaction is shrouded in mystery, and this dark deed, for a dark deed has been committed, may only be brought to light when the earth as well as the sea shall give up its dead. You cannot fail to have observed, gentlemen, the extraordinary manner in which the learned gentlemen who have managed the prosecution of this case for the government have proceeded. You have noticed that witnesses testified only in answer to interrogatories, and you cannot have failed to see the course we were obliged to adopt to prevent this singular mode of procedure. After examining about 60 witnesses and laying particular stress on the most trivial circumstances, you have seen the only witness placed on the stand who testified to anything like circumstances worthy of note. He was kept back for the very reason, and no other, that they knew he was not a credible witness, and that he was not to be believed. I therefore propose to argue this case without taking into consideration all this extraordinary testimony. Gentlemen have been placed on the stand to testify to the effects of prussic acid, undoubtedly one of the most deadly of all poisons, but we find them possessed of a very limited knowledge of the action of poison. They are not toxicologists, nor do they profess to be. The action and effect of poison is not a part of their profession. Physicians are not chemists, so much as they ought to be, and chemists are not toxicologists. But admitting there was a large amount of poison in the matter analyzed by Professor Loomis, you do not know it was the matter taken from the stomach of Edward Matthews. Mr. Williams does not know that no person was looking at him when he took the contents of the stomach of deceased and placed them behind the barrel, whence he took them 20 hours afterwards, and for the first time put them under lock and key. There might have been 100 eyes looking at him. You do not know that substances were not placed in that bowl during the night they were laying in the open air, but you do know that the acid bottles were taken from Dr. Coolidge's office on that very night. And are there not strong reasons for suspicion that the poison was then put in the bowl, in which were the substances analyzed by Professor Loomis? Are not these things probabilities? Are they not very possible, and do they not weigh heavily in your minds? It has been shown you that hydrocyanic acid is one of the most volatile of all substances, and that it was most likely to have been found on the opening of the body. But here all the witnesses testify that on opening the body of the deceased, they discovered no odor that would lead to the suspicion of the presence of any such poison. There is no proof that there was any poison in the body at all, and it is very questionable whether the matter analyzed by Professor Loomis was the contents of the stomach as they were taken from the body. Now, with all respect to the scientific gentlemen who have conducted these analyzations, I say they were not experienced men in such matters. They confess they were not, and it is a maxim which we find in the books that no man is fit to make an experiment which is to be relied upon unless he has often experimented before. A very learned gentleman, not a chemist, as he avows, not a toxicologist, as he avows, with some knowledge from books and less from experience, testifies that he believes the chemical test to be as certain as the testimony of those witnesses on the stand, but on questioning, he does not know that there are not other substances which may not be acted on in precisely the same manner as prussic acid, and yet he thinks his experiments are as much to be relied upon as the testimony of 3 witnesses on the stand. It is as much to be relied upon as the testimony of 3 Dutchmen or 3 Mahometans, whom the courts do not understand. Why have we not had here one who could have testified from a knowledge of books, not from an ignorance of them, one who is not only one of the most eminent chemists in New England, but in America? I had hoped we might have had him here. Why he was not brought forward, I am not able to say. There is very great reason to believe that the deceased, indeed we know it, had been indulging in the use of brandy on the day of his death, as well as some days before, and we find in his system just the morbid appearances that might be expected to be produced from such indulgence. I do not wish to speak harshly of the dead. My duty is to the living, and I mean to do it. And we are told these morbid appearances are not much to be relied upon. Furthermore, they are not to be relied upon at all. The learned gentlemen who have conducted the experiment on the stomach of the deceased talk as if the sciences they profess had been reached. Why, the very appearances they testify to are of modern discovery. I know that it is common for scientific persons to speak as if they knew what they affirm beyond a doubt. There is a pride and desire to be considered more learned than others. But how different from him who had made more scientific discoveries than any other man of any age, who on his deathbed said, "I do not know what I may seem to others, but to myself, a child who has been all his life picking up pebbles on the shore, while the great ocean of truth lies unexplored before me." The day may come when the fallacy of the tests which have been sworn to here will be exposed. I trust that in my time and yours, many discoveries will be made which will serve to throw light on those sciences now quite in their infancy. If there be any truth in the evidence of the learned professor, the basis of the acid which is said to have been found in the stomach of the deceased is contained in the very bread of which we partake. And is it not very probable that decomposition may produce the acid itself? Yet we have no proof there was any acid there, or if there was, the evidence as to its locality is most contradictory. One observed its odor in the brain, another did not notice it in the brain, but in the throat, while more did not notice it at all. And yet, if there was prussic acid in the system at all, what proof have you that it was placed there by the prisoner? None at all, not a particle. A great deal of proof has been intended to show you that the prisoner took extraordinary means to procure large quantities of prussic acid. He did send to Boston for such an acid, it is true, but in the same letter ordering the acid, he desires any other new medicine worthy of trial. It is simply a proof of his desire to keep up with the spirit of the age, and we find that he was supplied with liberal quantities of the very best of medicines of all kinds. If the prisoner exhibited a disposition to keep up with the times more than other physicians around him, I pray you it may not be set down as a circumstance against him. We grant he had the means of producing the death. He should have, and no physician should be without them. The prisoner was of too investigating a mind not to have about him everything that could assist in a thorough knowledge of his profession. He did not procure these poisons secretly, as he might have done, but wrote for them openly, signing his own name, and it appears to me that if he was plotting the awful deed charged, he would have endeavored to conceal rather than display circumstances which would go to prove his guilt. That is not the way crimes are committed. The conduct of the accused before and after the death they refer to. The learned counsel told you that he should prove that the prisoner endeavored to conceal evidence of his guilt. How have they shown this? Who was it that suggested the removal of the scalp? Who the opening of the stomach? It was he. We find no one of the physicians who says he suggested these investigations. It was the prisoner, no one else. We do not find that he was anxious to have the contents of the stomach destroyed. He told Mr. Williams they had better be removed from the room because the smell was disagreeable. But if he was anxious they should be destroyed, why did he not follow Mr. Williams, or watch where he put the bowl? Or if that polluted testimony to which I shall have to come by and by is to have one feather's weight, why did he not tell his ready agent Flint to watch Mr. Williams and to put some neutralizing substance in the bowl or in the body when he sewed it up? He had the means in his hands and knew their use, and he had an agent by his side ready to do his bidding. Who believes that such precautions could not have been taken by a guilty person? When some time after it was mentioned to him that there might be poison in the contents of the stomach, he answered by inquiring if they were preserved, but he expressed no anxiety about it, and when it was suggested that they be taken to Brunswick to be analyzed by Professor Cleveland, he answered that if there had been poison there, it would escape before it could reach the professor. Just such an answer as he or any other experienced physician should have made. Is this a circumstance which goes to prove guilt? Is it to be believed that for the paltry sum of $1,500 he should commit this heinous offense, and that is set down as the motive? We acknowledge that he had borrowed money, but he had ample credit and could always procure it. He, like a great many other men, did not wish it known how much or to whom he was indebted. He did not care that all his business should be known. No one was pressing him for money, for Mr. Noyes testifies that he has collected out of the prisoner's debts $1,600 in a few days, and from the best men in the place. If he had wanted $1,500, could he not have secured it in 16 hours? Most certainly he could. And as another proof of the fallacy of the motive set up, the government have themselves shown that he was to borrow and could have borrowed of the deceased the sum mentioned. Does this show that he was reduced to such an extremity as to require the commission of the heinous offense charged? We find that he had ample ability to pay all his debts, and how much more we do not know. I think you can perceive in the testimony of Gray, Gilman, and Layton a very particular circumstance. They all speak of transactions as happening at the time of the murder, as if the murder had already been proved. They ought to have more respect for themselves and the tribunal before which they testify. They spoke unadvisedly, indiscreetly, I hope unthinkingly. Now Gray appears here in quite a suspicious position. He had himself been wandering about that night, and I think contradicts himself in a small circumstance, it is true. But he does say that he would not have testified against Dr. Coolidge had he himself not been suspected. The learned counsel has told you that as to Gilman, it was an idea perfectly ludicrous that Dr. Coolidge should have thought to borrow of him a large sum of money. He was a young man without means, and so known to the prisoner. When suspicions were hovering around the prisoner, and when laboring under intense excitement and anxiety, it may be that the prisoner wished Gilman to testify in the manner he says. I know it will be said that innocence holds up its head, is bold and firm. I know that martyrs have died for the truth. But I know also that Judas, a man before apparently as pious as any of the followers of the founder of our religion, denied his master when on the first occasion put to the test. An instance happened in a neighboring state of two brothers who were convicted of the murder of a man, and when circumstances gathered thick around them, confessed the deed. But before the execution took place, the man supposed to have been slain appeared, and proved by his presence the falsity of the confession. It was better that the truth should be told on all occasions and under all circumstances. But we find mankind weak, and we must judge of persons as they are, not as we might wish to find them. Alas for the weakness of our race! We are not what we could wish to be. The Almighty has seen fit to constitute us as we are. And I beg leave to call your attention to the circumstance that witnesses endeavor in some way or another to connect any circumstances with a transaction. If Mr. Matthews went down Main Street, he went to the bank as if he went there after money. If Dr. Coolidge was seen one evening at the boarding house under the hall, he came from the direction of the shed where the watch was found. In the first case, Mr. Matthews was going in reality as much in the direction of Bangor as in that of the bank, and Dr. Coolidge had been seen undoubtedly coming from under the same hall 1,000 times before. Great stress is placed on the circumstance of the watch being found in Dr. Coolidge's sleigh. Does this connect Dr. Coolidge with the transaction? No, it rather disconnects him with it. Would he have secreted the watch in his own sleigh when there were 1,000 other and better places where he might have put it? When the watch was found, people were searching, and persons had been seen to go into the loft where the sleigh was stowed away before it was found. Might not someone who was anxious to throw suspicion on him have placed the watch there before the boy found it? There is nothing more unreasonable than to attempt to connect the doctor with this matter from the circumstance of his having got up early in the morning and gone on professional business. Every physician who has testified here on the stand has done the same thing. Had he not been a physician, not in the habit of being called in the night, it would be another thing. Why were these bottles brought here? Why the clothes? Why the carpet? All of which prove nothing. There was a hole in the pantaloons, it is true, under the pocket. I did not examine it minutely. I did not think it worth the while. But if I saw it rightly, it was not a cut, as testified to, but a tear. And after all, I can't see what those pantaloons were exhibited for. Can't you see how they were torn? The body was drawn across the woodpile, and what is more reasonable than to suppose the pantaloons might have caught on a splinter and thus been torn? It is all plain enough, and there I pass it by. How about the letter on which so much stress was placed? A witness testified that there was a letter written to Matthews desiring him to come to the prisoner's office and not mention it for his life. No date is given, no evening specified, and one witness testified that he had seen the letter on Tuesday and Wednesday in the office. Besides, the witness who testifies to the handwriting of the doctor knows it only from having seen a few lines of hieroglyphics written for an apothecary, and while the witness was sick in his bed. He had, however, seen something that was said to be written by the doctor, but in a disguised hand. It was a letter written once at a fair, and any person who is acquainted with this sort of amusement knows that such letters are usually written in disguised hands. Now, let us look at the circumstance of Matthews having been seen to enter the back office with the doctor. Matthews was somewhat in the habit of drinking brandy, and what more natural than when intending to take a social glass, they should shut the door? There was motive enough. I think my learned friend has read from that greatest of the world's dramatists. He quotes Macbeth. I think he has read Macbeth also for more purposes than his quotation, for it also said that on the night when the king was slain, the elements were in commotion, noises were heard in the air, etc. And we have had good testimony that though there were no particular commotions of the elements, a dog did howl, most strangely, as he had never been heard to howl before. He must have read further of the works of the great dramatist, for it is there written, and I believe it is a historical fact, that when the argument was made before the dignified jury, who were considering the death of Caesar, his robe was brought in and shown, and that the grave senators were called upon to see what a hole the envious Casca made. Here ran the dagger, etc. Is not this all stage effect and display calculated to impress on your minds prejudice and bias? Having now gone over the circumstances which have been introduced, do you not find them too flimsy and too unconnected to be seriously considered as proof of the guilt of this defendant? I have very nearly concluded the observations which I deem important, gentlemen, upon the various circumstances connected with this case, but I might extend them very much. This is not, however, my purpose, for while relying upon your candor, your judgment, and your experience, I have endeavored to go over the matter in the plainest and simplest language. I may not have touched on all the circumstances, for I have not looked at any notes, but knowing the industry of the gentlemen who are to follow me, I will again look at some of the prominent features of the case. By referring to the minutes of my brother, I see that I was wrong if I stated that Burns swore to nothing more than that an operation was performed on his finger in Coolidge's office. He said that he saw Matthews there, but how does that connect Coolidge with the commission of this horrible crime with which he is charged? It will be contended that Matthews was murdered in that office by Dr. Coolidge on a certain evening. It will be contended that such has been proved. Now, let us see. Matthews was seen at 9 o'clock. He was seen to go into Main Street, and that was the last time he was seen alive. The young men who were in the room near Coolidge's office at 10 minutes past 9 o'clock heard no noises there, and it is probable they would have heard them had any noises been made. At 9:15, Dr. Coolidge was seen by Bowles, the hostler, in the yard of Williams's tavern, and there appeared nothing unusual in his demeanor. According to their witness Flint, at 9:30 he went to the office and found the dead body, with the limbs rigid. In 20 minutes from the time the rooms around the office were occupied, the body is found cold in the back room. At 8 o'clock, the deceased was alive at the Parker house. He went out, it is true, but returned. Up to 10 minutes past 9, we have a right to assume he was alive. And now at what time was this awful tragedy enacted? The whole thing is too impossible of itself, even if it stood on better and firmer ground. There is not a circumstance in the whole case which is not easily explainable, and circumstantial evidence, to be of value, must be so positive that it cannot be explained in any other manner than the one alleged. Suppose a man is found wounded in a closed room by a bullet, and a person accused was seen on the day of the murder going secretly to that room with a loaded pistol, and such facts sworn to by one witness. Another witness swears that he saw the accused purchasing powder and bullets, another that he saw him go to the room, another that he saw him coming from the room, and another that no other person could have gone to the room, with the circumstances added that the pistol was found in the pocket of the deceased, discharged. Here is a chain of circumstances, each part sworn to by different persons, but so enumerated that the whole can be traced from one end to the other. This, you will say, is good proof, as good perhaps as would be the testimony of one credible witness on the stand. But have we such a chain here? Up to Friday night, were you as well satisfied of the guilt of the accused by the circumstances related as you could have been had one credible witness testified to his guilt? The humanity of the law is such that, formerly in England, a man charged of a capital offense was not allowed counsel to speak for him. You will think this rather severe, but why was it? It was because juries were not allowed to convict until the case was made absolutely certain. Mind you, gentlemen, I am speaking without reference to the evidence of Flint. Admitting that the murder was committed, might not some other person than the prisoner at the bar have committed the act? This is a matter worthy your most serious consideration, and I cannot too strongly impress it on your minds. Gentlemen, if my strength permitted, I might pursue this train of remark much further, but I do not know that I should make the case much clearer. You are not to convict, you cannot, until every reasonable doubt is dispelled from your minds. You are not to say that if there be 999 chances of guilt against one of innocence, you will convict, but you cannot transcend mathematical calculation. You must be absolutely and positively certain. In reference to the testimony of Flint, the law tells you, and rightly, that you must have unpolluted testimony, that of credible men, but I confess I was much surprised when with unblushing coolness Flint came upon the stand, and acknowledged himself guilty of some of the highest crimes which the law punishes severely. Had he been indicted, as he is liable to be indicted or convicted, he would not have been allowed to be heard here. By his own confession, he is an accessory to a murder, and by the same confession is guilty of the crime of perjury. I allow it is competent to place him upon the stand, but the books tell us that unless such testimony be corroborated in material parts, it is not to be considered as in any degree valid. The law will not permit either life or property to be put in jeopardy on such testimony. Is there security for life or property or anything if testimony coming from polluted lips is to be credited for a moment? What say the books? The moment a person is convicted of the crime of perjury, he is not to be believed in any case or under any circumstances. I think you do not wish to rely on this testimony. You will say to the government, "We will not be the means of taking away the life of a man until you give us substantial evidence." You have a right to demand proof free from all suspicion, more especially such suspicion as this. A perjury has been committed by this witness on his own confession. You have as full knowledge of it as if the copy of an indictment found against him were presented or read to you, and you know you are not to receive the testimony unless substantiated in material facts. This evidence is not substantiated at all by other testimony, but is contradicted in a most material matter. Either Flint or Hill lies, for while Flint and the prisoner were enacting this most horrible tragedy in the prisoner's office, Hill saw Dr. Coolidge walking leisurely along the river. End of section 87, read by Martha Weller, Champaign, Illinois, February 9th, 2024.